Very good morning to all. So today, before starting our first session, I request everyone to stand up for a minute to pray a silence for. Recently, we had a very bad experience of the Air India crash. The flight recently got crashed. So we want to observe a 1 minute silence. I request everyone to stand up, please. Yes, sir. Yes, sir. Yes, sir. No, who are the person from the flight as well as the students of the medical college? Thank you. So we'll start our sessions today. First, we'll have a today's session, a morning session, is like avoiding litigations in clinical practice. I would like to invite our today's session's first session chairperson, Dr. Reshmi sir, and Dr. Shivkumar Kumbar sir. I request our speaker, Dr. Rajiv Agarwal sir, to please come. Dr. Shashidhar Reshmi sir is a senior most obstetrician and gynecologist in Gadag, and he is also founder member of the GOGS Gadag, and he's practicing since almost 4 decades. The another one more speaker sir is Dr. Shukumar Kumbar sir. I think yesterday Guru Prasad sir already introduced him, and he even no needs for introduction. Sir is a consultant anesthetologist and a medical legal advisor and a pain and palliative care therapist. He's a member mediation cell, Dharwad District Consumer Court, medical journalist, and presently is practicing in Dharwad.
Thank you, sir.
To you, sir.
Thank you very much. Good morning, everyone. Today, we're going to start a very important topic in clinical practice. And one among them is communication. Friends, communication is not that an easy topic. It has to be experienced, okay? And today we have wonderful speaker, none other than Dr. Rajiv Agarwal. And whatever this book is mentioned, we're not going to practice it, but it's not feasible on us to only read and start communicating. It should come within ourselves, how exactly we should talk to the colleagues, friends, parents, children, and also more so to the patients. So in this aspect, Dr. Rajiv Agarwal, who is the Medical Director, Kasturba Medical Private Limited, and Medical Director for Kasturi Care for Seniors, President Kasturi Medical Foundation, and the President Association for Medical Consultants Mumbai. He's a honorary treasurer of IMA headquarters HP1 in 2022 and 24 also, and the past treasurer IMA Maharashtra, and the past president IMA Meera Bander, and a recipient of so many awards. One among them is a Coronavirus Award from State Governor, and IMA National President Appreciation Award in 5 times. It's not an easy job to have 5 times, okay, National President Appreciation, and IMA State President's Appreciation Award 7 times. So with this, I welcome Dr. Rajiv Agarwal to go ahead with the proceedings. Thank you.
Thank you, sir. Good morning, everyone. First of all, let me thank IMA Karnataka State and IMA Gadag, and especially Pawan Patil for inviting me here. And I'm really overwhelmed with the hospitality what you all have shown. So thank you from the core of my heart. My topic today is effective communication skills in healthcare, defining excellence, how we can improve our communication skills and this. So we'll examine why communication is the foundation for quality care. And believe me, after going through this next 20 minutes, you will realize how important it is to have a very good communication with the patient. You may not be very well up to date with your medical knowledge, but if you are a very good speaker, if you are able to communicate well, most of your problems will get solved. Did you know that miscommunication costs the healthcare system approximately $765 billion annually, according to a JAMA research? It's not me, it's a JAMA research. And the biggest problem what doctors or patients face, doctors just don't listen to us as they have no time. This is what most of us must have listened to from our patients, somewhere or other they keep on complaining, So the way something is said is more important than what is said. As simple as that. What I'm able to communicate to you, how I'm able to communicate is more important than what the matter of this PPT. So that is the most important crux of the matter. Now, what is listening? Listening, it's an art, it's a skill, and it's a key to good communication, And whereas hearing is, it's a passive mechanism where someone is speaking and you are just there, physically there. So that's, and 5 bad listening habits, which as doctors or as healthcare workers, we should overcome is faking attention, distractions, avoiding difficult materials, note taking when the patient is saying, we start writing something or doing something, and a wandering mind when the patient is speaking, or I am talking to you and then someone is looking there, that. So that is this. 5 techniques to improve listening. Reflexive feedback. You give your feedback to the patient. Silence. Sometimes you listen patiently to what the patient is saying. That also helps. Listening with your eyes and ears. It's not just you are listening with your ear, but if you are able to focus with your eyes on the patient, it does have an impact. Body language, if your body language is not good, definitely patient will not like it. And you should learn the art of dealing with angry and upset patients. If you are able to master that, I'm sure no one on earth can beat you in practice. For many people, the real art of medicine is just being listened to. As simple as that. Most of the patients come to us and they feel if the doctor has just listened to me, most of the problems get sorted out. Believe me, this is the real fact. Now, what is effective communication? It is mutual understanding. It is understanding between you and the patient. It is active listening. What the patient is saying, you need to listen to it. You need to understand it. And clear messaging. Your message should be very loud and clear to the patient, what you want to say, and it has to be very precise and concise. The critical role of communication, 80% serious errors are because of miscommunication, 80%. And 1 in 3 malpractice claims are because of communication failures. This is not me, it is the data that is. And 30% improvement in the patient safety if you are able to communicate yourself properly and to the caregiver of the patient, there is improvement in the patient safety. So this is very important. Now, what are the types of healthcare communication? Verbal, what we are talking to them. Non-verbal, this includes your body language, your facial expressions, your tone, what you're saying. Written, what you are giving in writing to the patient, it could be in the form of email or it could be, something written pamphlets. And interdisciplinary between the healthcare workers. A patient may require multidisciplinary team, other consultants may be involved. So there has to be communication between the team also. And of course, the communication should also be there with the grassroots workers in the hospital, like the nursing staff, the ward boy, maushi, on-duty doctors. Core principles of effective communication, it should be very clear. You should be clear in what you're saying. You should not beat around the bush. You should have empathy. Empathy to the patient is most important today. Patient should realize or feel, yes, this doctor is concerned for my illness and this doctor will be able to solve my illness. Conciseness, you have to be very precise and concise in what you're saying. And consistency, what you are saying, the same thing should be told by your colleagues, by a on-duty doctors, by a nursing system. It's not that one person is saying it's a myocardial infarction and the other is saying, no, it's a stroke, So that should not be there. So consistency is very important. And because of non-consistency, many of the legal issues arise. What is a patient-centered communication? What is the definition? Communication that respects patient's preferences, the patient's preferences, needs and values. It positions patient as active partners in care decisions. So you take into consideration what the patient wants and then you act accordingly. The impact is research from Annals of Family Medicine show patient-centered communication leads to 3x better adherence to care plans, higher patient satisfaction, and fewer diagnostic texts. So this is very important. So what is the element of patient-centered care? Open-ended questions. You ask the patient direct questions. What is your illness? What are the symptoms? Why have you come to me? Non-judgmental language. You should not be judgmental in coming to the conclusion. Always, avoid blame game with the patient. Teach back method. So when you have taught something to the patient, you see to it, you ask them, okay, what did you understand from that? Many times, most of the patients are so fearful or so shy, they are not able to respond back. So if you are able to ask them to speak back, they understand things better and their adherence to your care is better. And shared decision making, you have to share, collaborating on treatment plans, interdisciplinary as well as with the patients. Now, this is a slide which shows the cost of effective communication. Average malpractice claim decreases. Hospital readmissions, if there is ineffective communication. If there is ineffective communication, malpractice claims increase, hospital readmissions increase, adverse events increase, and extended hospital stay. So just a small communication, you can see the graph, how everything, and it is a cost to the patient. Believe me, if the patient is happy, if the patients go home early, they will always say good about you. Now, top barriers to effective communication. Language difference. Now, I am come here from all the way from Mumbai. It's Karnataka, so your language will be Kannada. I will not be able to understand. So if I'm treating a patient, I should know the local language. If I'm not able to know the local language, I should have an interpreter who can interpret things. And many of the time, non-English speaking patients face 35% higher risk of adverse effects. Health literacy gaps in India, except for Kerala, we can say there is so much of illiteracy, so you have to understand the basic education of your patient and the caregivers, whoever, and your relatives, because you may be speaking as a doctor or as a consultant, but the patient's relatives or the patient may not understand anything. So that is very important. Time pressure. We doctors, are so much busy in our work. So the average time what the patient feels, the doctor's ears is not more than 23 seconds. So patient feels, if the doctor, most of the time by 23 or 25 seconds, we interrupt the patient and we say, okay, I got the diagnosis, I'm going to treat you. So that is very wrong. Emotional stress, anxiety reduces patient comprehension by up to 40. So you have to make the patient and the relatives very comfortable. Health literacy, even in a country like US, 12% people are proficient about the basic healthcare system, only 12% patient, only 12% patients are aware of this. 53 are intermediate, they know something. And 35% are below basic, they don't know most of the medical terminologies. So this is very important. We need to understand the basic IQ of the patient and their literacy so that we can respond to them, communicate to them accordingly. Navigating language and cultural differences, access the language needs of the patient, and accordingly you speak to that. Use professional interpreters. Many times what we do, we call staff or we ask the relatives to interpret. That is because they may not be able to interpret it right. And you do not know what they are communicating to that patient. So that is the reason why always use professional interpreters wherever available, and apply cultural humility, respect diverse health beliefs and practices. Technology has a double-edged weapon, The benefits, it has 24/7 access, remote care possibilities are there, standardized documentation is possible with that, and it enables data sharing, which is very important. What are the challenges? Screen time, if you are talking and at the same time typing on the computer, your eye-to-eye contact with the patient is lost. And that is the biggest difference. The communication is lost with the patient. Digital divide excludes some patient. Information overload, because of this, Google Baba, we all say in short, on WhatsApp, WhatsApp PhDs and Google PhDs, patient comes to us, they are overloaded with information and they try to, bully us literally. Technical disruptions, foundational communication skills, empathic listening, you have to be very empathic when you are listening. Focus fully on the speaker, acknowledging the feelings, what the patient wants to say. Skillful questioning, open versus closed questions, probing for deeper understanding of the issue what the patient is facing. Plain language, avoid using jargons or using accessible vocabulary. You have to be very simple, you have to talk to them like a layman. And confirmation, verifying whether the patient has understood what you have told. That is most important because that is going to impact the treatment of the patient. And you have to have a feedback from the patient. Now, non-verbal communication. Whatever you communicate, only 7% is the actual words which has the impact on the patient. 93% is going through your body language. Now, if I am suppose speaking to you and I am, doing like this and this, you will learn this speaker is not good. His body language is not good. If I'm very firm, the way I speak to you, my tone, I have to be gentle. I cannot be harsh with the patient. So that is very important. So 55% of your body language has an impact on what you speak to the patient. 38% on the voice tone, how comfortably and confidently you are saying. It should not be this. So patient will understand this doctor does not know. So this is very important. According to researchers Albert Mehrabian, these percentage reflect how meaning it's communicated in emotional conversation, especially when a dying person is there. If you're not able to communicate with them, then it could have an impact. The teach back method: explain information, provide clear information using plain language, ask for repetition to the patient so that they are able to repeat it. If the patient speaks, it is proved beyond doubt that the patient will understand things and he will remember things. Clarify if there are any misunderstandings, what the patient has in the mind, and you answer each and every question. Unfortunately, we doctors don't have time, so we don't, try to clear the misunderstanding. And this misunderstanding later on impact the outcome of the patient. And confirm the understanding. It's not just clearing the misunderstanding, confirm what the patient has understood. That is most important. This SBR, a proven clinical strategy. Situation: briefly state the current problem, that you have a high blood pressure. You came with say 150 by 100 BP. Now your blood pressure is 140, 80, whatever. The background, provide relevant context. History: do you have a history of hypertension, diabetes, stroke, or other things? Assessment: assess the patient completely, not just on the reports or on the history. And recommendations: you have to recommend what you feel is proper and apt for the patient. And you have to ask them whether they are comfortable with these recommendations, whether they would like to have some additional information or medication. Motivational interviewing: partnership, collaborate as equal rather than, the patient should feel that he is equal to you. He is able to express himself comfortably. Acceptance: respect autonomy and acknowledge perspective. Evocation: draw out patients' own motivations for change. And compassion: prioritize patients' welfare and best interest. Now, this is a strategy for breaking bad news. It spikes. It's called spikes. What do you mean by spikes? Setting of interview. You have to have a place where you can, have a dialogue with the patient's relatives when you want to break the bad news for an illness or for the death of the patient. So it has to be a private. You cannot do it in public, and it has to be a comfortable environment. Perception of the patient is very important. Assess what the patient or the relatives already know. Invitation: you invite whoever wants to know you. This saves a lot of time also, because what happens, you declare something, you tell something, and then later on others say, okay, you tell to this. So you tell in advance, whoever wants to come, whoever wants to understand the criticalness or the outcome of the patient, please join. So that will save a lot of time. Sharing of knowledge: share knowledge clearly. Emotions and empathy: you have to be, it's not, when you're breaking a bad news, you get a call from your friend, okay, today night we have a party, and you start laughing and you smiling, and you say, yeah, I'll be there tomorrow, today evening, what all is there in the party. And also this is going to create a very bad impression. And unfortunately, we doctors do not realize these small things, and this happens with us day in and out. And this is where, you imagine you are in their shoes, and if someone is behaving like this, whether you will like it. And strategy and summary: plan next steps together. And you have to be planning everything in advance. So breaking bad news, many problems start at this point. This is where the main crux of the communication skill lies. Ask also from your staff, they should be able to know what they need to say and what all they do not need to say. Many times staff are arrogant with the patient's relatives. That is not there, at least for critical ill patient. Patient's expectations are not only from you, but from your staff, because they are giving the care to the patient. Train them to behave well. Find few intelligent staff or duty doctors who can, tell the relatives the seriousness of the patient, outcome of the patient. They are good way of communication. We may not have time. We may be busy in our OPD or in surgery, but this staff can communicate with them well. Ask them to be in constant touch with the sick patients and their attendants. This communication of the staff, if they have a good rapport with the patient and the attendants also, it definitely impacts the outcome, and outcomes are better. If they are happy with their attitude, then most of the time they say, okay, it was the wish of God. That is the reason why my patient did not. But if you are not able to communicate, the blame game comes on you. tell ICU staff or the gateman to be, relaxed, slightly relaxation when there is a dying patient, because most of the relatives come and they want to see the patient. And that is where, the real tussle starts between the hospital management or the hospital staff and the relatives, and they feel ki we have not been denied our right of seeing our dying patient, So there you have to be slightly this. Tips for doctors from IIM Ahmedabad on breaking bad news: identify patient attendants who can create problem, develop rapport with them, know their name, communicate with them, and address their concerns. 5 stages of attendance on breaking the bad news. They will be in a mode of shock, denial, and disbelief. Convince them that this is the actual outcome. We cannot do anything in this. Blame, anger, and aggression. That is the second stage. Support them, listen to them, be calm, and make them calm. Bargaining, empathy, show some empathy with them and feel with them what has happened, and you try to show them you are part of their grief. Help them to accept the reality. They will go into depression and finally they will accept. Don't leave them at the stage 1 and 2. What we do in our hospital, I run a multi-specialty hospital. What we do, whenever we want to break a bad news, we time it every 15 minutes or 20 minutes or half an hour. Our staff or our consultant goes and speaks to the relatives. We delay the declaration of the death, not for money, very clearly, not for money, just to pacify the relatives, let them accept the reality. And then if you are able to break the news after 2 hours or 3 hours, they'll be able to accept it better. Otherwise, you just come out of the ICU and say your patient is dead. No one is going to accept it. So communication during dialysis: establish clear change of command, implement closed loop communication, use common terminologies, don't use hi-fi words, and utilize the checklists which are there. Poor communication: doctors are taught clinical behavior but not empathy. Unfortunately, in medical colleges also this is not being done. Caregivers must be trained in breaking bad news, empathizing, and communicating with their patients. Training communication skills from expert as a part of the ongoing curriculum of medical students, even for undergraduate. This should be a must, and it should be a part of our curriculum, which is very important. So 3 things to control when you are communicating with the patient: your speech, your behavior, and action. And 3 things to avoid is rough tone, arguments, and gimmicks. Engaging with families and caregivers. You have to have family meetings, as I told earlier. You need to train caregivers how to give medications. Patient is on insulin. You need to train them how to give that injection. And discharge planning, just 2 more minutes. Share decision-making models, the present options, discuss the pros and cons, clarify patient values, and reach to a decision together with the caregivers and the patient. And documentation, this is the crux of the matter. If you are not able to document, no one on earth, we have a medical legal con, no one on earth is going to save you. And difficult situation like end of life discussions, mental health concerns, medical errors, and substance issues, these you need to tackle it very tactfully. The role of interdisciplinary communication: it decreases mortality by 10%, 30% better care coordination, and 26% fewer medical errors. So I'll just skip. Yeah, plain language like myocardial infarction, you use the word lay language: heart attack, hyperlipidemia, high cholesterol, pulmonary embolism, blood clot in the lungs, and hypertension means high blood pressure. So these are common words. Visual aids are very helpful. If you are able to use that in your practice, it will have a better impact. And digital communication like patient portal messages, telemedicine, as well as email communication, you need to be very concise and very sure what you're communicating. AI and chatbots, they are good for appointments, but still the human touch is not there. So we cannot replace AI with the human touch. And what is the human factors which affect healthcare communication? Fatigue, workload, noise, and interruption. The power of empathy: it increases the patient satisfaction, treatment adherence, anxiety reductions, and disease. This is the return of investment for communication. Even if you are able to give 4 hours of communication talks or literacy to your staff, the return investment much high. The staff training, interpreter services, this, if you are able to spend even this much, it will give a very good effect long run. So the summary is: patient-centered approach, clear and accessible approach, culturally responsible, and structured and standardized. Thank you for having a patient listening. Thank you.
Very nice lecture, Dr. Rajiv Agrawal. Just in a lighter note, there was an incident in Bombay teaching hospitals. Post-operative wards, there was a standard order, TPR, every 15 minutes, temperature, pulse, and respiration. for the unexpectedly in one of the busy hospitals, the tea was missing. So PR every 15 minutes. So the nurse started doing PR throughout night. No, this is the lighter vein. Communication matters. All of us are taught about how to give a lecture, how to talk to in the interviews, but nobody teaches us how to listen. By listening to others, we can understand them better. The seniors, our parents are always complain that my children don't listen to me. To listen to your children, you have to listen to them. To understand them, you have to listen to them. Same thing happens in patient and doctor communication. Any questions if time permits?
We can take one or two questions.
Questions from the audience?
Most of our problems will get solved if you are able to communicate to the patient well. Unfortunately, as doctors, we feel this is not our cup of tea. Our staff will do, our RM will do. But the treating doctors should do that, primarily.
As the breaking the bad news is so important, breaking the bad news, good news also very, very important. I've seen many patients, once the cesarean took place and the gynecologist and pediatricians that tell the relatives that there's a joyous moment that the boy or the girl is born and other things. And they simply say that everything is all right. Okay, it can be discharged within 2 or 3 days. But after a couple of hours, the patient goes into PPH. So when you are telling the good news, you have to be very, very judgmental and balanced. Otherwise, it has a repercussion once the patient goes into PPH and lands with the cardiac arrest.
Thank you for the nice presentation, sir. I just want to add some points, no questions. Like in a small place like Gadag, we know everyone and patient first come to family doctor. So even though they also know that the patient is serious, just for the sake of people and relatives, they just bring them to hospital and they ask us to call another doctor for confirmation and telling. So we should kill our ego and call our colleague at the right time and ask them to explain the consequences so that relatives are also satisfied. And if there is a death in our hospital, it's our duty to stay in hospital till the body is taken away by the relatives. And we should be ready to answer how many people they come or whatever it is. So if we spend one day in that, we'll not have any complications. And sometimes we get patients from rural areas and they don't have money. So if the patient is dead and they don't have vehicle
Sonia,
to take them.
Falling short of time. Can you continue?
Just 1 second. And if they don't have money, so we can arrange for a vehicle. And in fact, if for one patient, if we pay money for transport, we are not going to become poor. So that way we can help our patients and maintain our reputation.
Point taken, madam. One more thing I would like to emphasize here. Many times these family doctors play a very important role when you're breaking the bad news, So if there is a family doctor who has referred this patient, you try to call him also when you're trying to break, because he has a better relation and rapport with the family.
One online question from YouTube channel, that online one. How to pacify angry patient whose sole reason is to argue to decrease the cost of treatment and walk off?
Sir, whenever there is a death in the hospital or whenever you see a mob, it is better to be wise. You may give the leverage to your staff or to yourself to give some more extra concession, because ultimately, if there is violence in the hospital, if there is something wrong that happens in the hospital, that is going to give you more negative publicity and more damage, and that damage will be long term, And what I have seen, I give a lot of talk on recovery of hospital bills, there I make it a point ki whenever a patient, we call it kit patient, short form KK. So our staff says ki, sir, this patient is KK. So we understand. So there, you have to give that extra leverage to the patient, and whatever discount you're doing, make sure that you don't ask the patient to come back to paid, because no one is going to come back to paid. And what happens, if they have not paid, suppose you have not paid my bill, whenever a person known to you comes to my hospital, you are the first person to stop him to come to my hospital, because you have to come to my hospital to see that patient, and that time I'll ask you money. So you will, tell the patient's relative, don't go to that hospital, this hospital not good, bad, they charge you. But if I have given you that extra concession, you will be, no, that doctor is really very good. He is like God. He understands. He will motivate patients. So that is one important thing for specifically angry patients. You need to give that extra leverage.
Thank you. Thank you.
Sir, so one last question, sir.
Sir, continuation of this.
Discuss.
It's a
Sir,
TO.
continuation of that, it's a double-edged sword. If
Absolutely.
you leverage, they think you are the culprit. You should be sensible in that. You can't straight away say, I will leave off because
No,
it's
sir.
a death.
I'm not saying you do straight away.
Yeah.
You start with
Over the period,
5%,
over the-
then 7%, then ultimately, okay, this is the last. And what I do,
Sir, we
if
are
the
falling
patient
short of
says,
time. We can
this is the
discuss during
last,
tea
after
break.
that, you pay the entire money.
I think we can discuss. the
Thank you.
debate
Yes,
after
sir.
that. Thank you.
Thank you, Dr. Rajiv Agarwal, sir. I request our chairperson, Dr. Shashidhar Reshmi, sir, and Shivkumar, sir, to felicitate speaker. I request Dr. Biradar, sir, to come and felicitate chairpersons Reshmi, sir, and Kumbar, sir. Slight change in the program. We'll be having the moot court case 2. After that, followed by our two more sessions. That is a consent in a medical practice and preventing and combating the violence. Later, maybe post lunch or something, another will be having a moot court case 3, followed by the panel discussions. Thank you. Now we'll be having the moot court case 2 by Dr. Jogarao sir and team. Thank you, sir. Thank you, Biradar sir, and Reshmi sir, and Kumbar sir. Small request. I want to know the vehicle XL6 number KA34 P1914. It is in the midway of it's obstructing some vehicle. Is somebody having that car? KA34 P1914.
Next is going to be the moot court, case 2. I request all the delegates to go through the case, which is forwarded to you on WhatsApp. And also it's been handed in the file with the scientific program. Yeah. Sir has again posted it on the WhatsApp group. So kindly go through the case so that you can understand the proceedings in a much better manner. So there have been some minor changes. We were supposed to start with the moot court, but we have completed one talk of session 4, followed by the moot court. This will be followed by the inauguration session, which is going to be again followed by the 2 remaining talks of session 4. And then we'll break for lunch. After that will be the panel discussion.
Hello. Check.
Check. Yes. Thank you. Check.
Hello. ನಾನು ಕೊಡ್ಬೇಕು ಹೇಳ್ರಿ ಅವಾಗ ನಾ ಹಿಡ್ಕೋದು
Yes.
Check, 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 check. Good morning, everyone. I'm Advocate Yashwant Prasad. I'm the Senior Associate at Legal Excel Attorneys. And today, we will be having two moot court proceedings to demonstrate what exactly happens in court insofar as medical negligence cases are concerned. Yesterday, we had one moot court session highlighting quashing proceedings before the Karnataka High Court. And today, we will be commencing with a fresh case and also a case on medical negligence before the District Consumer Commission, Gadag. And as part of these proceedings, we will be not just showing final arguments by both parties. We will also be showing how the cross-examination of a doctor takes place in a court. And as part of this cross-examination, we have Dr. S.V. Jogarao, who will be posing questions to the doctor. And then this would give you a broad idea as to how cross-examinations take place. And at the same time, what are the kind of arguments that are addressed on behalf of the patient as well as the opposite party doctor. So we'll do that insofar as the first case is concerned. And the next case is before the State Consumer Commission in Bangalore. Before the State Commission, we have two appeals that are listed. One filed by the patient side and one filed by the doctor's side. And in that hearing, we will be seeing why the patient argues for enhancement of compensation, for example, and why the opposite party or the respondent doctors would argue that there is no finding of medical negligence at all. So that would be the kind of proceedings that you will see before both the fora, that is the District Consumer Commission, Gadag, and the State Consumer Commission in Bangalore. So this is what we plan to do for all of you today, because oftentimes we do hear from a lot of our doctor clients and hospital clients that they're not very clear or not sure about how a cross-examination takes place. And sometimes they may not know how court proceedings take place. And through this endeavor of ours, we'd like to disseminate information as to what happens in court. It is not a complete replication of what happens in a court, but just to give you certain ideas about the court proceedings. And in a couple of minutes, we'll be starting. We just are waiting for Dr. Rao, and then we'll commence with the proceedings. Any questions that you may have, you may definitely feel free to ask us, probably post the case and even during the break. And feel free to observe, raise questions, and reflect on what happens in court. Thank you.
Okay.
Disclaimer, moot court proceedings are being conducted purely for educational purposes and creating awareness on courtroom proceedings. There is no intent and attempt made to misinterpret the courtroom proceedings or bring disrepute to the judiciary. ಅಣಕು ನ್ಯಾಯಾಲಯದ ಕಲಾಪಗಳನ್ನು ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಗಳಿಗಾಗಿ ಮತ್ತು ನ್ಯಾಯಾಲಯದ ಕಲಾಪಗಳ ಬಗ್ಗೆ ಜಾಗೃತಿ ಮೂಡಿಸುವ ಉದ್ದೇಶದಿಂದ ಮಾತ್ರ ನಡೆಸಲಾಗುತ್ತಿದೆ. ನ್ಯಾಯಾಲಯದ ಕಲಾಪಗಳನ್ನು ತಪ್ಪಾಗಿ ಅರ್ಥೈಸುವ ಅಥವಾ ನ್ಯಾಯಾಂಗಕ್ಕೆ ಅಪಖ್ಯಾತಿ ತರುವ ಯಾವುದೇ ಉದ್ದೇಶ ಮತ್ತು ಪ್ರಯತ್ನ ನಡೆದಿಲ್ಲ.
First case is policy, no? I'm not. He's the admission. But
Open court.
silence.
Paper. How many cases are listed today?
Total 38 cases, sir.
Okay,
And 3 cases are for hearings.
3 cases for hearing. Okay, we can start the call.
District Consumer Dispute Redressal Commission, Gadak. Item number 1, CC 282 of 2025, Mr. PP versus Notepad Insurance Limited. Counsel for Complainant, Advocate Arun Kumar.
My lord, filing for the complaint in this matter.
Yes, counsel. What is this fresh complaint?
Yes, my lord. I had taken a health insurance policy, my lord.
Okay,
And commencing from 26/6/2024 to 25/6/2025, issued by opposite party. My son fell in the house on 16th July 2024. His left knee was injured. And I took my son to the hospital. On examination, doctor suggested to get X-ray. X-ray was taken. After seeing the report, doctor advised to get the knees operated. So after surgery, hospital raised a bill, total amount 2,34,000 rupees. So since I had health insurance, I made claim to the insurance company. Insurance company rejected for reason unless caused by accident. That's why beginning non-policy ತಗೊಂಬೇಕಾದ ಸಂದರ್ಭದಲ್ಲಿ ಎಲ್ಲ ಸರ್ಜರಿ, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಹಿಪ್ ರಿಪ್ಲೇಸ್ಮೆಂಟ್ ಅಂಡ್ ನೀ ಸರ್ಜರಿ ಎಲ್ಲದಕ್ಕೂ ಕವರ್ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ತಿರ್ತಾನೆ. ಸೊ ನಾವು ಟರ್ಮ್ ಆಫ್ ಕಂಡೀಷನ್ ಕೂಡ ಇದೆ. ಅದು ಆಲ್ರೆಡಿ ಪ್ರೊಡ್ಯೂಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆಲ್ಸೋ ಮೇಲೋ. ಈಸ್ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಟರ್ಮ್ಸ್ ಆಫ್ ಕಂಡೀಷನ್ಸ್ ಇಸ್ ವೈಲೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. It amount to defense of service, the part of the insurance company. The complaint submit that my praise that kindly admit the case and issue notice the opposite parties. Grateful.
counsel, is there any delay in filing this complaint?
No,
Another
madam.
delay there?
Within 2 years,
Within 2 years file.
this limitation is there.
Can you please tell us how this honorable commission has jurisdiction? Gadagalli, why are you filing?
Yes, my lord. His complaint residing address in Gadag. So jurisdiction is there.
Mr. Counsel, I've seen from the documents that you filed along
Yes,
with the complaint, ನೀವು annexes ಅಲ್ಲಿ photocopies ಹಾಕಿದ್ದೀರಾ.
Yes, my lord.
See, as a matter of practice, as you know, as a lawyer, you should be filing certified copies or originals.
Yes, my lord.
Because photocopies ನೋಡೋದು ಬರೋದಿಲ್ಲ.
I will produce the evidence stage, my lord.
Evidence stage ಅಲ್ಲಿ
Yes,
ಮಾಡ್ತೀರಾ?
please.
Okay, done. Funny, please take down. heard learned counsel for the complaint, Arun Kumar, on admission of the complaint. Complainant has made out a prima facie case of deficiency of service against the opposite party insurance company. Hence, the complaint is admitted and office is directed to issue notice to the opposite party, returnable by
28/7. 28/7, sir.
Obliged, my lord.
Item number 2, CC 295 of 2025, Mr. J versus Royal King Travels, counsel for complainant, Advocate Jogarao.
Yes, Mr. Counsel, what is this fresh complaint?
Your Honor, my client has purchased a packaged tour for his parents who are senior citizens. This is from Gadag to Shirdi. The ticket very clearly indicated the seat numbers, during the travel, what kind of facilities, etc. And accordingly, the package includes even accommodation as well in Shirdi. Such and such date, onward journey went uneventful, and accordingly they reached Shirdi. But to their utter shock, they realized that their luggage was missing. As a result, they faced lot of difficulties. Neither from the bus crew nor from anybody could help my client's aged parents. That is the reason why, on this ground of deficiency of service, complaint is being filed.
Mr. Counsel, I think it is an admitted position that the travelers were the parents of the complainant. Can you demonstrate how the son can be construed as a consumer under the Consumer Protection Act 2019?
Your Honor, under the relevant provisions of Consumer Protection Act 2019, a person is considered as a consumer if he or she either pays or promises to pay or partly pays. And it also includes the beneficiary of the transaction. Consequently, the son who purchased the package tour tickets for his parents squarely falls under the ambit of the definition of consumer.
When you have purchased the ticket, on which portal did you purchase these bus tickets?
This particular portal offered special care for senior citizens.
Okay.
And accordingly, from that portal, I booked the tickets.
So you're saying that portal is an intermediary or a third party?
Intermediary.
Intermediary.
Yes.
But in this complaint, you have not made the intermediary as a party, as another.
Your Honor, insofar as the grievance is concerned, I don't have any grievance vis-a-vis the intermediary. In terms of booking, in terms of handing over of tickets, and all the travel kit, everything they have done. My only grievance is against the bus crew who are expected to take care of the luggage of the passengers. Particularly, I draw your attention to the fact that the ticket holders are senior citizens. That's where the deficiency is quite apparent.
Okay. Funny, please take down. Heard learned senior advocate Dr. S.V. Jogarao appearing for the complainant on admission of complaint. On perusal of materials placed on record, this commission is of the opinion that a prima facie case of deficiency of service has been made out against the sole opposite party. Hence, the complaint is admitted and office is directed to issue notice to the opposite party, returnable by
24/7, sir.
Much obliged.
CC 2 of 2018, Mr. O and Mr. O versus Dr. K, counsel for complainant, Advocate Jogarao, counsel for opposite parties, Advocate Radha Pyari and Arun Kumar. Sir, in this case, the case has been listed for both arguments and cross-examinations.
Oh, okay.
I appear for complainant, Your Honor.
I'm for opposite party doctor.
Counsels, I understand this is a case of medical negligence. But since the proceedings have been instituted under the Consumer Protection Act, I just want to understand how cross-examinations can be permitted in a consumer commission where summary proceedings take place and the focus is on expeditious disposal of cases. So if you could please tell me why I should proceed with cross-examination.
May I make a submission?
Please.
As per the settled position of law in our context, Supreme Court of India, time and again, and National Commission also very clearly laid out that cross-examination cannot be considered as a matter of rule. However, a window of opportunity is always given, particularly in the context of medical negligence cases, where the counsels make out a case for cross-examination. The discretion is vested in the hands of the Honorable District Commission. To my mind, in this particular case, where a young mother passed away on account of certain problems, accordingly, her husband filed a complaint. We think expert evidence will enable Honorable District Commission to arrive at a rational conclusion. That's our submission.
The complainant in this case has made several allegations of medical negligence against the opposite parties. And though any of the opposite parties cannot claim it as a matter of right to cross-examine or to adduce expert evidence, since we need to rebut the allegations made against the opposite party, and further, because the allegations made against the opposite parties are very complex in nature, which cannot be made out or established just by mere perusal of the documents on record. And since the Honorable Commission will be ably assisted by an expert if his evidence is adduced, and this will benefit both the parties, both the complainant as well as the opposite party doctors in arriving, and this will assist the Honorable Commission in arriving at a just and fair conclusion in this matter, Your Lordship. And therefore, we have adduced the expert evidence of Dr. Kulkarni.
Since I understand this is a very complicated case involving alleged medical negligence, let us proceed with expert evidence and also the cross-examination of expert. But before we do, has the expert affidavit been filed?
Yes.
Has been filed. And whether the witness is present? Present? Are you ready to cross-examine?
Yes, you.
Please. Let us continue.
Yes.
Witness, doctor.
I do swear, make in the name of God, that what I say shall state to be truth, the whole truth, and nothing but the truth. Thank you.
Doctor, have you filed the affidavit?
Yes, sir. Huh? Yes, sir. The affidavit is filed.
What is your qualification?
I am a senior gynecologist, sir, MBBS, DGO, and MD in OBG. And my age is 62 years. I'm practicing this profession since the last 30 to 5 years and have conducted around 1,000 deliveries.
Your Lordship, there is a discrepancy in terms of what he is saying and what is stated in the affidavit.
What's the discrepancy, sir? May I know?
The discrepancy is you are qualified with MBBS and DGO.
DGO and MD.
It is not mentioned here, doctor.
DGO is also.
And you are 35 years old. That's what is mentioned in the affidavit. And your experience is 7 years. And you have conducted 400 deliveries. That is what is mentioned in the affidavit. Therefore, I request you to kindly avoid any kind of improvisations.
Okay. Okay, sir.
I hope I.
Yes, sir.
You gave this expert opinion on behalf of the doctor in this particular.
Yes, sir, doctor.
Your specialization is OBG.
Obstetrician and gynecologist.
I hope you are aware Code of Medical Ethics 2002.
Yes, sir.
Clause 7.20. It says, and it reads as follows. A physician shall not claim to be specialist unless he has a special qualification in that branch.
I'm a qualified obstetrician, sir.
Yeah, no, that's not my question. In fact, my question is yet to come. Okay. The question is, as per Code of Medical Ethics, you may be a specialist, but can you be considered as an expert?
Definitely, Mila. Because DGO is also a recognized qualification to be an expert, particularly in this particular case.
Your
Lordship,
Lordship, yes. Your Lordship, my submission is, the doctor is a specialist, but whether a doctor, under what circumstances, can be considered as an expert? That is the reason why I'm asking you, do you think you can be considered as an expert?
Because I have conducted many deliveries and have seen a lot of such patients who have postpartum hemorrhage and what exactly is the problem here. So I think that I'll be able to give an expert opinion regarding this patient.
Okay.
Counsel, I have gone to the expert affidavit, and I think on the basis of the affidavit, I seem that he is well qualified and in terms of his expertise. So in case you have any contention on the very credibility of his evidence, please take it up at the stage of final arguments. But right now, let us continue with the expert evidence, because I don't see any infirmity in the affidavit that he has filed. So I don't see any objection he being considered as an expert, and the credibility of the evidence can be seen at the stage of final arguments.
Thank you. Doctor, in your affidavit, you have claimed that you have reviewed all the medical records of this patient. Am I right?
Yes, sir.
What actually the complication the patient has suffered?
Before I go into the complications the patient has suffered, I want to tell the stages of how exactly the delivery occurs. Because that is what is to explain, give a clarification regarding what I want to tell.
Doctor, what we can do is, ideally in a cross-examination, you will have to stick to the questions that are being asked.
Okay, sir.
So you can answer to the point of whatever question the counsel.
Okay, sir.
I repeat the question. What exactly the problem or complication the patient has experienced?
This patient after delivery had severe bleeding because of something called as an atonic PPH. And the treatment was followed correctly. And
my question is not about that.
She had a postpartum hemorrhage.
Doctor, please listen to my question and answer to the point.
She had a postpartum hemorrhage.
PPH she suffered.
Yes, sir.
In your affidavit, you have mentioned that whatever doctor has done subsequently is in accordance with established medical practice.
Yes.
That's what you said. Am I right?
Yes, sir.
Did you refer any kind of literature or authority indicating what is expected to be done in your affidavit?
Yes, sir. Yes, sir.
Where is it? Can you show me? In your affidavit, there is nothing.
So what we do is we follow the textbooks which are considered as a standard, like the William textbooks of obstetrics. The recent most update always mentions what
That's
exactly
fine,
has to follow.
doctor. I'm asking, in your affidavit, did you mention? You have not mentioned. But you gave an opinion saying that it is according to medical.
Because I want to give an expert opinion, sir. That's the reason. It is understood that I have undergone all these things and I'm updated as far as this particular subject is concerned.
Your Lordship, I require your indulgence here, informing that expert doctor what is written and submitted in the affidavit is what is to be taken into consideration.
Yes. Based on the amendments that you have made, what you have deposed in your affidavit, you will have to stick to those, and you cannot improvise in the sense that you cannot add any updated information.
Okay, sir.
This might be perhaps pretty old affidavit, and there may have been updates in your professional career which wouldn't be reflected. But nonetheless, that would not be of any prejudice to you. You have to stick to what has been mentioned in the
Okay, sir. Okay.
Then how come, even though she has taken what is expected as per the medical practice, how come the patient died?
Sir, the thing is, this patient had undergone a cesarean section, and in the particular, it was mentioned the time of delivery and the cesarean done is not mentioned, sir. So I just wanted to know what was the time of delivery, and because that's a very significant thing, time of delivery and the time the baby was delivered. It's not mentioned, sir. May I know when the time of delivery was done?
Doctor, you have made this entire thing as if you are cross-examining
No, sir,
me.
it's not.
I want you to understand, I am the counsel, I need to cross-examine you. Another thing, if nothing is mentioned about the delivery time in the affidavit, you are the author of the affidavit. I am not the author.
I'm not telling the affidavit in the main proceedings which has been given to me.
Not proceedings, affidavit you need to read. Doctor, my only point is, if you claim the doctor has taken all the care, how come she died?
Sir, the first thing is, immediately after the cesarean section, the anesthetist was there, the pediatrician was there, as well as the consulting operative surgeon was there. Then after the surgery was done, the patient will be sent to the post-operative ward only when everything is confirmed that everything is normal, that the patient BP, pulse and bleeding, everything is well controlled.
Doctor, you are not answering my question. My question to you is, if the doctor has taken warranted care, how and why the patient died?
So the patient died because of postpartum hemorrhage. The fourth stage of labor, usually PPH around 80% of the postpartum hemorrhage occurs in the first 2 hours of delivery. But here the patient was kept under observation. It is only after 2 a.m. this patient went into bleeding. So because of this atonic PPH, the problem has occurred, sir.
Which means, according to you, the atonic PPH led to death. Am I right?
It may not be atonic PPH, sir. It may be other conditions which is associated with atonic PPH.
Okay. But that led to death. That's what you are saying.
Yes, sir. Yes, sir.
In your affidavit, one more thing you have mentioned. You said that there is no negligence on the part of the doctor. On what basis you say that?
Because starting from the patient, from the time the patient went into labor, the doctor has already told the patient as well as the person who is attending the patient that you can have a normal delivery or you can end up in a cesarean. This was already explained. So afterwards, when she went into labor and when the patient was not able to deliver and the doctor decided that this patient needs a cesarean, the cesarean was performed. And after performing the cesarean along with the anesthetist, obstetrician and pediatrician, everything was done correctly.
Yes. Doctor, when she experienced PPH, whether doctor was present in the premises of the hospital?
Yes, sir. Doctor was present. The duty doctor was there. Who is...
Doctor, I'm not talking about duty doctor. I'm talking about the doctor who is a party to the complaint.
But in most of the situations, the first 2 hours when everything is maintained well, usually the duty doctor in the hospital and the nurse are the one who actually take care of the patient, sir, because they are experts.
Now, my question is, when she suffered PPH, whether this doctor was present or not?
The PPH was after 2 a.m. It was not before that. Before that, the patient was fine.
I know that. But my question is, at the time when she suffered, was she in the hospital? That's what I'm asking.
Because each and every patient doesn't go into PPH. So the first 2 hours when they found out that this patient is normal and all the parameters are normal, so that she thought that this can be handled by the duty doctor who is also well versed, as well as the nurse who is maintaining the ICU. So she gave that responsibility to them.
This is the third time I'm asking, you are not answering my question. One more question I'll ask. Do you know who is this doctor in this particular complaint?
Yes, sir.
How?
That doctor is the one who actually contacted me to give an expert opinion. Dr. K is mentioned here.
Which means the doctor has selected you as an expert doctor to give opinion for her.
Yes, sir.
That may be recorded, Your Lordship. Second, your claim that no question of negligence, etc. I thought you are saying like a judge, not as an opinion doctor. Do you still hold that opinion that there is no negligence on the part of the doctor?
Because see, a doctor is one who is definitely, without having any, he gives I want to give always the correct picture, whether I have been appointed by a doctor or not. It doesn't make much of a difference. I felt that this particular thing, what the doctor has given and what the treatment the patient has received is correct, sir.
Doctor, I put it to you that you gave this expert evidence because you want to save her.
It is not like that, sir.
But that's what your affidavit indicates. You have given such a clean chit.
The doctor has given the treatment like that. Everything was correct.
Thank you, Your Honor. Cross-examinations.
I have one question in re-examination.
Yes, permitted.
Doctor, before giving this expert opinion, have you consulted any medical literature on the subject?
Yes, sir. And we have consulted.
Are you in a position to produce before this honorable court the said medical literature? You can produce or not?
No, I have not. I don't have it at present, sir.
But will you be in a position?
Yes, I will be in a position to provide all the detailed documents.
File ಮಾಡಿ, we'll anyway go through it. So that should be fine.
Oblige.
Your Honor, as the cross-examination is completed, I request for a date, most probably after 3 weeks, because I have certain commitments.
Mr. Counsel, I understand that the cross-examination is just concluded. But as you know, this is a 2018 complaint and we are in 2025. And in my experience as a presiding officer, I have never seen a consumer case prolonged beyond 2 years. And I don't know what has transpired before my predecessor, but I understand that the State Commission and National Commission have given us these directions to dispose of matters quickly, especially when there's a very one-off instance of a 7-year-old case. So what I would direct both parties to do is to conclude arguments today itself.
Your Lordship. Maybe at least 1 week.
My hands are tied because I'm bound by what the state.
No, I have completed cross-examination.
What I'll do is I'll pass it over. Pass over Martsbito. 3 gantege I'll ask them to hear it.
3 p.m.
3 p.m. Both of you should argue. Otherwise, I'll have to post it for orders. The choice is yours.
We will go the argument, ma'am.
We'll out.
3 gantege ಹಾಕ್ಬಿಡಿ.
Passed over. Three PM matters, CC 2 of 2018, Mr. O versus Dr. K, Counsel for Complainant Advocate Jogarao, Counsel for Opposite Parties Advocate Radha Pyari and Advocate Arun Kumar.
Your Lordship, this particular matter pertains to medical negligence, where my client's wife, who is under the care of the respondent doctor, was subjected to the delivery. Considering the underlying condition, she was subjected to lower segment cesarean section. And accordingly, healthy baby has been retrieved. Thereafter, she was under the observation and monitoring. Around night 2 a.m., the duty nurse noticed that she had bleeding and accordingly breathlessness as well. Immediately alerted the duty doctor who came, and as per the information that is available to us, he contacted the respondent doctor who was not in the premises of the hospital. And accordingly, the doctor has asked the duty doctor to administer certain medications. Despite doing that, there was a bit of deceleration, but the volume of bleeding sustained. And the duty doctor realized the BP is falling. Accordingly, he informed the respondent doctor. After 45 minutes of that incident, doctor came, and accordingly, as claimed by the expert doctor, whatever that is required, she has done. But unfortunately, in the process, she developed a cardiac arrest. They claim that they have done CPR. I am not very sure, but she succumbed and she could not be revived. Your Lordship, there are three important allegations which I emphasize. Number one, the fact that the delivery time and the time at which she suffered PPH has not been documented in the medical record. Number two, the most important, she came to the rescue of the patient only after 45 minutes. I do concede that she did ask the duty doctor to give medication. Her presence, immediate presence, would have saved the life of my client's wife. It is really shocking that she took 45 minutes. Third, the most important, Your Lordship, I may not intend to defame or derogate a practicing doctor like the expert doctor, but somewhere down the line, I felt in the course of cross-examination, the expert opinion is a manufactured opinion. Manufactured opinion, not only that, he is an interested witness because on his own deposition, he mentioned doctor asked him to give the expert evidence. And expert evidence does not indicate the basis of his opinion. And his claim, I agree that the Honorable Commission has said he can be considered as an expert. But I repeat by saying that he may be at best a specialist, but cannot be considered as an expert. And in the affidavit, there is no mention whether he did experience PPH-related, PPH-like complications, the deliveries he has conducted. Affidavit is silent. On these three aspects, and more importantly, my client's WhatsApp photo clearly indicating at what time the doctor's car entered the hospital, which is very, very apparently indicates she's 45 minutes late. And the fact that my wife was suffering PPH also has been. Therefore, in the light of, on one hand, the manufactured expert opinion, on the other hand, the kind of evidence that is available, that's not, she was not present. And thirdly, the most important, there is no documentation as to the time of delivery, etc. On these grounds, I pray for allowance of the complaint.
Mr. Counsel, I have a couple of queries insofar as the evidence that has been led to substantiate your claims. Could you please clarify if it is only these medical records that have been filed, to substantiate your claim, there are these medical records that I have received.
Yes, Your Honor.
Okay. If that is the case, when the opposite party has tendered the expert evidence of a doctor, apart from cross-examining the expert, did you not explore the remedy of introducing counter-expert evidence?
Your Honor, I'm sure you are aware, but let me share my own experience. It is almost impossible to find a doctor to give evidence against another doctor. Number one. Number two, I did produce medical literature because Honorable Supreme Court in Krishna Rao versus Nickel Super Specialty made it very clearly, expert evidence is not mandatory. It can be in a given situation, medical literature may suffice. And accordingly, on one hand, I could not, rather my client could not get an expert doctor, which to give a counter expert opinion evidence. In addition to that, because of that situation, we have produced medical literature. And as per Supreme Court of India interpretation, the medical literature very clearly indicates the base point in this case, if there is delay in attending to the person in terms of suffering PPH, the only consequence would be the death. And that's what happened.
My second question, counsel. You have made allegations of fabrication of medical records. Insofar as the fabrication is concerned, is there any evidence that you have produced or the evidence of the expert evidence of any handwriting expert, anybody else to substantiate? Because as you know, the mere making of an allegation does not prove medical negligence. And every allegation must be substantiated with cogent evidence. And therefore, in this kind of a scenario where you've already made allegation, it's a serious allegation. It's an allegation of fabrication of medical records. To that extent, have you filed any, tendered any evidence?
Your Honor, it is so strange in this particular case. The medical records were two types. The medical records, what we got immediately after the death of the patient, are substantially different from the records what we got after a week. And both types of records clearly show the place where the additions, deletions, etc. took place. That's where the allegation of fabrication has been. For instance, there was no mention about the date of delivery, the time of delivery. There was no mention about when PPH took place. But the resubmitted documents, all the details are. That's where I think fabrication is prima facie.
And my concluding question. In this case, you have sought for a global compensation of rupees 1.5 crores. At the very outside, I think it is exorbitant as a claim. And I see that there is no proportionality as such, insofar as the expenses that were paid and ultimately the compensation that is being sought. Is there any basis on which you have sought for 1.5 crores as compensation before this Honorable Commission?
There are two submissions, Your Lordship. As per the provisions of 2019 Consumer Protection Act, the pecuniary jurisdiction of the commission is only decided by the consideration that is paid for the product or services. In this particular case, the total expenditure that the client has incurred is less than 50 lakhs. That's the reason why the complaint is filed before District Commission. As per 2019 Act, there is no cap on claim of compensation. Your Lordship, in this case, when she died, she was 28 years old and she is working in a reputed MNC as a software engineer. As per the Supreme Courts, the way the compensation gets computed, that's what we have followed, and accordingly 1.5 crores global compensation has been claimed.
that Supreme Court judgment, have you filed a copy?
I have not. I will.
Please give us the copy.
I will.
And,
I
you
will
can file
definitely.
it with the bench clerk.
Sure.
And you can also serve advance copy to the opposite side. Also.
Definitely. I will.
Yes. Madam, what is your response?
Yes. Basically, the complainant counsel has already placed all the facts on record, and due to paucity of time, I am only emphasizing on the crucial allegations of medical negligence made against the opposite party, which is the case of the complainant is simple, that the opposite party has delayed intervention, the opposite party's delayed intervention has led to the death of the instant patient. And primarily, the opposite party has answered all the allegations made by the complainant in his version at the trial court. And that is before this district commission. And the opposite party has substantiated the facts and responses in his version based on the medical records maintained by them. And these are very authentic documents and certified copies produced before this honorable court by the opposite parties. And the contentions taken by the opposite parties are that they have followed the protocol of attending and management of PPH is in accordance with the standard text of medical literature, and which I have already produced before this honorable commission along with my written arguments.
May I make
Now,
a submission?
Let Madam complete and then you can.
Let me complete. So the contention of the opposite party is made out in paras 4 and 5 of the version, in which I have clearly mentioned, on further examination, the nurse noticed vaginal bleeding. The duty doctor alerted the opposite party, and she is in turn instructed the duty doctor to administer certain medications. Almost 45 minutes later, the opposite party came and noticed severe bleeding. Now, the complainant is emphasizing that there is delay. But there is a duty doctor who is already attending and whom I have instructed over phone as to what kind of protocol that she has to follow before I came. And she is already on the treatment. It is not that delay has caused the unfortunate incident.
May I make a submission? Yes. Your Honor.
Yes.
I want to make a submission. Please. The way the opposite party's counsel is mentioning about the duty doctor's role. My only one question is, whatever the respondent doctor has done to the patient after she arrived at the hospital, whether duty doctor has done the kind of care, for example, packing, manual, all those things, what she has done after 45 minutes, if the duty doctor is treating, did he do the same care? Did he exercise the same care? Therefore, because duty doctor was there, because duty doctor was asked to give medication, doesn't hold water.
Your
Yes,
Honor,
madam. Continue, please.
Your Honor, the duty doctor has initiated the first line of treatment by administering uretronics and other transfusion measures and all before I came, and to control the bleeding. And therefore, the duty doctor has taken the very first line of treatment, which is necessary in the facts and circumstances of the case. And not everything need to be done at a particular stage. And it is one after another. There is a step-by-step management to manage the PPH, and which is already done by the duty doctor in this case. And thereafter, I have intervened and as mentioned in my version, I have followed the other protocol which is necessary responding to the patient's condition and situation, my lord. And therefore, in my version, I have denied all the allegations made by the complainant, which are totally based on surmises, and they are not true. And moreover, the complainant in this case has not adduced any scrap of evidence to show that the protocol adopted by me is deviated. What I have done is totally in accordance with the standard textbooks prescribed in this regard. And also, I have produced the relevant medical literature in this regard as to the protocol to be followed by the doctor in the case of PPH. And this is also whatever I have produced Datta's textbook on gynecology, and also Williams Williams textbook of gynecology, operative gynecology.
Madam, one minute. I just have one question with respect to this duty doctor aspect. Now, you are saying that the main doctor, she has not come, and she had given the responsibility to the duty doctor to oversee the patient's condition. Now, who is this duty doctor? What is the qualification of the doctor?
She is a MBBS and DGO. She was assisting me, and because I have after cesarean section, I have been to attend few other patients who have come to the labor ward to conduct deliveries. I have entrusted my case to the duty doctor, who is equally qualified and competent, and she has also performed so many surgeries along with me in the past. Therefore, there is nothing to show, there is nothing like she is not qualified or experienced to attend the instant patient.
Madam, but when you know it's a very serious complication and also life-threatening, if you were not present as the main doctor, you could have probably sent another senior doctor. I mean, the duty doctor perhaps could have administered some sort of basic treatment, but when it is an emergency, it's a life-threatening condition. Aren't you not under a duty to send your other colleague, somebody else who could see the patient? I understand you were busy, you were attending to other patients, but you still do have a duty of care towards this patient. So you sending a duty doctor itself is not enough.
The duty doctor was monitoring the patient from time to time, and she was following the instructions given by me. And the complication continued after I arrived at 2 a.m. and after I arrived, and for which I have appropriately responded to the treatment by giving the necessary treatment.
Also, with respect to this 45-minute delay, have you taken a contention in your version as to what caused the delay? Why was there a delay of 45 minutes? And that too late in the night?
Actually, there was not a 45-minute delay, There is only a delay of 15-20 minutes. And I have produced my CCTV coverage before this Honorable Commission by way of a CD. At the instance of the complainant himself, we have produced, he called for the CD, and I have produced the CD before this Honorable Commission, which clearly indicates that there was no delay of 45 minutes as alleged by the complainant.
Adu CD jete 65B affidavit hakidira? Yes.
Yes. So,
okay. Done, madam. What I have understood the arguments from both sides.
I just
one more submission.
I'll just give you 1 minute each. Please tell. You can continue and then sir can
yes.
finish in 1 minute.
Yes. To conclude, I have produced relevant medical records and the CD. And also I have furnished medical literature which adequately substantiates and supports my case, and which is also corroborated by the expert evidence of Dr. Kulkarni, who just deposed before this honorable court. And whereas the complainant has not adduced any evidence, as per law, the burden of proof is on the complainant to establish with cogent and coherent evidence to show that the practices adopted by me are not consistent with standard medical practices. Therefore, on the one hand, the complainant has failed to discharge the burden of proof, And I have rebutted all the allegations made by the complainant with cogent evidence, and which substantiates the stand taken by me. And therefore, I pray your lordships to kindly dismiss the complaint in the interest of justice.
Yes, sir. Quick,
Your
1 minute,
Honor,
John.
just 3 points. When the patient suffered PPH, the kind of care the duty doctor has done. Suppose if the respondent doctor came to the rescue of the patient and initiated the care which he has done after 45 minutes, the patient would have survived. Second important point, Your Lordship. CCTV footage is only indicating when she started, because CCTV is in her premises. But WhatsApp photos which I have taken clearly indicate when the jeep has crossed the security gate of the hospital, and also the time when my wife, client's wife was suffering. Third, as per a very important Supreme Court judgment, discharge of burden of proof need not necessarily be in the light of independent evidence. Suppose if I can pinpoint the kind of discrepancy, the kind of foundational lapse in their evidence, I'm sure the complaint can definitely be. In view of this, the shocking death of a young woman, 28 years, I think the request to be taken note of. Accordingly, the
I may be
complaint may be
permitted to submit 2 points. ma'am.
Illa, madam. What I would do is, I've heard they've already written arguments no hakidira. I'll go through it, and also you file medical
No,
literature.
one submission.
Yes, yes.
One is PPH is a known complication in gynecological surgeries, particularly cesarean. It is a complication, and worldwide there are every one woman is like collapsing or falling prey to the PPH, and every 4 minutes throughout the world, every 4 minutes, one woman is dying because of the complication of PPH, which is a known complication. And as per the leading case decided by the National Commission recently, that is Chandarani Akori and others versus Dr. M.A. Setupati, it was observed, it clearly emerges from the exposition of law that a medical practitioner is not to be held liable simply because things went wrong from mischance or misadventure, or through an error of judgment in choosing one reasonable course of treatment in preference to other. And it continues, adopting a course of treatment, the duty cast upon the medical practitioner is that he must ensure that the medical protocol being followed by him is to the best of his skill and with competence at his command. At the given time, the medical practitioner would be liable only where his conduct fell below that of standard or a reasonably competent authority, competent practitioner.
Anyway, you've mentioned in your written arguments.
Yes,
I'll go through it. Citation hakidira?
Yes, sir.
Done. Okay.
Therefore, in the light of all the evidence produced by me, I pray your lordship to kindly dismiss the complaint.
Okay. Pani, please take down. Heard final arguments addressed by learned counsel for the complainant, Senior Advocate Dr. S.V. Jogarao, and learned counsel for the opposite party, Senior Advocate Dr. S. Radha Pyari and Arun Kumar. On the basis of the voluminous evidence tendered by both the sides, this commission is of the opinion that the complaint deserves to be partly allowed, since there is medical negligence specifically on the inexplicable delay of 45 minutes by the opposite party doctor when the patient was in an emergency state. Having said so, there is no sufficient evidence led by the complainant to prove the allegation of fabrication of medical records. And at the same time, the complainant has failed to prove how there is a rational basis to seek a compensation of rupees 1.5 crores. Therefore, in the interests of Justice, the complaint is partly allowed and a compensation of rupees 15 lakhs has been awarded to the complainant. And this order is to be complied with within 4 weeks from the date of this order. And the case is accordingly disposed of.
Silence.
Yes.
ఇక్కడ ఫుల్ స్క్రీన్ వచ్చావా ఇక్కడ ఫుల్ అయింది ఇక్కడ ఫుల్ కాదు సో డిస్ప్లే సెట్టింగ్ డూప్లికేట్ స్లైడ్స్ లేకుంటే సింగిల్ కనపడదు స్లైడ్ షో ఫుల్ స్క్రీన్ కనపడదు ఇంకోసారి చేసానా సే నువ్వు చెయ్యి ఏ ఇది వాడినావు నువ్వు ఇది ఆల్రెడీ ఓపెన్ ఉందని వచ్చేది ఆల్రెడీ అక్కడ ఫుల్ స్క్రీన్ ఉంది కాబట్టి ఇప్పుడు ఇట్లుంటది కాదు ఆడ చెక్ చేసుకుంటా చూడండి. రాకేష్ ఆడియో విజయ్ ఎగడే మెయిన్ పర్సన్ విజయ్ ఎగడే ఎగడే ఆడియో విషయం ಮತ್ತು ವಿಜಯ್ ಹೆಗಡೆ ಅನ್ಕೊಂಡಿ ಬಸವರಾಜ್ ಅವ್ರೆ ಏನ್ ಬೆಟ್ಟನೇ ಇಲ್ಲಪ್ಪ ಸಾಯಂಕಾಲ ಹೋಗ್ಬಿಟ್ಟೆ ಓದು ಆನಂದೆ ಖುಷಿ ಖುಷಿ ಕೂಡದಲ್ಲ
Hello.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಈ ಒಂದು ಸುಂದರ ಸಮಾರಂಭಕ್ಕೆ ಎಲ್ಲರಿಗೂ ಸ್ವಾಗತ.
Very good morning and a warm welcome to all of you who have gathered here. Ajramara Pranyo Vidya Arthajam Chintayer Grahit Iva Kesheshu Mrityona Dharma Machati.
ಅಜರ ಅಮರ ಅಂದರೆ ವಯಸ್ಸು ಮತ್ತು ಮರಣ ಇಲ್ಲ ಅಂತ ತಿಳ್ಕೊಂಡು ನಾವು ಜ್ಞಾನವನ್ನು ಅರ್ಜನೆ ಮಾಡಬೇಕು, ಅರ್ಥವನ್ನು ಅರ್ಜನೆ ಮಾಡಬೇಕು. ಅದೇ ತರ ಧರ್ಮ ಪಾಲನೆ ಹೇಗೆ ಮಾಡ್ಬೇಕಂದ್ರೆ ಮೃತ್ಯು ಈಗ ನಮ್ಮ ಹಿಂದೆ ನಮ್ಮ ಕೇಶವನ್ನು ಹಿಡಿದುಕೊಂಡು ಕೂತಿದೆ ಅಂತ ನಮ್ಮ ಒಂದು ಧರ್ಮ ಪಾಲನೆ ಮಾಡಬೇಕು. ಇಂತಹ ಒಂದು ಜ್ಞಾನಾರ್ಜನೆ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಎಲ್ಲರಿಗೂ ಸ್ವಾಗತ.
We are truly honored to host you today at the IMA Medico Legal 2025 Annual State Conference under the theme Safeguarding Ourselves While Saving Patients, hosted by IMA KSP in association with IMA Gadag and KH Patil Institute of Medical Sciences Gadag. Myself, Dr. Shilpa K, Assistant Professor Community Medicine, KH Patil Institute of Medical Sciences Gadag.
And ನಾನು Dr. Salim Jamal, consultant dermatologist, Gadag. It's our privilege to host this occasion. We request the esteemed dignitaries on the dais. We request our organizing secretary to be ready with the stalls to welcome them.
I request our National President, IMA, Dr. Dilip Balasari sir, on the dais.
And State President, IMA KSP, Dr. Chinwala sir. And above all, the censor of this occasion, ನಮ್ಮ ಗದಗ ಜಿಲ್ಲೆಯ ನೆಚ್ಚಿನ ಧುರೀಣರಾದ ಗೌರವಾನ್ವಿತ ಸಚಿವರಾದ ಡಾಕ್ಟರ್ ಎಚ್.ಕೆ. ಪಾಟೀಲ್ ಸರ್ ಅವರು ವೇದಿಕೆ ಮೇಲೆ ಬರಬೇಕು. ಅಂಡ್ ಹಾಗೆ ನಮ್ಮ ಕರ್ನಾಟಕ ವೈದ್ಯಕೀಯ ಪರಿಷತ್ ಅಧ್ಯಕ್ಷರಾದ ಡಾಕ್ಟರ್ ಯೋಗಾನಂದ ರೆಡ್ಡಿ ಸರ್,
Dr. Basuraj P. Bagnalli sir, Director, KH Patil Institute of Medical Sciences, National Vice President, IMA, Dr. Vignal sir,
and we will specially welcome Gadag IMA President Dr. Pawan Patil, who has been can be described as one-man army. Please come on the dais, sir. It's him, and it's because of him that this day is possible. Please give him a big round of applause.
Dr. Tukaram Suri sir, Gadag IMA Secretary,
and organizing chairperson of this conference, Dr. Radhika Kulkarni ma'am. Please come on the dais. and Dr. Organizing Secretary
Dr.
Arvind
Arvind
Karinagan,
the
ever enthusiastic
leader.
leader.
I also welcome State IMA President-elect Dr. Veerbhadraya sir on the dais.
It's time to welcome our past presidents, our seniors, Dr. P.M. Alu sir, Dr. Rajshekhar Ballari sir, Dr. Shivkumar Lakkol sir, Dr. Annadani Meti sir, Dr. Madhusudan Karignuru sir,
Dr. Venkatapati sir and Dr. Hollegowda sir.
Please give a big round of applause to all the dignitaries
on the dais.
Collect photos collect ಮಾಡಿ
Before we start, we are deeply saddened by the tragic loss of lives in the Air India Flight 171 crash incident. No words can truly ease the pain of such a devastating event. But we stand in solidarity with those affected, offering our praise, compassion, and strength.
ಈ ಒಂದು ದುರ್ಘಟನೆಯಲ್ಲಿ ಅಗಲಿದ ಅನೇಕ ನಾಗರಿಕರು, ವೈದ್ಯರು, ಅನೇಕ ಸರ್ಕಾರಿ ಅಧಿಕಾರಿಗಳು, ರಾಜಕಾರಣಿಗಳು ಇವರೆಲ್ಲರ ಈ ಅಗಲಿದ ಒಂದು ಆತ್ಮಗಳ ಗೌರವಾರ್ಥಕವಾಗಿ ನಾವು ಈಗ ಒಂದು ನಿಮಿಷ ಮೌನ ಪ್ರಾರ್ಥನೆ ಸಲ್ಲಿಸೋಣ. ದಯವಿಟ್ಟು ನಿಂತುಕೊಂಡು ಭಾಗಿಯಾಗಲು ವಿನಂತಿ.
Thank you all.
ಈಗ ಮತ್ತೆ ಪ್ರಾರ್ಥನೆಗಳು. ಮೊದಲಿಗೆ ನಮ್ಮ ನಾಡಗೀತೆ, ನಮ್ಮ ರಾಜ್ಯದ ಇತಿಹಾಸ, ಸಂಸ್ಕೃತಿ ಹಾಗೂ ಜನಜೀವನ ವ್ಯಕ್ತಪಡಿಸುವ ಈ ಒಂದು ಹೆಮ್ಮೆಯ ನಾಡಗೀತೆ ನೀಡುವಾಗ ಎಲ್ಲರೂ ಗೌರವಪೂರ್ವಕ ಗೆದ್ದು ನಿಲ್ಲಲು ಪ್ರಾರ್ಥಿಸುತ್ತೇವೆ. ಹಾಗೆಯೇ ಮುಂದೆ IMA ಪ್ರೇಯರ್ ಮತ್ತು ಫ್ಲಾಗ್ ಸಾಲ್ಯೂಷನ್ ಇರುತ್ತದೆ. ಡಾಕ್ಟರ್ ತುಕಾರಾಮ್ ಸೂರ್ಯ ಅವರಿಗೆ ನಾನು ತಯಾರಾಗಿರಲು ಈ ಮೂಲಕ ಕೇಳಿಕೊಳ್ಳುತ್ತೇನೆ.
I request Honorable IMA Secretary Dr. Tukaram Suri sir to deliver IMA prayer and flag salutation.
ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಪ್ರಾರ್ಥನೆ. ಎಲ್ಲರೂ ಸಂತೋಷವಾಗಿರಲಿ, ಎಲ್ಲರೂ ಆರೋಗ್ಯವಾಗಿರಲಿ, ಎಲ್ಲರೂ ನೋವಿನಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲರೂ ದುಃಖದಿಂದ ಮುಕ್ತವಾಗಿರಲಿ, ಎಲ್ಲ ಆಶಯ ಆಕಾಂಕ್ಷೆಗಳನ್ನು ಮೀರಿ ಗುಣಪಡಿಸುವವರು ನಾವಾಗಿರಲಿ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಧ್ವಜವಂದನೆ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ರಾಷ್ಟ್ರಧ್ವಜಕ್ಕೆ ವಂದನೆ ಸಲ್ಲಿಸಲು ಇಲ್ಲಿ ನಿಂತಿದ್ದೇವೆ. ಅದರ ಗೌರವ ಮತ್ತು ವೈಭವವೇ ನಮ್ಮ ಬೆಳಕು ಮತ್ತು ಶಕ್ತಿ ಮತ್ತು ಅದರ ಪದವಿ ನಮ್ಮ ಪಥವು. ಈ ರಾಷ್ಟ್ರೀಯ ಸಂಸ್ಥೆಯ ಮಾನ್ಯತೆ ಪಡೆದ ಸದಸ್ಯರಾದ ನಾವು ನಮ್ಮ ಜವಾಬ್ದಾರಿಗಳನ್ನು ಅರಿಯುವ ಮೂಲಕ ಅದಕ್ಕೆ ನಮ್ಮ ನಿಷ್ಠೆಯನ್ನು ತೋರಿಸುವ ಪ್ರತಿಜ್ಞೆ ಮಾಡುತ್ತೇವೆ. ದೇಶ ಸಮೂಹಗಳ ನಡುವೆ ನಮ್ಮ ರಾಷ್ಟ್ರಧ್ವಜವು ಉನ್ನತ ಮಟ್ಟದಲ್ಲಿ ಹಾರಾಡುವ ಸಲುವಾಗಿ ನಮ್ಮ ಅಧಿಕಾರದಲ್ಲಿರುವ ಎಲ್ಲವನ್ನು ಅದಕ್ಕೆ ಸಮರ್ಪಿಸುವ ಪ್ರಮಾಣ ಮಾಡುತ್ತಿದ್ದೇವೆ. ಜೈ ಹಿಂದ್. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘ ಚಿರವಾಗಿರಲಿ.
Thank you, sir. I request all to be seated. Now I request organizing chairperson Dr. Radhika Kulkarni ma'am to deliver welcome address.
Sorry, Dr. Pawan Patil sir, to give the bouquets to the dignitaries. While Dr. Radhika madam is coming, please sir.
ವಕ್ರತುಂಡ ಮಹಾಕಾಯ ಸೂರ್ಯಕೋಟಿ ಸಮಪ್ರಭ ನಿರ್ವಿಘ್ನಂ ಕುರು ಮೇ ದೇವೋ ಸರ್ವಕಾರ್ಯೇಷು ಸರ್ವದಾ. ಗುರು ಬ್ರಹ್ಮ ಗುರು ವಿಷ್ಣು ಗುರುದೇವೋ ಮಹೇಶ್ವರ ಗುರು ಸಾಕ್ಷಾತ್ ಪರಬ್ರಹ್ಮ ತಸ್ಮೈ ಶ್ರೀ ಗುರವೇ ನಮಃ. Good morning everybody. Actually, it's a very proud moment for full IMA Gadag for having this Medico legal conference first time in Gadag. First time. For the information of dignitaries, actually Gadag IMA is completing 100 years next year. So it is a proud moment for all of us today, which our IMA members have done it.
Name is not changed instead of doctors.
Actually, about this medico legal conference, if I want to talk, when we started our practice, when we studied medicine, it was in 80s. The medical books had only clinical knowledge. And our practice was only with faith and communication. The days are changing. The violence against the doctors has become more. The faith factor has reduced. So, we being the doctors, we should have the knowledge of law also, what to do if such things happen. So, this is the reason our IMA, along with the state IMA, they organize these medical legal conferences frequently. So this time we are having it in Gadag to give the knowledge about the law for all the doctors in and around Gadag. So today, I welcome the dignitaries on the dais. First, Chief Guest, Shri H.K. Patil, Sir, Minister of Law, Justice, Human Rights, Parliamentary Affairs, Legislation and Tourism, Government of Karnataka, and he is Pro-Chancellor of Karnataka State Law University, and he is in charge of full Gadag district. Welcome, sir. Next, our National President, IMA, Dr. Dilip Bansali. Next, our State President, IMA, Dr. Chiniwala. Then State KMC President, Dr. Yogananda Reddy. Then Director, K.H. Patil Institute of Medical Sciences, Dr. Basavaraj Bommanhalli. National Vice President of IMA, Dr. G.B. Bidinal. State IMA President-elect, Dr. Veerabhadrappa. Now we go to the past IMA State Presidents, Dr. B.M. Alur. Gadag has produced so many State Presidents, we are proud of that also. Dr. Rajshekhar Ballari, Dr. Shivakumar Lakot, Dr. Annadani Meti, Dr. Madhusudan Kariganu, Dr. Venkatachalapati, Dr. Honnegowda. Now, we are coming to the most active, our IMA President. This full medical legal conference is done by one-man show. That is most beloved IMA President, Dr. Pawan Kumar Patil. And most active IMA Secretary, Dr. Tukaram Sori. And full conference managed by our organizing secretary, Dr. Arvind. Since so many days he has not slept only. He has organized it very well. Welcome, Dr. Arvind. I also welcome all the members of IMA, delegates and guest lecturers who have lecturers who have come all the way from all over India, and the support staff, interns, PGs of the medical college. I also welcome all the media persons and members of the press. Now, I conclude my welcome speech by telling a quote from Gandhiji. Life will be in harmony if what you think, what you say, what you do should be in harmony. If you follow this, our practice, our life, everything will be good. Thank you very much. Long live IMA.
Thank you, ma'am. I also request our organizing chairperson, Dr. Radhika Kulkarni, ma'am. I welcome, ma'am. I request Dr. Pawan Patil, sir, President IMA Gadag, to honor. Thank you, sir. Thank you, ma'am. I, with immense respect and admiration, request our own Rajyotsava awardee, Dr. B.G. Bignal, National IMA Vice President, who has demonstrated his exceptional dedication, perseverance, and passion towards the betterment of the medical fraternity and care for the society, to present the preamble.
ಡಾಕ್ಟರ್ ಗೋವಿಂದಪ್ಪ ಬಿಡ್ನಾಳ್ ಸರ್, ವೇದಿಕೆ ತಮ್ಮದು. ತಾವು ಈ ಕಾರ್ಯಕ್ರಮದ ಬಗ್ಗೆ ಕೆಲವು ನುಡಿಗಳನ್ನು ಹೇಳಬೇಕಾಗಿ ವಿನಂತಿ.
First of all, good morning to all. And my respected guests, esteemed colleagues, and my fellow IMA members, and past president of IMA Karnataka, state president. I am honored to welcome you all to this IMA State Medico Legal Conference hosted by IMA Gadag in association with IMA Karnataka State Branch on yesterday and today. Today we gather with a distinguished panel of experts, including our Law and Parliamentary and Tourism Minister, Dr. Sri H.K. Patil ji, and Dr. Dilip Bhanushali, IMA National Vice President, IMA National President, and Dr. Yogananda Reddy, President, Karnataka Medical Council, Dr. Chilinwala, President, IMA Karnataka State Branch, Dr. Basuraj Bomlalli, Director, Sri K.S. Patil Institute of Medical Sciences, and Dr. Veerabhadraya, President-elect IMA Karnataka State Branch, Pawan Patil, most active President of IMA Gadag, Pawan Patil, and Dr. Radhika Kulkarni, Chairman Medical Legal Conference, and members of, and Dr. Arvind, and members of all conference committee members who worked hard, and past president of IMA Karnataka State Branch, and my dear delegates, and lawyers, and participant faculty, and advocates. As you know, ignorance of law is not an excuse. Through by vast experience of Dr. Pawan Patil, Dr. Yogananda Reddy, Dr. Veerabhadraya, and Dr. Mannegoda, and all the KMC members gathered here handling medical negligence cases at Karnataka Medical Council. They have realized the importance of educating our fraternity about laws governing our medical profession. Small ignorance in day-to-day practice can lead to unnecessary litigation problems. Dr. Pawan Patil was a part of hosting four medical legal conferences, and many conferences, and numerous webinars on this medical legal topic. This conference is an improvisation of all their previous efforts designed to reduce the fear among the medical fraternity and about medical related laws and litigation. The current trend of avoiding high-risk litigation patients is leading to delayed treatment and unfortunate deaths. We need to empower our members with knowledge and confidence to navigate these challenges. The conference provides a platform for delegates to express their views, clear their queries, clear their doubts, and learn from experts. For the first time in any medical legal conference, we are incorporating moot court session to help our members and understand the court procedures and overcome their fear. We have also invited advocates, police officials to share their insights, ensuring a comprehensive understanding of the medical legal landscape. We'll discuss recent judgment related to medical legal negligence cases, providing a valuable take-home message to our members. Let us all, our medical fraternity, work together to create a more informed, confident medical community, and we look forward for a productive and enriching conference.
we, the members of IMA Karnataka State Branch, President, and all the members are grateful to our Minister, Sri H.K. Patil ji, sir, in bringing a healthcare violence act in our state, which is one of the best in the entire country. Sri H.K. Patil ji was instrumental in bringing the healthcare violence. Having said this, I will say this preamble. I will welcome all the guests, chief guests, to my own hometown, the most ancient, historic city of Gadag, the holy land of Veeranarayana and his devotee Kumarasa, who wrote the epic Gadagina Bharata Karnataka Katha Manjari. I welcome you to holy place of Panchakshari Putras Gavai, Music College of Physically Challenged and Blind Students, which is paradise for the learning music student in this part of the country. I welcome you, sir, to this cooperative place of Gadag. As the way back to 1905, before independence, the cooperative society was started at Kadingnala village, Gadag, first time in the Asian continent. Afterwards, the visionary leader, Sri K.S. Patil ji, the father of our minister, has made it widespread all over Karnataka, this cooperative movement and cooperative work. And today is World Father's Day. We are remembering the father of Sri S.K. Patil. He is a visionary leader for this Gadag district and all Karnataka. We are remembering him, sir. And cooperative societies in Pan Karnataka, K.S. Patil was started cooperative societies in whole Karnataka, and for the and Gadag is known for its natural integration and communal harmony. For this fact, the Hindu Vaishnava temple, Veeranarayana, Trikoteswara temple, and Jumma Masjid are in one trustee, only one in entire India. And I also welcome to the communal harmony Swamiji, Tontada Siddhalinga Swamiji, who awarded communal harmony award, and also Bharata Ratna awardee, Gadag, the Hindustani music recital hero, Bhimsen Joshi, Bharata Ratna awardee, is from Gadag. Sir, we are welcoming you to this Gadag. Once again, I welcome you all to this Gadag, sir, to this medical conference. Thank you, sir. Thank you very much, sir.
Thank you, sir. Asatoma Sadgamaya, Tamasoma Jyotirgamaya, Mrityomar Amritangamaya, Om Shanti Shanti Shantihi.
ಕತ್ತಲೆಯಿಂದ ಬೆಳಕಿನೆಡೆಗೆ ಅಜ್ಞಾನದಿಂದ ಜ್ಞಾನದ ಕಡೆಗೆ ಕರೆದೊಯ್ಯುವ ಈ ಒಂದು ಜ್ಞಾನ ಸುದಯ ಕಾರ್ಯಕ್ರಮವನ್ನು ದೀಪ ಬೆಳಗಿಸುವ ಮೂಲಕ ಉದ್ಘಾಟಿಸಲು ವೇದಿಕೆ ಮೇಲೆ ಆಸೀನರಾಗಿರುವ ಎಲ್ಲ ಗಣ್ಯಮಾನ್ಯರನ್ನು ಈ ಮೂಲಕ ಕೋರಿಕೊಳ್ಳುತ್ತೇವೆ. ದಯವಿಟ್ಟು ಎಲ್ಲರೂ ಮುಂದೆ ಬಂದು ದೀಪ ಬೆಳಗಬೇಕಾಗಿ ವಿನಂತಿ. ವೇದಿಕೆ ಮೇಲಿನ ಗಣ್ಯರು ಒಂದು ಗ್ರೂಪ್ ಫೋಟೋಗಾಗಿ ನಾವು ವಿನಂತಿಸಿಕೊಳ್ಳುತ್ತೇವೆ. ಥ್ಯಾಂಕ್ ಯು ಆಲ್. ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ಈಗ ವೇದಿಕೆ ಮೇಲಿನ ಗಣ್ಯಮಾನ್ಯರು ನಮ್ಮನ್ನೆಲ್ಲರನ್ನು ಉದ್ದೇಶಿಸಿ ಮಾತಾಡುವಂತ ಸಮಯ. ಮೊದಲನೇದಾಗಿ ನಮ್ಮ ಕರ್ನಾಟಕ ವೈದ್ಯಕೀಯ ಪರಿಷತ್ ಅಧ್ಯಕ್ಷರಾದ ಸ್ಟೇಟ್ KMC ಪ್ರೆಸಿಡೆಂಟ್ ಡಾಕ್ಟರ್ ಯೋಗಾನಂದ ರೆಡ್ಡಿ ಇವರು ಬಳ್ಳಾರಿಯವರು. ಇವರು ಒಬ್ಬರ MBBS MD ಮತ್ತೆ DNB MD ಮಾಡಿದ್ದಾರೆ ಬಳ್ಳಾರಿ ಮತ್ತು ಹುಬ್ಬಳ್ಳಿಯಿಂದ. ಇವರು ಬಳ್ಳಾರಿಯ IMS ಸದಸ್ಯರು. ಈಗ ಪೃಥ್ವಿ ಚಿಕ್ಕ ಮಕ್ಕಳ ಆಸ್ಪತ್ರೆ ಬಳ್ಳಾರಿ ಇದರ ಒಂದು ಮುಖ್ಯ ಸಂದರ್ಶಕ ವೈದ್ಯರಾಗಿದ್ದಾರೆ. ಇವರು ಅನೇಕ ಹುದ್ದೆಗಳನ್ನು ಬಳ್ಳಾರಿ IMAಯಲ್ಲಿ, ಕರ್ನಾಟಕ IMAಯಲ್ಲಿ ಹಾಗೂ ನ್ಯಾಷನಲ್ IMAಯಲ್ಲಿ ಕೂಡ ಅನೇಕ ಹುದ್ದೆಗಳನ್ನು ನಿರ್ವಹಿಸಿದ್ದಾರೆ. ನಮ್ಮ ರಾಜೀವ್ ಗಾಂಧಿ ಮೆಡಿಕಲ್ ಸೈನ್ಸಸ್ ಯೂನಿವರ್ಸಿಟಿಯ ಸಿಂಡಿಕೇಟ್ ಸದಸ್ಯರು ಹಾಗೂ ಬೇರೆ ಬೇರೆ ಆಯೋಗಗಳು, ಕಮಿಟಿಗಳು, ನಮ್ಮ IMA ಸಮಿತಿಗಳು, ಕರ್ನಾಟಕ ರಾಜ್ಯ IMA ಸಮಿತಿ ಹಾಗೂ ನಮ್ಮ ಭಾರತೀಯ IMA ಅನೇಕ ಸಮಿತಿಗಳಲ್ಲಿ ಕಾರ್ಯಕಾರಿ ಸಮಿತಿ ಸದಸ್ಯರಾಗಿ, ಅಧ್ಯಕ್ಷರಾಗಿ ಕೂಡ ಕಾರ್ಯ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಬಳ್ಳಾರಿ IMA ಅಧ್ಯಕ್ಷರು ಹಾಗೂ ಕಾರ್ಯದರ್ಶಿಗಳಾಗಿ ಕೂಡ ಕಾರ್ಯ ಸಲ್ಲಿಸಿದ್ದಾರೆ ಇವರು. ಹಾಗೆ ನಮ್ಮ ಸಾಮಾಜಿಕ ಭದ್ರತಾ ಯೋಜನೆ ದಟ್ ಈಸ್ IMA ಸೋಷಿಯಲ್ ಸೆಕ್ಯೂರಿಟಿ ಸ್ಕೀಮ್ ಕರ್ನಾಟಕದಲ್ಲಿ ಮಾತ್ರ ಒಂದು ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿರುವಂತದ್ದು. ಹಿಮೋಫಿಲಿಯಾ ಸೊಸೈಟಿ ಹಾಗೂ ವಿಪತ್ತು ನಿರ್ವಹಣಾ ಸೊಸೈಟಿ ಮತ್ತು ನಮ್ಮ ವೈದ್ಯಕೀಯ ಸಿಬ್ಬಂದಿಯ ಒಂದು ರಕ್ಷಣಾ ಕಾಯ್ದೆಯನ್ನು ನಮ್ಮ ಗೌರವಾನ್ವಿತ ಸಚಿವರಾದ ಶ್ರೀ HK ಪಾಟೀಲ್ ಸರ್ ಅವರು ಇದರ ಬಗ್ಗೆ ಒಂದು ಮುಖ್ಯವಾಗಿ ಡಿಸ್ಕಷನ್ ಹಾಗೂ ಚರ್ಚೆಗಳನ್ನು ಪ್ರಾರಂಭ ಮಾಡಿದಾಗ ಶ್ರೀಯುತರಾದ ಡಾಕ್ಟರ್ ಯೋಗಾನಂದ ರೆಡ್ಡಿ ಸರ್ ನಮ್ಮ ಗದಗಿಗೆ ಬಂದು ಈ ಒಂದು ಕಾನೂನಿನ ಒಂದು ಕರಡುಪಟ್ಟಿಯನ್ನು ತಯಾರು ಮಾಡುವಲ್ಲಿ, ಸಿದ್ಧಪಡಿಸುವಲ್ಲಿ ಒಂದು ಮುಖ್ಯ ಪಾತ್ರವನ್ನು ವಹಿಸಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದರೆ ತಪ್ಪಾಗಲಾರದು. ಈಗ ಇರುವ ಒಂದು ವೈದ್ಯಕೀಯ ಸಿಬ್ಬಂದಿ ಹಾಗೂ ಆಸ್ಪತ್ರೆಗಳಿಗಿರುವ ರಕ್ಷಣಾ ಕಾನೂನು ಅದರಲ್ಲಿ ಒಂದು ಮುಖ್ಯ ಕಾಂಟ್ರಿಬ್ಯೂಟರ್ ನಮ್ಮ ಡಾಕ್ಟರ್ ಯೋಗಾನಂದ್ ರೆಡ್ಡಿ ಸರ್. ಪ್ಲೀಸ್ ಸರ್, ಮೈಕ್ ಇಸ್.
ಎಲ್ರಿಗೂ ನಮಸ್ಕಾರ. ನನ್ನ ಅಥವಾ ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಅತ್ಯಂತ ನೆಚ್ಚಿನ ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯ. ಈ ಮಾತು ಯಾಕೆ ಹೇಳ್ತಾ ಏನಂತಂದ್ರೆ, ಅಂದಿನ ಗದಗ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಮೆಡಿಕಲ್ ಸೈನ್ಸಸ್, ಗದಗ್ ವೈದ್ಯಕೀಯ ವಿಜ್ಞಾನಗಳ ಸಂಸ್ಥೆ, ಇಂದಿನ ಶ್ರೀ KH ಪಾಟೀಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಮೆಡಿಕಲ್ ಸೈನ್ಸಸ್, ಇದರ ಪ್ರಾರಂಭದಿಂದಲೂ ಇಲ್ಲಿಯವರೆಗೆ ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘ ಜೊತೆಯಾಗಿ ನಡ್ಕೊಂಡು ಬಂದಿದೆ. ವೇದಿಕೆ ಮೇಲೆ ಆಸೀನರಾಗಿರ್ತಕ್ಕಂಥ ಮಾನ್ಯ ಮಂತ್ರಿಗಳು ಈ ಒಂದು ಸಂಸ್ಥೆಯ ಜೊತೆಗೆ ಎಷ್ಟು ಅನನ್ಯವಾದ ಒಂದು ಸಂಬಂಧವನ್ನ, ಕಾಳಜಿಯನ್ನ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಅದು ಯಾವ ಶಬ್ದಗಳಿಂದಲೂ ವರ್ಣಿಸಲಾಗಲ್ಲ. ಹಾಗಾಗಿ ಇವತ್ತಿನ ಈ ಒಂದು ಸಮಾವೇಶದಲ್ಲಿ, ಈ ನನ್ನ ನೆಚ್ಚಿನ ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯದ ಈ ಸಭಾಂಗಣದಲ್ಲಿ ಯಾರ ಕನಸಿನ ಕೂಸಾಗಿತ್ತೋ ಅಂತಹ ಮಂತ್ರಿಗಳ ಉಪಸ್ಥಿತಿಯಲ್ಲಿ ನಿಂತು ನಿಮ್ಮೊಂದಿಗೆ ಎರಡು ಮಾತು ಮಾತಾಡಲಿಕ್ಕೆ ನನ್ನ ಸ್ವಲ್ಪ ಗಂಟ್ಲು ಕಂಪಿಸ್ತಾ ಇದೆ. ನಾನು ಸರಳವಾಗಿ ಮಾತಾಡಬಲ್ಲೆ, ಅದು ತುಂಬಾ ಎರಡೇ ಶಬ್ದ ಮಾತಾಡ್ತೀನಿ. ಇವತ್ತಿನ ಒಂದು ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಬಂದಿರತಕ್ಕಂತ ರಾಷ್ಟ್ರೀಯ ಅಧ್ಯಕ್ಷರಾದ ಡಾಕ್ಟರ್ ಬನ್ಸಾಲಿ ಅವರಿಗೆ ನಾನು ಒಂದೇ ಒಂದು ಮಾತು ಹೇಳ್ತೀನಿ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘ ತನ್ನ ಕಾರ್ಯಚಟುವಟಿಕೆಗಳ ಜೊತೆಗೆ ವೈದ್ಯಕೀಯ ಸಂಸ್ಥೆಗಳ ಬೆಳವಣಿಗೆಯಲ್ಲೂ ಕೂಡ ಮುಖ್ಯ ಪಾತ್ರವನ್ನು ವಹಿಸಿದರೆ ನಾವು ಸಮಾಜವನ್ನ ಮತ್ತೊಂದು ದಿಕ್ಕಿಗೆ, ಮತ್ತೊಂದು ಎಡೆಗೆ ಕೊಂಡೊಯ್ಯಲಿಕ್ಕೆ ಸಾರ್ಥಕವಾದ ಒಂದು ಸೇವೆಯನ್ನ ಕೊಟ್ಟಾಗ್ತದೆ. ನಾವು ಒಂದು ಸಂಸ್ಥೆಯಿಂದ ಹೊರಗಡೆ ಹೋದ್ಮೇಲೆ ಸಂಸ್ಥೆಯನ್ನ ನಾವು ಬೆಳೆಸೋದಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಬೇಕು. ಅತ್ಯಂತ ಮುಖ್ಯವಾದದ್ದು ಇಂದಿನ ವಿದ್ಯಾರ್ಥಿಗಳು ಬೇಕಾಗಿರೋದು ನಮ್ಮಂತಹ ಹಿರಿಯ ವೈದ್ಯರ ಮಾರ್ಗದರ್ಶನ. ಇದರ ಅಂಗವಾಗಿಯೇ ನಾವು ಇಂದು ಎಂದೂ ಕಂಡರಿಯದ ಒಂದು ಸ್ಥಿತಿ, ನಾನು ಇವತ್ತು ಕರ್ನಾಟಕ ವೈದ್ಯಕೀಯ ಪರಿಷತ್ ಅಧ್ಯಕ್ಷನಾಗಿರೋದು ಹೇಳ್ತಾ ಇರೋ ಮಾತಲ್ಲ, ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಸದಸ್ಯನಾಗಿ ಸಾಮಾನ್ಯ ಕಾರ್ಯಕರ್ತನಾಗಿ ಹೇಳೋದೇನಂತಂದ್ರೆ, ನಾವೆಲ್ಲರೂ ಕಂಡರಿಯದ ಒಂದು ಸಂದರ್ಭದಲ್ಲಿ ನಾವಿದೀವಿ. ಅಂದ್ರೆ ವೈದ್ಯ ಮತ್ತು ರೋಗಿಯ ನಡುವಿನ ಒಂದು ಅವಿನಾಭಾವ ಸಂಬಂಧ ಇಂದು ಯಾಕೋ ಏನೋ ಸ್ವಲ್ಪ ಶಿಥಿಲಗೊಳ್ತಾ ಇದೆ, ಸಡಿಲಗೊಳ್ತಾ ಇದೆ. ಅಂತ ಸಂದರ್ಭದಲ್ಲಿ ಇಂತಹ ಒಂದು ಕಾನ್ಫರೆನ್ಸ್ ನ ಗದಗ IMA ಪ್ರೆಸಿಡೆಂಟ್ ಡಾಕ್ಟರ್ ಪವನ್ ಪಾಟೀಲ್ ಮೇಡಮ್ ಹೇಳಿದ್ರು, ಒಬ್ಬರೇ ಮಾಡಿದ್ರು. ಇಲ್ಲ, ನಾನು ಒಪ್ಪೋದಿಲ್ಲ. ಗದಗ IMA ನಿಂತುಕೊಂಡು ಇಂಥ ಒಂದು ಕಾನ್ಫರೆನ್ಸ್ ನ ಗದಗಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಇಂಥದ್ದೊಂದು ನಾಲೆಡ್ಜ್ ನಮ್ಮ ವೈದ್ಯಕೀಯ ವೃತ್ತಿ ಬಾಂಧವರಿಗೆ ತಿಳಿಸೋದಕ್ಕೆ ನಮಗೆ ಸಂತೋಷ ಅನಿಸಿದ್ರು ಕೂಡ ಎಲ್ಲೋ ಒಂಥರ ವಿಷಾದ. ಏನಪ್ಪಾ, ಯಾಕೆ, ಯಾವ ತರಹದ ವೈದ್ಯ ರೋಗಿಯ ಅವಿನಾಭಾವ ಸಂಬಂಧ ಇತ್ತು, ಈಗ ಯಾಕೆ ಕಳ್ಸಿ ಹೋಗ್ತಾ ಇದೆ? ಇದನ್ನ ಮರುಸ್ಥಾಪನೆ ಮಾಡ್ಲಿಕ್ಕೋಸ್ಕರ ನಾವು ಇಂಥ ಒಂದು ಕಾನ್ಫರೆನ್ಸ್ ಮಾಡ್ತಿದ್ದೀವಿನೋ, ನಾವು ನಮ್ಮನ್ನ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಅಥವಾ ಡಿಫೆನ್ಸಿವ್ ಮೆಡಿಸಿನ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಥವಾ ಎವೇಸಿವ್ ಮೆಡಿಸಿನ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಈ ಕಾನ್ಫರೆನ್ಸ್ ನಾವು ಮಾಡ್ತಾ ಇಲ್ಲ. ಇದು ನಿಮಗೆಲ್ಲ ಸ್ಪಷ್ಟವಾಗಿ ತಿಳಿದಿರಬೇಕು. ಕಳಚಿ ಹೋಗಿರ್ತಕ್ಕಂಥ, ಶಿಥಿಲಗೊಳ್ತಿರ್ತಕ್ಕಂಥ ವೈದ್ಯ ಮತ್ತು ರೋಗಿಯ ನಡುವಿನ ಅವಿನಾಭಾವ ಸಂಬಂಧವನ್ನ, ನಂಬಿಕೆಯನ್ನ ಮರುಸ್ಥಾಪನೆ ಮಾಡೋದಕ್ಕೆ ಇಂಥ ಒಂದು ಕಾನ್ಫರೆನ್ಸ್ ನಾವು ಮಾಡ್ತಾ ಇದೀವಿ ಅಂತಕ್ಕಂಥ ಒಂದೇ ಒಂದು ಮಾತು ಹೇಳ್ತಾ ನನ್ನ 2 ಮಾತುಗಳನ್ನ ಮುಗಿಸ್ತೇನೆ.
ಧನ್ಯವಾದಗಳು ಸರ್. ತಮ್ಮ ಮಾತುಗಳು ಒಂದು ಈ ಕಾರ್ಯಕ್ರಮದ ಕಿರುಚಿತ್ರವನ್ನು ಕೊಡೋದಲ್ಲದೆ ಒಂದು ರೋಗಿ ಮತ್ತು ವೈದ್ಯರ ಒಂದು ಸಂಬಂಧದ ಬಗ್ಗೆ ಒಂದು ಬೆಳಕಿನ ಕಿರಣ ತೋರಿಸಿ ಹಾಗೂ ಮುಂದಿನ ಒಂದು ಆಶಾ ಕಿರಣವನ್ನು ಕೂಡ ನೀವು ತೋರಿಸಿದ್ದೀರಿ. ಧನ್ಯವಾದಗಳು ಸರ್.
Thank you, sir. I take this honor to call Dr. V.V. Chinivalar, sir, our next speaker, who is a general and laparoscopic surgeon, Sushrusha Nursing Home, Gangavati. Sir has done his MBBS and MS from MRMC Kalburgi. Sir has joined various posts in Gangavati, IMA and state IMA, and also local organizations and charitable trusts. Sir is also a syndicate member of Rajiv Gandhi University of Health Sciences. Sir, please.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಗದಗಿನ ತೋಂಟದಾರ್ಯ ಮಹಾಸ್ವಾಮಿಗಳನ್ನು, ಶ್ರೀ ಪುಟ್ಟರಾಜ ಗವಾಯಿಗಳನ್ನು, ಗದಗಿನ ವೀರನಾರಾಯಣನು ನೆನಪಿಸಿಕೊಳ್ಳುತ್ತಾ, ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಅಡಿಯಲ್ಲಿ 2 ದಿನಗಳಿಂದ ನಡೆಯುತ್ತಿರುವ ಈ ಮೆಡಿಕೋ ಲೀಗಲ್ ವರ್ಕ್ಶಾಪ್ನ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಮುಖ್ಯ ಅತಿಥಿಗಳಾಗಿ ಆಗಮಿಸಿದ ಕಾನೂನು, ಪಾರ್ಲಿಮೆಂಟರಿ, ಪ್ರವಾಸೋದ್ಯಮ ಮತ್ತು ಗದಗ ಜಿಲ್ಲಾ ಉಸ್ತುವಾರಿ ಸಚಿವರಾದಂಥ ಶ್ರೀ HK ಪಾಟೀಲ್ ರವರೇ, ನ್ಯಾಷನಲ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆದಂಥ ನಮ್ಮ IMA ನ್ಯಾಷನಲ್ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ಡಾಕ್ಟರ್ ದಿಲೀಪ್ ಭಾನುಶಾಲಿ ಅವರವರೇ, ನ್ಯಾಷನಲ್ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆದ ಡಾಕ್ಟರ್ GB ಬಿಡಿನಾಳ್ ರವರೇ, ಕರ್ನಾಟಕ ಮೆಡಿಕಲ್ ಕೌನ್ಸಿಲ್ದ ಅಧ್ಯಕ್ಷರಾದಂಥ ಡಾಕ್ಟರ್ ಯೋಗಾನಂದ ರೆಡ್ಡಿ ಅವರೇ, KH ಪಾಟೀಲ್ ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯದ ನಿರ್ದೇಶಕರಾದಂಥ ಡಾಕ್ಟರ್ ಬಸವರಾಜ್ ಬೊಮ್ಮನಹಳ್ಳಿ ಅವರೇ, ನಮ್ಮ ಪ್ರೆಸಿಡೆಂಟ್ ಎಲೆಕ್ಟ್ ಆದಂಥ IMA KSB ಪ್ರೆಸಿಡೆಂಟ್ ಎಲೆಕ್ಟ್ ಆದಂಥ ಡಾಕ್ಟರ್ ವೀರಭದ್ರಯ್ಯನವರೇ, ಡಾಕ್ಟರ್ ರಾಧಿಕಾಲ್ ಕುಲಕರ್ಣಿಯವರೇ, ಡಾಕ್ಟರ್ ಅರವಿಂದರ್ ಅವರೇ, ಮತ್ತು ಈ ವರ್ಕ್ಶಾಪ್ನಲ್ಲಿ ಮೂಟ್ ಕೋರ್ಟ್ ನಡೆಸುತ್ತಿರುವ ಡಾಕ್ಟರ್ ಜೋಗರಾವ್ ಮತ್ತು ಅವರ ತಂಡದವರೇ, ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘ ರಾಜ್ಯ ಶಾಖೆಯ ಎಲ್ಲ ಮಾಜಿ ಅಧ್ಯಕ್ಷರುಗಳೇ, ಪದಾಧಿಕಾರಿಗಳೇ, ಗದಗ್ ಶಾಖೆಯ ಅಧ್ಯಕ್ಷರಾದ ಡಾಕ್ಟರ್ ಪವನ್ ಕುಮಾರ್ ಪಾಟೀಲ್, ಮತ್ತು ತಂಡದ ಸದಸ್ಯರೇ, ಅಕ್ಕ ತಂಗಿಯರೇ, ಅಣ್ಣ ತಮ್ಮಂದಿರೇ ಮತ್ತು ಪತ್ರಿಕಾ ಮಾಧ್ಯಮದವರೇ, ತಮಗೆಲ್ಲರಿಗೂ ನನ್ನ ಪರವಾಗಿ ಮತ್ತು ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘ ರಾಜ್ಯ ಶಾಖೆಯ ಪರವಾಗಿ ವಂದನೆಗಳು. ಮುದ್ರಣ ಕಾಶಿ ಎಂದೇ ಪ್ರಖ್ಯಾತವಾಗಿರುವ ಗದಗ ಸಿಟಿಯು ಬಹಳ ವರ್ಷಗಳಿಂದ ವಾಣಿಜ್ಯ ಕ್ಷೇತ್ರದಲ್ಲಿ ಹೆಸರು ಮಾಡಿದೆ. ಗದಗ ಬೆಟಗೇರಿಯ ಸೀರೆಗಳು ದೇಶದಲ್ಲಿಯೇ ಅತಿ ದೊಡ್ಡ ಹೆಸರು ಮಾಡಿದಿರುವ ಜೊತೆಗೆ ದೇಶಕ್ಕೆ ಒಂದು ಒಳ್ಳೆಯ ಕಾಣಿಕೆಯನ್ನು ನೀಡಿವೆ. 1997ರಲ್ಲಿ ಜಿಲ್ಲಾ ಕೇಂದ್ರವಾಗಿ ಧಾರವಾಡ ಜಿಲ್ಲೆಯಿಂದ ಬೇರ್ಪಟ್ಟು ಸ್ವತಂತ್ರ ಜಿಲ್ಲೆಯಾಗಿ ಅಭಿವೃದ್ಧಿ ಪಥದಲ್ಲಿ ಸಾಗುತ್ತಿದೆ. ಆಗಿನಿಂದಲೂ ಸಹಕಾರಿ ಕ್ಷೇತ್ರದಲ್ಲಿ ತನ್ನದೇ ಆದ ಛಾಪನ್ನು ಮೂಡಿಸುವುದಲ್ಲದೆ ಉಳಿಸಿಕೊಂಡು ಬಂದಿದೆ. ಇದಕ್ಕೆ ಕಾರಣೀಕರ್ತರೆಂದರೆ ಶ್ರೀ H.K. ಪಾಟೀಲರವರ ತಂದೆಯವರಾದ ಶ್ರೀ K.H. ಪಾಟೀಲರು. ಅವರ ಅಂದಿನ ದೂರದರ್ಶಿತ್ವ ಇಂಧನ ಬೆಳವಣಿಗೆ ಕಾರಣ ಎಂದರೆ ತಪ್ಪಾಗಲಿಕ್ಕಿಲ್ಲ. ಅಂದಿನ ರಾಜಕಾರಣದಲ್ಲಿ ಕುಲಕೋಟಿಯ ಹುಲಿ ಎಂದೇ ಹೆಸರಾದವರು ಶ್ರೀ ದೇವರಾಜು ಅರಸರವರ ಮಂತ್ರಿಮಂಡಲದಲ್ಲಿ ಸಹಕಾರಿ ಸಚಿವರಾಗಿ ಸಹಕಾರಿ ಕ್ಷೇತ್ರಕ್ಕೆ ಅಭೂತ ಕೊಡುಗೆಯನ್ನು ನೀಡಿದ್ದಾರೆ. ಅಂದಿನ ಅವರ ಸೇವೆ ಮತ್ತು ಇಂದಿನ ಅವರ ಚಿರಂಜೀವಿಗಳಾದ ಶ್ರೀ H.K. ಪಾಟೀಲರ ಸೇವೆಯಿಂದ ಗದಗ ಜಿಲ್ಲೆ ಬಹಳ ಕ್ಷಿಪ್ರದಲ್ಲಿ ಅಭಿವೃದ್ಧಿಯತ್ತ ಸಾಗುತ್ತಿದೆ. ಇದಕ್ಕೆ ಈ ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯವೇ ಸಾಕ್ಷಿ. ಈ ವೈದ್ಯಕೀಯ ಮಹಾವಿದ್ಯಾಲಯದ ಪ್ರಾರಂಭವಾಗುವುದರಲ್ಲಿ ಸಹ ನಮ್ಮ IMA KSBಯು ತೆರೆಮರೆಯಲ್ಲಿ ತನ್ನ ಅಳಿಲು ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸಿದೆ. ಅದು ಡಾಕ್ಟರ್ ಯೋಗಾನಂದ ರೆಡ್ಡಿಯವರ ಮತ್ತು ಡಾಕ್ಟರ್ GB ಬಿಡಿನಾಳರ ಮುಖಾಂತರ ಎಂದರೆ ತಪ್ಪಾಗಲಿಕ್ಕಿಲ್ಲ. ಶ್ರೀ KH ಪಾಟೀಲರ ಸೇವೆಯನ್ನು ಪರಿಗಣಿಸಿ ಈ ವಿದ್ಯಾಲಯಕ್ಕೆ, ಈ ಮಹಾವಿದ್ಯಾಲಯಕ್ಕೆ ಅವರ ಹೆಸರನ್ನು ಕರ್ನಾಟಕ ಸರ್ಕಾರವು ಇಟ್ಟು ಅವರಿಗೆ ಗೌರವವನ್ನು ಸೂಚಿಸಿದೆ. ನಿಜಕ್ಕೂ ಇದೊಂದು ಒಳ್ಳೆಯ ಕಾರ್ಯ. ಗದಗ ಮತ್ತು ರಾಜ್ಯ ಸರ್ಕಾರಗಳ ಪರವಾಗಿ ಸರ್ಕಾರಕ್ಕೆ ನನ್ನ ಮತ್ತು ನಮ್ಮ ರಾಜ್ಯದ ಶಾಖೆಯ ಪರವಾಗಿ ಅಭಿನಂದನೆಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತಿದ್ದೇನೆ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘವು 1928ರಲ್ಲಿ ಕೇವಲ 222 ಸದಸ್ಯರೊಂದಿಗೆ ಕಲ್ಕತ್ತಾದಲ್ಲಿ ಪ್ರಾರಂಭವಾಯಿತು. ತದನಂತರ 1949ರಲ್ಲಿ ಸ್ವಾತಂತ್ರ್ಯ ಸಿಕ್ಕ ನಂತರ ಈ ಕಲ್ಕತ್ತಾದಿಂದ ದೆಹಲಿಗೆ ವರ್ಗಾಯಿಸಲ್ಪಟ್ಟಿತು. ಈಗ ಇದರ ಸಂಖ್ಯೆ 3.5 ರಿಂದ 4 ಲಕ್ಷ ಇದೆ. 1750 ಶಾಖೆಗಳು, 50 ಶಾಖೆಗಳಿವೆ. ನಮ್ಮ ರಾಜ್ಯದಲ್ಲಿ 180 ಶಾಖೆಗಳಿವೆ. 31,000 ಸದಸ್ಯರಿದ್ದಾರೆ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘವು ವಿಶ್ವದಲ್ಲಿಯೇ ಅತಿ ದೊಡ್ಡ ಆಧುನಿಕ ವೈಜ್ಞಾನಿಕ ವೈದ್ಯ ಪದ್ಧತಿಯ ವೈದ್ಯರ ಏಕೈಕ ಪ್ರತಿನಿಧಿಸುವ ಸ್ವಯಂ ಪ್ರೇರಿತ ಸಂಸ್ಥೆಯಾಗಿರುತ್ತದೆ. ಇದು ವೈದ್ಯರ ಹಿತಶಕ್ತಿ ಮತ್ತು ಯೋಗಕ್ಷೇಮವನ್ನು ನೋಡಿಕೊಳ್ಳುತ್ತದೆ. ವೈದ್ಯಕೀಯ ಮತ್ತು ಸಂಬಂಧಿತ ವಿಜ್ಞಾನಗಳ ಪ್ರಚಾರ ಮತ್ತು ಪ್ರಗತಿ. ಎರಡನೆಯದು ಭಾರತದಲ್ಲಿ ಸಾರ್ವಜನಿಕ ಆರೋಗ್ಯ ಮತ್ತು ವೈದ್ಯಕೀಯ ಸುಧಾರಣೆ. ಮೂರನೆಯದು ವೈದ್ಯಕೀಯ ವೃತ್ತಿಯ ಘನತೆ ಮತ್ತು ಗೌರವವನ್ನು ಕಾಪಾಡುವುದು ಇದರ ಮುಖ್ಯ ಕರ್ತವ್ಯಗಳಾಗಿವೆ. ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಎಲ್ಲ ಶಾಖೆಗಳು ನಿರಂತರವಾಗಿ ವೈದ್ಯಕೀಯ ಶಿಬಿರಗಳನ್ನು ಮತ್ತು ವರ್ಕ್ಶಾಪ್ಗಳನ್ನು ನಡೆಸುತ್ತಿವೆ. ಈ ಸಲ ಮೆಡಿಕೋ ಲೀಗಲ್ ವರ್ಕ್ಶಾಪ್ ನಡೆಸುತ್ತಿರುವುದು ಮೊದಲು ಕರ್ನಾಟಕ ರಾಜ್ಯ ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಇತಿಹಾಸದಲ್ಲಿ ಪ್ರಥಮವಾಗಿರುತ್ತದೆ. ಇದನ್ನು ನಡೆಸಿದ ಕೀರ್ತಿ IMA ಗದಗ ಶಾಖೆಗೆ ಸಲ್ಲುತ್ತದೆ. ಈ ವರ್ಕ್ಶಾಪ್ ಮಾಡಿದ ಉದ್ದೇಶವೆಂದರೆ ಇತ್ತೀಚೆಗೆ ಮತ್ತು ವೈದ್ಯರ ಮತ್ತು ಆಸ್ಪತ್ರೆಗಳ ಮೇಲೆ ಹಲ್ಲೆಗಳು ಹೆಚ್ಚಾಗುವುದರ ಪ್ರಯುಕ್ತ ಜೀವನದಲ್ಲಿ ನಾವು ಹೇಗೆ ಎದುರಿಸಬೇಕು, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹೇಗೆ ಸಿದ್ಧಪಡಿಸಬೇಕು ಎನ್ನುವುದರ ಬಗ್ಗೆ ಡಾಕ್ಟರ್ ಜೋಗರಾವ್ ಮತ್ತು ಅವರ ತಂಡದವರು ನಿಜವಾಗಿಯೂ ತಮ್ಮ ಕೋರ್ಟ್ ಮುಖಾಂತರ ತಿಳಿಸಿ ಕೊಡ್ತಿದ್ದಾರೆ. ಸೊ ಇದರಿಂದ ಈ ವರ್ಕ್ಶಾಪ್ ಅಲ್ಲಿ ಭಾಗವಹಿಸಿದ ಎಲ್ಲ ಪ್ರತಿನಿಧಿಗಳಿಗೆ, ಉಪನ್ಯಾಸಕರಿಗೆ ಮತ್ತು ಡಾಕ್ಟರ್ ಜೋಗರಾವ್ ಅವರ ತಂಡಕ್ಕೆ ಈ ಅವಕಾಶವನ್ನು ಒದಗಿಸಿಕೊಟ್ಟಂತಹ ಗದಗ IMA ಪದಾಧಿಕಾರಿಗಳಿಗೆ, ವಿಶೇಷವಾಗಿ ಡಾಕ್ಟರ್ ಪವನ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ಮತ್ತು ತಂಡದವರಿಗೆ ನನ್ನ ಮತ್ತು ಭಾರತೀಯ ವೈದ್ಯಕೀಯ ಸಂಘದ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಶಾಖೆ ಪರವಾಗಿ ಹಾರ್ದಿಕ ಅಭಿನಂದನೆಗಳನ್ನು ಸಲ್ಲಿಸುತ್ತೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ, ಲಾಂಗ್ ಲಿವ್ IMA.
ಧನ್ಯವಾದಗಳು ಸರ್. ತಾವು ರಾಷ್ಟ್ರೀಯ IMA, ಕರ್ನಾಟಕ IMA ಹಾಗೂ ಗದಗ IMA ಪರಿಚಯವನ್ನು ಮಾಡಿದ್ದಲ್ಲದೆ ನಮ್ಮ ಇತಿಹಾಸವನ್ನು ನಾವೆಲ್ಲರೂ ಮರುಕಳಿಸುವಂತೆ, ನಮಗೆಲ್ಲ ಮನದಟ್ಟು ಮಾಡುವಂತೆ ಹೇಳಿದಿರಿ. ಹಾಗೂ IMA ಕಾರ್ಯಕ್ರಮಗಳ ಬಗ್ಗೆ ಹಾಗೂ ಈ ಒಂದು ಸಮಾರಂಭದ ಉದ್ದೇಶ ಬಗ್ಗೆ ತುಂಬಾ ಚೊಕ್ಕವಾಗಿ ಹೇಳಿದ್ದೀರಿ. ತುಂಬಾ ಧನ್ಯವಾದಗಳು ಸರ್.
I request our next speaker, Dr. Dilip Banusali, sir, who is the National President IMA. Sir is basically from Hyderabad. We are proud that sir has pursued his MBBS from MRMC Kalburgi. Sir has held various posts in both national and state IMA. Sir has also worked for IMA in various committees. He has received multiple awards, and few among them are National President Appreciation Award, both as Best Secretary and Best President, and also has received Gold Medal for Best Secretary. He has conducted many regional, national CMEs and conferences in various capacities. Sir, please.
Namaskar. Krishnaya Vasudevaya Harare Paramatma Namah. Vantakle Sanasai Govindaya Namah. I admit a great honor and privilege to be here in Gadag. I saw first time on such a big, massive scale, this IMA Medical Legal Conference. I should compliment both the Karnataka unit and the Gadag unit of IMA for conducting this. Chief guest of today's function, Sri Dr. H.K. Patil, sir. Dr. G.B. Vidnal, Vice President at Headquarters. Dr. V.V. Chinwar, sir, at State President. Dr. Yoganand Reddy, President, Karnataka Medical Council. Dr. Baswaraj C. Bomandi, sir, Director of H.K. Patil Institute of Medical Sciences. Branch President, Dr. Pawan Patil. Secretary, Dr. Tukaram. President-elect, Dr. Veerbhadraya. And innumerable, I believe there are 6 to 7 past presidents from Gadag who have been President of Karnataka Indian Medical Association. That historical place of Gadag, I believe the IMA started in 1926. It's almost going to complete 100 years next year. That's a wonderful achievement. I'm really privileged to address you here as a president of Indian Medical Association. So my basic thrust in this talk, people should understand that what IMA doing for the IMA members. Every time we go, people ask, what's IMA doing? What's IMA doing for its member? Friends, if I enumerate what's IMA doing, you'll be shocked to know there are so many issues that IMA has been facing. I won't go in much detail of it, but few of it I should enumerate because you should all know what IMA has been doing. Well, the theme of this year's IMA was empowering the medical fraternity. Empowering the medical fraternity. Among this, I think today's 2 days workshop plays a very important role. We as a doctor should know what are our limitations, what are the medical legal issues we face. And for this, I should really compliment. This conference has been doing a wonderful service to the IMA by educating our doctors regarding medical legal issues. So, friends, IMA, you know, we have is the largest body in the world at a medical organization with 4 lakh members, 1 lakh junior doctors, 1 lakh medical students, so almost 6 lakhs. Out of 13 to 14 medical doctors, modern medical doctors, we are only 4 lakh. So you can understand, strength only comes when we have membership. And last time when we started, when I took over charge in December, immediately I started a membership drive, and I'm glad to announce that we had almost 10,000 members enrolled in this year. Well, this is not sufficient. I request the state branch and the local branches to enroll as many members as possible, because unless we have strength, we can't fight. Now, the most important thing which we have been fighting is regarding violence against doctors. Each day, in the last 2 weeks, if you have seen, there are dozens of cases which have come from. It's only because of our strength, our unity, that we could fight, especially in a case in Miraj and Sangli 2 weeks back. There was a arson and loot in a nursing home where 14 people came and did all this hangama there. And the solidarity of that IMA there. 400 doctors came on the road. I phoned up the DCP of Miraj, and within 24 hours, all the 14 people were arrested. That shows the unity. Second case, what you have heard about is the Goa incident. Of course, the doctor was not a member of IMA, but still, I gave a call, and we said he is a medical fraternity, and the whole of Goa, whole of JDN and MSN, they mobilized, and you saw the result. The minister has to come and apologize. People have seen the video, how the hiredness of the minister, I mean, in what language he spoke to the doctor. That is not acceptable. The chief minister himself had to come and apologize, and afterwards the strike was taken back. Similarly, so many incidents have been happening. IMA went to the court regarding this. We went till Supreme Court. With a 3-bench judgment, but we said that if judges and lawyers are exempted from Consumer Protection Act, why not doctors? Friends, you won't believe, in 2 seconds, they threw our application. And if you want to fight back once again, we have to go to the 5-bench judge. And the amount of expenditure, you can understand, is horrendous. So, since the moral of the story is we are not supported by the judiciary, we are not supported by the politicians, neither by the bureaucrats, and in fact, not by our patients. How many patients come to your rescue when you have violence in our hospitals? So what will save us? Only thing save us is our unity, our membership. So my request is increase our membership and be united. Second thing was about mixopathy. Mixopathy is from ages together here. And last 4 years we have seen, we went for a strike on mixopathy. I personally wrote to the Honorable Prime Minister, to the Home Minister regarding this. But since the government is very bent upon this Ayush thing, you know, in 1.5 years course, they want to teach 50 surgeries. They want to produce 50 half-baked doctors. So what are we going to do about this? And the only thing what we have remained, either we go to the court. Of course, there is a case pending in the Supreme Court, which is going to come on hearing in July about mixopathy. We told to the government that we are not against any pathis, whether it's Ayurvedic, homeopathy, Siddha, they have their own science that the government encourage it. Let it be, you know, let the public decide what they want. But why do you want to mix it? Why do you want to mix with all of you know, 90% of Ayurvedic doctors write allopathic medicines. Supreme Court in 2019 gave a judgment that no doctor can write medicines apart from what he has been taught. But still, Ayurvedic doctors write about allopathic medicines. Now, this is causing indirect quackery. Quackery is rampant, both in urban and rural areas, and for which I think we have to blame ourselves. We employ non-MBBS doctors in nursing home. We go and operate in the nursing homes. We encourage those homeopathic and Ayurvedic doctors. So are we not responsible for some of the quackery? We are. So you should introspect whether we are doing the right thing by employing those people, or we go and operate in those. In fact, some of us go and teach them. That's the job of the government. Let them do it. My due apologies to our Honorable Minister here, because I'm a bit open and bit straightforward in answering this. This message on my mixopathy was a front headline in Times of India. And in fact, I had a phone call from the Home Ministry also regarding this. But the fact remains that we have seen Mixopathy. GST. Friends, doctors who are in charge of all the branches should know GST is going to stay. Every branch should have its GST number. If you have a turnover of more than 20 lakhs in your branch, you have to pay GST. In fact, Kerala IMA went to the court and got a stay on that. But government is definitely going to challenge this in Supreme Court. So we have to continue to pay GST. 3 months back, I met the commissioner of GST in Delhi. I went with a request to almost reduce the rates on commonly used drugs for hypertension and diabetes, cancer drugs, cancer equipments. The GST was somewhere from 8% to 18%. We asked them to reduce it. They were very kind enough. They sent us to the council. We met the GST council. GST council asked us the list of drugs they want us to remove from the GST preview. We gave the names of almost 20-30 drugs, commonly used drugs. And this is under consideration. So GST, every branch has to pay the GST and take the GST number. The flagship program of IMA, Aao Gaon Chale. This is a very ambitious project taken by Dr. Ketan Desai of Britain. And almost we have 500 villages which has been adopted throughout the country. They are doing human services. I believe, I don't know how many villages have been adopted in Karnataka, but I request they should adopt villages. In urban areas, if they can't go to the villages, my call is to adopt slum areas. We at Telangana in Hyderabad, we have adopted a slum and we've been serving them for the last 30 years. Every Friday, we give free medicines and free services. Every week, we take different specialty people there. And there is a continuous record of that. It's a very ambitious project, Aao Gaon Chale. See, not only we take care of the patients, we can percolate the message of sanitation, good food, anti-TB program. This can be, through Aao Gaon Chale, we can do it. The other ambitious program which I took when I took over the president was HPV vaccination training program. This was a MOU signed with the Foxy people. Foxy people had done this phase 1 program last year where they trained 10,000 obstetric people. And in turn, they came to IMA and we have promised that we will teach 50,000 of our doctors, general practitioners, pediatricians, obstetric people. This is a training program where we, online program, you have to just attend this for 1 hour in a week where you get a certificate. Now people ask why this training program? See, we have seen HPV vaccination gives almost 90% protection against cervical cancer. If it's given between the age of 9 and 14. And at this age, children are not in the capacity to understand the significance of it. The parents have to be taught. What are the drawbacks? What are the reactions? When to give, what to give, how to give. These are all been trained for the doctors. So Karnataka, of course, is doing a wonderful job in this. They are almost enrolled 400 members in this. Is leading right now. So say the members who are present right now, they should ensure, irrespective of whatever field you are. This is a very important movement from IMA. Organ donation. If you have seen that India-Australia match in President Narendra Modi's stadium in Ahmedabad, where he gave a clarion call of organ donation. 40,000 members from Ahmedabad. They pledged for their donation. And from there, we started this organ donation camp. And this have been doing throughout India. The other important thing for IMA members was the job portal. We have opened a job portal both for the medical students, medical graduates, employment within India and outside India. It's a simple online registration form where you can fill up, you know where are the vacancies, and you can enroll yourself. This is an important development which has taken place in the last 3 months. Next was the tuberculosis. Prime Minister had given a call about this. We should eliminate tuberculosis from India by 2028. In that direction, we have association with Tuberculosis of India, Fight Against Tuberculosis, 2-3 organizations, and IMA has been participating with them in a big scale. Fit India movement was started by our sports minister, Dr. Mansukh Mandviya. They said you should cycle yourself. In fact, Dr. Mandviya himself cycles to the parliament for the last 5 years. So he said we should encourage, as a doctors, we can ask our patient to, this is a physical activity. So Cycle India or Fit India movement is very important. Regarding this PCP and DT Act, very important because a lot of our gynecologists, radiologists were suffering with this. We are fighting against this also. Last but not the least, I'm a building fund. As you are aware, our building has been totally demolished. We are coming with a state-of-the-art 8-story building in New Delhi, and for which we have asked for the building fund. I just asked rupees 1,000 per each member. Nothing more than that. 1,000 from every member. 4 lakh members, we collect 40 crore rupees. Friends, I think you should be proud that you are an IMA member. You should be proud that you're donating something for our own building. And my request is everybody should contribute to this. This is going to be completed. In fact, I'm doing the Bhumi Puja on 23rd of this month. And we expect that this project should be completed by 2 years. Well, these are some of the challenges I may be facing. And unless, as I said, we are united, we have membership, there is nothing much we can do. I once again thank the local branch, Gadag, for hosting this wonderful conference. I should compliment all the speakers who have come all over India, who have given their wonderful ideas on this. I should compliment the state of Karnataka, who has been in forefront in all the programs of IM. I should once again thank our Honorable Chief Guest sir for being here. And I think somebody said that he was instrumental in getting us this act in Karnataka. My request is, sir, if you can bring the provision of 7 years imprisonment with non-bailable warrant. Is that? That's wonderful. So I think we'll follow up this with the other states, this act of yours, and we'll see, because this is a state subject. And I met Mr. Amit Shah, Home Minister. He says, a state subject, you go and contact your chief ministers. So we have requested all state branches to contact their local governments to see this. And the other was Clinical Establishment Act. People, small nursing homes, people with 10 beds, 12 beds, 15 beds, 50-bed hospital are facing a lot of, majority of the closing. The amount of harassment on this, they once again said it's a state subject. So state people have to go to the respective state governments to fight against this for getting exempted. Almost 6 states have already got it. In fact, Karnataka, Bihar, Haryana, and in Kerala, they have got it. So we are trying to get throughout India this provision of exempting 50-bedded hospital from this preview. Ladies and gentlemen, it's really a proud privilege to once again in Gadag amongst you and seeing this wonderful conference. My best wishes to all of you. Long live IMA, Jai Karnataka, Jai Hind.
Thank you, sir, for your kind words and also encouraging for more members to join. We assure you that Gadag IMA is in forefront of membership drive, and also we thank you for explaining about various services and activities of National IMA in the service of nation. Thank you, sir.
ಈಗ ನಮ್ಮನ್ನು ಉದ್ದೇಶಿಸಿ ಮಾತನಾಡಲು ಬರುವವರು ಅವರನ್ನೊಂದು ವ್ಯಕ್ತಿ ಎನ್ನಲು ಸಾಧ್ಯವಿಲ್ಲ. ಅವರು ಒಂದು ಶಕ್ತಿ, ನಮ್ಮ ಗದಗ ಜಿಲ್ಲೆಯ ಒಂದು ಮಹಾನ್ ಶಕ್ತಿ. ಅವರಿಗೆ ನಮ್ಮ ಜನರು ಕೊಡುವ ಗೌರವ ಜವಾಬ್ದಾರಿಗಳು ಎಷ್ಟೊಂದೇ ಇರಲಿ, ಸರ್ಕಾರ ಕೂಡ ಅವರ ಕೆಳಗೆ ಎಷ್ಟೊಂದು ಇಲಾಖೆಗಳನ್ನು ಕೊಟ್ಟಿದ್ದಾರೆ. ಅವರ ಎಲ್ಲ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಹಾಗೂ ಎಲ್ಲ ಕೊಡುಗೆಗಳನ್ನು ನಾನು ಇಲ್ಲಿ ಓದಲು ಹೋದರೆ ಈ ಸಮಾರಂಭ ಅಧ್ಯಕ್ಷರು ಕೊಟ್ಟರೆ ನಮ್ಮ ಸಮಯ ಮುಗಿದು ಹೋಗಬಹುದು. ಈ ದೇಶದಲ್ಲಿಯೇ ಒಂದು ವಿಶ್ವವಿದ್ಯಾಲಯ, ಗ್ರಾಮೀಣಾಭಿವೃದ್ಧಿ ಹಾಗೂ ಪಂಚಾಯತ್ ರಾಜ್ ವಿಶ್ವವಿದ್ಯಾಲಯ ಅಂತ ಒಂದು ವಿಶಿಷ್ಟ ವಿಶ್ವವಿದ್ಯಾಲಯ ನಮ್ಮ ಗದಗಿಗೆ ಬಂದದ್ದು ಈ ಒಂದು ಮಹಾನ್ ಶಕ್ತಿಯ ಮೂಲಕ. ಹಾಗೆಯೇ ಸಾಬರಮತಿ ಆಶ್ರಮ ಅದರ ಪಕ್ಕ ಇದೆ. Why I am mentioning this, all the dignitaries can visit this beautiful university and its campus and the Sabarmati Ashram replica. And our Vice Chancellor sir is also here. He will guide you through. Coming back, ನಮ್ಮ ಜಿಲ್ಲೆಯ ಹೆಮ್ಮೆಯ ಧುರೀಣರು, ಪ್ರಶ್ನಾತೀತ, ಪಕ್ಷಾತೀತ ಹಾಗೂ ಜಾತ್ಯತೀತ ನಾಯಕರು, ಅಜಾತ ಶತ್ರು ನಾಯಕರು, ಮುತ್ಸದ್ದಿ ರಾಜಕಾರಣಿಗಳು, ಈ ರಾಜ್ಯ ಕಂಡ ಒಂದು ಧುರೀಣರು ಹಾಗೂ ಜನಪರ ಕಾಳಜಿ ವಹಿಸುವಂತ ಒಂದು ಕಾರ್ಯಕ್ರಮಗಳು, ಕುಡಿಯುವ ನೀರೇ ಆಗಲಿ, ಜನರಿಗೆ ಒಂದು ಸಹಕಾರ ಚಳವಳಿ ಆಗಲಿ, ಸಹಕಾರಕ್ಕಿಂತ ಹೆಚ್ಚಾಗಿ ಒಂದು ಸ್ವಾವಲಂಬನೆ ಒಂದು ಚಳವಳಿ ಆಗಲಿ, ಈ ಆಟೋ ಓಡಿಸೋದಾಗಲಿ, ಬೇರೆ ಬೇರೆ ಬಿಸಿನೆಸ್ಗಳು ನಡೆಸುವಂತಹದ್ದಾಗಲಿ, ರೈತರ ಹಾಗೂ ಒಂದು ಕಾರ್ಮಿಕರ ಸ್ವಾವಲಂಬನೆಯನ್ನು ಸಾಧಿಸಿದ್ದು ನಮ್ಮ ಗೌರವಾನ್ವಿತ ಸಚಿವರಾದ ಡಾಕ್ಟರ್ H.K. ಪಾಟೀಲ್ ಸರ್ ಇವರ ಒಂದು ಮಹತ್ವದ ಕೊಡುಗೆ. ನಾನು ಹೆಚ್ಚಿನ ಸಮಯ ತೆಗೆದುಕೊಳ್ಳದೆ ಸರ್ ಅವರನ್ನು ಈ ವೇದಿಕೆಗೆ ತಮ್ಮ 2 ಮಾತುಗಳನ್ನು ಹೇಳಲು ಆಹ್ವಾನಿಸುತ್ತೇನೆ. ದಯವಿಟ್ಟು ಬನ್ನಿ ಸರ್.
I am a Medico Legal Annual Karnataka State Conference. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಪಾಲ್ಗೊಂಡಿರ್ತಕ್ಕಂಥ ಎಲ್ಲರಿಗೆ ನನ್ನ ನಮಸ್ಕಾರಗಳನ್ನು ತಿಳಿಸ್ತೀನಿ. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಮುಖ್ಯ ಅತಿಥಿಗಳಾಗಿ ಪಾಲ್ಗೊಂಡಿರ್ತಕ್ಕಂಥ ರಾಷ್ಟ್ರೀಯ IMA ಅಧ್ಯಕ್ಷರಾದ ಹೈದರಾಬಾದ್ನಿಂದ ಬಂದಿರುವ ಡಾಕ್ಟರ್ ದಿಲೀಪ್ ಬನ್ಶಾಲಿ ಅವರೇ, ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಗೌರವಾನ್ವಿತ ಅತಿಥಿಗಳಾಗಿರ್ತಕ್ಕಂಥ ನಮ್ಮವರೇ ಆದ ನಮ್ಮ ಗದಗಿನವರಾಗಿರ್ತಕ್ಕಂಥ IMA ಇಂಡಿಯನ್ ಮೆಡಿಕಲ್ ಅಸೋಸಿಯೇಷನ್ನ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಿರ್ತಕ್ಕಂಥ ಮಾನ್ಯ GB ಬಿಡ್ನಾಳ್ ಅವರೇ, ರಾಜ್ಯದ ಇಂಡಿಯನ್ ಮೆಡಿಕಲ್ ಅಸೋಸಿಯೇಷನ್ನ ಅಧ್ಯಕ್ಷರಾಗಿರ್ತಕ್ಕಂಥ ನಮ್ಮ ಭಾಗದವರೇ ಆದ ಡಾಕ್ಟರ್ VV ಚಿನಿವಾಲ್ರವರೇ, ಕರ್ನಾಟಕ ಮೆಡಿಕಲ್ ಕೌನ್ಸಿಲ್ನ ಅಧ್ಯಕ್ಷರು ಆತ್ಮೀಯರು ಆದ ಡಾಕ್ಟರ್ ಯೋಗಾನಂದ ರೆಡ್ಡಿ ಅವರೇ, KH ಪಾಟೀಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಮೆಡಿಕಲ್ ಸೈನ್ಸ್ ನಿರ್ದೇಶಕರು ಆತ್ಮೀಯರು ಆದ ಡಾಕ್ಟರ್ ಬಸವರಾಜ್ ಬೊಮ್ಮನಹಳ್ಳಿ ಅವರೇ, ಈ ಕಾರ್ಯಕ್ರಮ ಏರ್ಪಾಟಾಗೋದಕ್ಕೆ ವಿಶೇಷ ಮುತುವರ್ಜಿ ವಹಿಸಿರ್ತಕ್ಕಂಥ ಗೆಳೆಯ ಡಾಕ್ಟರ್ ಪವನ್ ಪಾಟೀಲ್ರೆ, ಸಹೋದರಿ ಡಾಕ್ಟರ್ ರಾಧಿಕಾ ಕುಲಕರ್ಣಿ ಅವರೇ, ಕಾರ್ಯದರ್ಶಿಗಳಾದ ಸುರಿರಾಜು ಅವರೇ, ಡಾಕ್ಟರ್ ಆರ್ಗನೈಸಿಂಗ್ ಸೆಕ್ರೆಟರಿ ಆದ ಡಾಕ್ಟರ್ ಅರವಿಂದ್ ಕರಿನಾಗಣ್ಣ ಅವರವರೇ, ತುಕಾರಾಮ್ ಅವರೇ, ಡಾಕ್ಟರ್ ಸುಮೋರೇಕರ್ ಅವರೇ, ಇಂಡಿಯನ್ ಮೆಡಿಕೋ ಲೀಗಲ್ ಸ್ಟೇಟ್ ಕಾನ್ಫರೆನ್ಸ್ ಮಾಡುವಾಗ ನಾವಷ್ಟೇ ರಾಜಕಾರಣಿಗಳು ವೈದ್ಯರು ಮಾತ್ರ ಇಲ್ಲಿರೋದಕ್ಕೆ ಸಾಧ್ಯ ಆಗೋದಿಲ್ಲ. ಹಿರಿಯರಾದ ಡಾಕ್ಟರ್ ಆಲೂರ್ ಅವರು ಹಾಗೂ ಅನೇಕ ಗಣ್ಯರು ವೇದಿಕೆ ಮೇಲೆ ಇದ್ದಾರೆ. ಲೀಗಲ್ ಲೆಮಿನರಿ ಅಂತ ಹೇಳಿನ ರಾಜ್ಯ ಸರ್ಕಾರ, ರಾಜ್ಯ ಕೂಡೇ ಗುರುತಿಸಿರುವಂತ ಜೋಗೇರಾವ್ ಅವರು ಇಲ್ಲೇ ನಮ್ಮ ಜೊತೆಗಿದ್ದಾರೆ. ನಾನು ಪವನ್ ಪಾಟೀಲ್ರಿಗೆ, ಬೊಮ್ಮನಹಳ್ಳಿ ಅವ್ರಿಗೆ ವಿನಂತಿ ಮಾಡ್ತೀನಿ, ಜೋಗೇರಾವ್ ಅವರು ವೇದಿಕೆ ಮೇಲೆ ಬಂದ್ರೆ ನಿಮ್ಮ ಮೆಡಿಕೋ ಕಾನ್ಫರೆನ್ಸ್ ಇದು ಖರೆ, ಮೆಡಿಕೋ ಲೀಗಲ್ ಪೂರ್ಣ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಜೋಗೇರಾವ್ ಅವರು ವೇದಿಕೆ ಮೇಲೆ ಬರ್ಬೇಕು. ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ ನೋಡಿ ಅವ್ರನ್ನ ಕರೆತರಬೇಕು ಅಂತ ಹೇಳಿ ನಾನು ವಿನಂತಿ ಮಾಡ್ತೇನೆ. ನಮ್ಮ ಜೊತೆಗೆ ಹಿರಿಯ ವೈದ್ಯರುಗಳಾದ ಡಾಕ್ಟರ್ ನೂರಾನಿ ಇದ್ದಾರೆ, ಡಾಕ್ಟರ್ ನಾಗನೂರ್ ಅವರು ಇದ್ದಾರೆ, ನಮ್ಮ ಪಂಚ ಗ್ಯಾರಂಟಿ ಸಮಿತಿಯ ಅಧ್ಯಕ್ಷರಾದ ಅಸೂಟಿ ಅವರಿದ್ದಾರೆ, ನಮ್ಮ ಗದಗ್ ನಗರಾಭಿವೃದ್ಧಿ ಅಧ್ಯಕ್ಷರಾದ ಮಾನ್ಯ ಬಬರ್ಚಿ ಅವರಿದ್ದಾರೆ. ನೆರೆದಿರ್ತಕ್ಕಂಥ ಎಲ್ಲ ವೈದ್ಯರುಗಳೇ, ಈ ಮಹಾವಿದ್ಯಾಲಯದಲ್ಲಿ ವಿದ್ಯಾರ್ಜನೆ ಮಾಡ್ತಕ್ಕಂಥ ಯಾವತ್ತು ಸಹೋದರ ಸಹೋದರಿಯರೇ, ನನಗೆ 2 ಆಪ್ಷನ್ ಅದಾವು. ನಾನು ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಬಿಡ್ನಾಳ್ ಅವರ ಕ್ಲೂ ತಗೊಂಡೆ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಸ್ಪೀಕ್ ಇನ್ ಇಂಗ್ಲಿಷ್. ಚಿನ್ವಾಲ್ ಅವರಿಂದ ಪ್ರೇರಣೆ ಪಡ್ಕೊಂಡೆ ಅಂದ್ರೆ ಐ ಕ್ಯಾನ್ ಸ್ಪೀಕ್ ಇನ್ ಕನ್ನಡ ಆಲ್ಸೋ. 2 ಆಪ್ಷನ್ ಅದಾವು. ಆದ್ರೆ ಈ ಒಂದು ಕಾನ್ಫರೆನ್ಸ್ ಮೆಡಿಕೋ ಲೀಗಲ್ ಕಾನ್ಫರೆನ್ಸ್ ಆಗಿರೋದ್ರಿಂದ ಬಹಳಷ್ಟು ಶಬ್ದಗಳನ್ನ ನಾವು ಇಂಗ್ಲಿಷ್ ಬಳಕೆ ಮಾಡಬೇಕಾಗ್ತದೆ. ಆ ಹಿನ್ನೆಲೆಯೊಳಗ ನಾನು ನಮ್ಮ ಮುಖ್ಯ ಅತಿಥಿಗಳು ಸಹಿತ, though he is from Hyderabad, I was told by Dr. Chinwala that you have studied in Gulbarga. Then at least you have studied, you understand Hyderabadi Karnataka's Kannada also. But however, I may be permitted to mix the language. Nothing like mixopathy, but you can take it for convenience we do. Friends, the theme is safeguarding ourselves while saving patients. Very important theme. The theme which is to be discussed, deliberated, in depth and seriously, forgetting for a while self-interest. Appropriately, timely, the IMA Gadag has created this forum, organized this conference, for which I compliment the IMA President Pavan and the other office bearers and IMA Gadag. Friends, you all know, and we do speak, not just in Gadag or in these colleges or with doctors. In whole of India, we speak of, I quote, Vaidyo Narayano Hari, meaning doctor is embodiment of God. Of course, you all are. Doctors play an important role in building a healthy society and productive nation. We use this phrase often used to express gratitude, respect for doctors and medical profession. And is sometimes in your own hospital, you display this just to make people understand. You display this in your hospitals, clinics, medical institutions as a reminder to those who are the patients or their guardians, as a reminder, of course, to this noble nature of the work of a doctor. We all have heard pro bono publico commitment. That is more seen, that is to be more seen also in this medical service. Friends, traditionally doctors practice medicine as service. There was a pro bono publico commitment in the profession. Even if it was there, even if it was their means of livelihood, it was the means of doctors of livelihood. There was no commercial angle in it earlier. That was the prime reason because of which doctors had hallowed place in the society. Medical profession is an autonomous profession. It has constitutionally conferred autonomy and monopoly on medical profession. The legal system has ordained that only doctors on the rolls of medical council can practice medicine and no one else. Only those who are on the rolls of medical council can practice medicine and no one else. It is there in the law book, rule book, but not practiced. We have a system of quacks. We have system of different degree holders in various practices of medicine and allopathy. But one practices the other medicine, which is also a matter of concern, as Dr. Banshali has already expressed. However, the profession is expected to evolve its own code of ethics and retain the trust of society. In earlier days, as doctors were strictly adhering to the professional ethics and law, the courts did not interfere in professional matters. Doctors are often revered as selfless healers who dedicate their lives to the well-being of others. Their commitment to patient care is unquestionable, especially in times of crisis such as pandemics, natural disaster, or war. It is a profession pursued for others, not for self. But however, in the changed circumstances, you're brought under a lot of legal framework. Many of the doctors may not be very much acquainted. How many laws govern them? It is not 1, 2, 3, 4. It is not dozen. It is more than dozen. About 16, 17 laws govern them. They are there to protect them. They are there, those laws are there to regulate them. There are laws to punish them. There are laws which will prevent any wrong happening on these professions. There are 16, 17 laws, 11 of central acts, 5 of Karnataka state acts, and 1 or 2 which are also concerned to you, like Fire Service Act, etc. Friends, the state has power to evolve an appropriate legal framework for guaranteeing this act. You all know, right to health is a human right, and it is fundamental right. The Constitution of India has made health as a right, fundamental right. Right of life under Article 21 includes right to health and medical care. Article 39, 41, 47 of the Directive Principles of the State Policy oblige the state to provide public health and protect workers' health. Access to medical service is an essential component of this right. The state has power to evolve an appropriate legal framework for guaranteeing this right. More so, when the profession deviates from its own professional ethics. The legal regime applicable to the medical profession in India is governed by a combination of statutes, regulations, judicial precedents, and professional ethical guidelines. Just to refresh your memory and to communicate to those who are not medical people here, the Indian Medical Council Act 1956, which is of course now repealed, which established the Medical Council of India, which is now replaced in place of Indian Medical Council Act. National Medical Commission Act 2019, it is replaced by Medical Council of India with National Medical Commission NMC Act. This body regulates medical education and institutions, professional standards, ethics, and conduct, licensure, and registration. Clinical Establishment Act, which is the Registration cum Regulation Act 2010, Drug and Cosmetics Act 1940, Consumer Protection Act 2019, Indian Medical Council Professional Conduct, Etiquettes, and Ethics Regulations. Here, I wish all professionals remember that it is not just ethics, your etiquettes are also summarized in the Act. The Transplantation of Human Organs and Tissues Act 1994 regulates organ donation and transplantation, of course, of which the President of National President of IMA did mention on this. The Preconception and Prenatal Diagnostic Techniques Act 1994, which prohibits sex selection and regulates prenatal diagnostic techniques. Mental Health Care Act of 2017, which ensures rights based on mental health care. Biomedical Waste Management Rules 2016 regulates disposal of medical waste. The Epidemic Diseases Act 1897 and Disaster Management Act 2005, which were invoked during health emergencies like COVID, etc. These are all central acts. If you come to Karnataka, in addition to these, we have Karnataka Medical Registration Act 1961, Karnataka Ayurvedic, Naturopathy, Siddha, Unani, Yoga Practitioners Registration and Medical Practitioners Miscellaneous Provisions Act 1961, Karnataka Private Medical Establishment Act 2007, Karnataka Medical Registration and Certain Other Law Amendment Act 2024. Friends, you all know much about this act. You have discussed about this act. For the information of National President and those who are outsiders of Gadag, if this amendment has come, it is because of IMA, the great initiation, IMA Gadag particularly, and great initiation taken by Yoganand Reddy, Dr. Nagnur, Dr. Nurani, Dr. Kuradigi, Dr. Pavan. All these are the people who were responsible for amendment of this. It may not be fair on my part if I say that the government of Karnataka or the legislature of Karnataka has made all the amendments. We've only given our seal. Whatever amendments are done, it is at the instance of all these people and Gadag IMA and the state IMA. The Karnataka legislature, the Karnataka government has given its seal. Of course, we appreciated the concern. We were very keen that that type of society should emerge, and almost recommendations, except those where technically things were not done, are accepted. That's why I was wondering, when National President made a suggestion that we should include something, I wanted to tell National President that if there is any lapse or any lacuna or any shortcoming is there in this amendment, don't blame Government of Karnataka. It is your colleagues which are to be blamed. That is why with that intent, the whole amendment was done. And you all will be very happy to know that the Karnataka Prohibition of Violence Against Medicare Service Personnel and Damage to Property in Medicare Service Institution Act 2024 again was a desire of all medicos that this type of prevention or prohibition of violence should be there. Otherwise, we all will get disturbed. And that law is also now brought into being, and it is now implemented. Apart from that, if National President or State President, Mr. Chinwala, or KMC President, Mr. Yoganand Reddy, if there is anything that can be done at the government level in making law or making any change or amendment in the system that is to be brought, Government of Karnataka is of open mind. Yoganand Reddy and Chinwala were talking to me about firefighter services and some professional or administrative problems. Let me assure them that you write to me, I will call you in less than 2 months. Whatever modifications to be done, whatever will be reasonable, the government of Karnataka will take up those. In addition, there are guidelines evolved by judiciary in relation to medical negligence. Of course, if you allow Jogirao to express, not necessarily in moot court, even to advise you people, he will tell what is the intent of judiciary to give a lot of guidance. You will be knowing it. And particularly the court has taken a strong view on medical negligence, informed consent, right to die with dignity, etc., are the provisions imposing criminal liability on doctors and principles where doctors can be saddled with civil liability. Friends, there is a changed scenario. Now, go anywhere, people will be thinking when the patient becomes very, very serious, the guardians of the patient attenders, patient relatives will start feeling, what should we do? How can we sue doctor? How can we get compensation? The patients and the relatives have developed a sort of consumer-like mindset. The fiduciary relationship between the doctor and patient has lost its sanctity for various reasons. Already the speakers, including National President, has made that point. Chinwala also made that point, that sadbhavana between the patient and the doctor, that is missing, that is going down. Medical service has to adhere to the expected levels of ethics in practice. When we drift from ideal ethical standard to the permissible, from permissible to unacceptable, law steps in and starts watching. Medical profession also has to follow a legal framework. You can't be let totally free. Everyone in the country, including President of India, they are under the legal frame. And you all will also have to undergo legal framework. When there's a deviation from ethical practice, of course, the law steps in. There should be ethical and rule-abiding senior doctors who will be role models. There should be ethical and rule-abiding senior doctors who should be and will be role models to all of us. We should iconic professionals whom every young doctor will aspire to emulate. In recent years, there is a slow shift in the status of healthcare professionals from once revered healers in a noble profession to a vastly different scenario where they are assaulted and not trusted. This is an issue that deserves spotlight. Doctors are dragged into unnecessary litigation. Often they become victims of extortion by pressure groups and anti-social elements. Sometimes the astronomical compensation awarded by the courts produce chilling effects on the professionals. Of course, that perhaps has made you to have a moot court on a very exemplary or astronomical compensation which Jogerao was pleading to be levied in a moot court. Anyway, friends, doctors are human beings, susceptible and vulnerable as anyone else. The ideal of complete self-sacrifice can be both unrealistic and harmful. In truth, doctors must also prioritize their own physical and mental health. Then only they can continue to serve others effectively. The balance between caregiving and self-preservation is not just a personal necessity for doctors, it is a professional responsibility. It is the responsibility of the state also. If doctors do not take care of themselves and the state fails to take care of them, the entire healthcare system becomes more fragile. The best way to empower healthcare workers is to educate them about the legal system, including their rights, responsibilities, and protections. Lack of awareness results in fear and ignorance. Of course, it was mentioned in the speeches earlier that ignorance of law will not take you for innocence. It will not pardon. Nobody will pardon. Law will not pardon you because of your ignorance, limiting their practices, which is not good for all stakeholders. If doctors can be acquainted with the requirement of law, they can comply with them and create a conducive environment for themselves to better perform on professional front. For this reason, I compliment all the organizers for choosing the theme which deserves immediate attention and focused sub-themes of contemporary relevance. The theme, safeguarding ourselves while saving patients. Friends, it may not be out of place if I am trying to be little frank. The professionals where we speak in law books about the ethics and etiquettes. In very few laws, I don't know whether there is anything other than this Medico practitioners' laws, anything about etiquettes. I don't think that is there in engineers' protection law. I don't think it will be there in other laws. But here, the etiquette is also given the prime importance. Unfortunately, the profession has started talking of corporate thinking. You all have started moving from your practices, your clinics, your hospitals to corporate bodies, or convert your groups into corporate bodies. What is, after all, the motto of corporate body? Corporate body's watchword is profit. Then comes the service. Unfortunately, you're moving towards corporate bodies where they have their watchword of profit. Then how will you expect you to be embodiment of God? Why should people call you Vaidyo Narayana? This is all the introspection also that one should do. Move towards ethical corporate, where motive should be service, and secondarily the profit. I told in my earlier speech that we should protect you, we should encourage you, we should make you strong also. Not that ನೀವೆಲ್ಲರೂ ಸನ್ಯಾಸಿ ಆಗ್ರಿ, ಸುಮ್ಮನೆ ಎಲ್ಲ ಕೆಲಸ ಮಾಡ್ರಿ. No, that is not the message that anybody can give. My request to you is, don't move towards the philosophy of corporate world. Your watchword should be service. Friends, I also feel that we train, I would like to tell Dr. Bomnalli that we teach medical science. I don't think all these 16, 17 laws I have quoted are made to be acquainted to your students. All these laws to be taught to them. Make it like a syllabus. It should be included in a curriculum. It can be like one paper also, wherein you can give 20 marks, 30 marks. Because ultimately it is that which will protect them. It is that which will make them feel secured. I would only urge upon you to take up. And Yoganand Reddy is also a member of the syndicate. He can think of moving it in the academic council and the syndicate to get this included in the curriculum, or have one paper for that, so that the boys, girls who are getting prepared for medical practice, they will feel secure, they will get protected, and they will also know what are the rules that are regulating them. Friends, before I close, I am deeply impressed by the Dr. Dilip Bansali's speech and also Chinwala's speech. Our Bidnar made my job very easy by giving him details of Gadag and Gadag district. In fact, I was duty bound to be here yesterday to welcome all of you for this conference. Though I am a President Pawan, Kurdigi, Nurani, Dr. Nagnur, all requested me to be here, but it was not possible because of my earlier commitment at Gulbarga. Hope you will pardon me. And I was very happy that Bidnar took national president of the IMA to our Gandhi Ashram. And he was very much pleased. ನಾನು ತಮಗೆ ಹೇಳೋದಾದ್ರೆ, ನಮ್ಮ ಭಾಗಕ್ಕೆ ಬಂದಂತ, ಅದರಲ್ಲೂ ಮೆಡಿಕಲ್ ಕಾಲೇಜ್ಗೆ ಏನು ಬೊಮ್ಮನಹಳ್ಳಿಯವರು, IMAದವರು ಈ ಕಾನ್ಫರೆನ್ಸ್ಗಳನ್ನ ನೋಡ್ತಾರೆ, ಅವರೆಲ್ಲರೂ ನಮ್ಮ ಅಭಿವೃದ್ಧಿಯನ್ನ, ನಮ್ಮ ಪ್ರಗತಿಯನ್ನ, ನಮ್ಮ ಬೆಳವಣಿಗೆಯನ್ನ, ನಮ್ಮ ಆಲೋಚನಾ ಪ್ರಕ್ರಿಯೆಯನ್ನ ಬಹಳ ಗಂಭೀರವಾಗಿ ಗಮನಿಸಿದ್ದಾರೆ. ಅವರ ಬರುವಿಕೆ ನಮಗೆ ಬೇರೆ ಬೇರೆ ರೀತಿಯಿಂದ ಬೇರೆ ಬೇರೆ ಪ್ರದೇಶಗಳಲ್ಲಿ, ಬೆಂಗಳೂರಲ್ಲಿ ಮತ್ತೊಂದು ಕಡೆ ಬಹಳ ದೊಡ್ಡದಾಗಿರ್ತಕ್ಕಂಥ ಒಂದು ಎನ್ಕರೇಜ್ಮೆಂಟ್ ಅನ್ನ, ಪ್ರೋತ್ಸಾಹವನ್ನ ಕೊಟ್ಟಾಗ ಆಗಿದೆ. ಈ ಒಂದು ಕಾನ್ಫರೆನ್ಸ್ ಬಹಳ ಯಶಸ್ವಿ ಆಗಿ ನಡೆದಿದೆ ಅನ್ನೋದನ್ನ ಕೇಳಿದೆ. ಇದರಿಂದ ಅಷ್ಟೇ ಉಪಯುಕ್ತವಾಗಿರ್ತಕ್ಕಂಥದ್ದು ಮಾಹಿತಿಗಳು, ವಿಷಯಗಳು, ವಿಚಾರಗಳು. ಯಾಕಂದ್ರೆ 450 ಜನ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೀರಿ, 100ಕ್ಕಿಂತ ಹೆಚ್ಚು ಜನ ವರ್ಚುವಲ್ ಆಗಿ ತಾವು ಈ ಕಾನ್ಫರೆನ್ಸ್ ಅನ್ನ ಗಮನಿಸ್ತಾ ಇದ್ದೀರಿ. ನಿಮ್ಮೆಲ್ಲರಿಗೆ ನನ್ನ ಶುಭಾಶಯಗಳನ್ನ ಕೋರ್ತಾ, ಮತ್ತೊಮ್ಮೆ ವೈದ್ಯೋ ನಾರಾಯಣೋ ಹರಿ, ಈ ಮಾತು, ಈ ಒಂದು ವಾಕ್ಯ ವಿಶೇಷ ಘನತೆಯನ್ನ ಪಡೆಯುವ ಹಾಗೆ ನಮ್ಮ ವೈದ್ಯರುಗಳ ಸೇವೆ ನಮ್ಮೆಲ್ಲರಿಗೆ ಲಭಿಸ್ಲಿ ಅಂತ ಹಾರೈಸಿ ನಾನು ಮಾತು ಮುಗಿಸ್ತೀನಿ.
ಧನ್ಯವಾದಗಳು ಸರ್. ವೈದ್ಯ ರೋಗಿಯ ಸಂಬಂಧ ಸೇವೆಯ ಪ್ರಥಮ ಪ್ರಾಶಸ್ತ್ಯ ಬಗ್ಗೆ ಮಾತನಾಡಿದ ಸನ್ಮಾನ್ಯ ಸಚಿವರಿಗೆ ಧನ್ಯವಾದಗಳು. And sir spoke like not like a politician, but like a resource person of a scientific session, mentioning the laws, legalities, and also about the ethics and etiquettes. Thank you, sir, for reminding us of the ethics and the etiquettes. He spoke about and he mentioned about many articles, laws, extempore, and he has assured us of a meeting about the administrative problems we are facing. Thank you, sir. And he's also given us about clues and guidance about the changing scenarios, which is like in America and all ambulance chasers. We hope it do not come to India, but he has asked us to be prepared. And thank you, sir, for all your inputs and advices. ಧನ್ಯವಾದಗಳು ಸರ್. ಸರ್ಗೆ ಇನ್ನೊಂದು ಸಾರಿ ಎಲ್ಲರೂ ಚಪ್ಪಾಳೆ ಮೂಲಕ ಧನ್ಯವಾದ ಕೇಳ್ತೇನೆ. ಹಾಗೆಯೇ ನಮ್ಮ ಮುಖ್ಯ ಅತಿಥಿಯಾಗಿ ಹಾಗೂ ಮುಖ್ಯ ರಿಸೋರ್ಸ್ ಪರ್ಸನ್ ಆಗಿ ಬಂದಿರುವಂತಹ ಮಿಸ್ಟರ್ ಜೋಗಾರಾವ್ ಸರ್ ಅವರು 2 ನಿಮಿಷ ನಮ್ಮೆಲ್ಲರನ್ನು ಉದ್ದೇಶಿಸಿ ಮಾತಾಡಲು ಈ ಮೂಲಕ ಕೇಳಿಕೊಳ್ಳುತ್ತೇನೆ.
Dignitaries on the dais and other friends. I just want to share one thing what I have learned from my short interaction or association with Honorable Minister for Law. His commitment towards the post what he is holding, particularly the subject matter, is something unique and unbelievable. For instance, when Indian Penal Code, CRPC Evidence Act amendments have taken place, Honorable Home Minister of Central Government wrote a letter to all the state governments, particularly Karnataka. Immediately, Honorable Minister has taken the initiative in constituting an expert committee, and accordingly, the recommendations from the Karnataka government have been placed before the central government. The kind of interest he has taken, he has attended a couple of meetings. One more thing. As a law minister, what he has introduced just 3 months back, I have never heard in my maybe 50 years of professional life. In the debut meeting, he addressed the gathering, some invitees. He said, law ministry is endowed with the responsibility of drafting legislative bills. But on what subject matter the government has to initiate the process? Normally, government only decides. He posed a question, why government has to decide? You are all the stakeholders, right? Why don't you come and tell us what subject matter it can be? And accordingly, he constituted 10 committees. And in all probability, within 3 to 6 months, almost 10, each committee 10, which means around 80 to 100 legislative draft bills will be ready for the consideration of the concerned ministry officials. This kind of unique initiative I have never come across. And I am telling you, I am fortunate enough to be a part of that particular. And in that regard, already I have submitted 3 propositions which revolve around healthcare, law and ethics, on which we propose to draft the bills. This is what I thought is the befitting tribute to the kind of work he does. For me personally, I never felt that he is a politician, basically. He is such a humble and knowledgeable person, the way he interacts. My visit to Sabarmati just 2 hours back. I request every one of you, time permits, please visit. Otherwise, please come back to Gadag and visit that university. Thank you so much.
Thank you, sir. It's our honor to felicitate today's chief guest, our own Honorable Minister for Law and Tourism Department, Shri H.K. Patil Sirji.
Request all the dignitaries to join for the felicitation. ಕಾನೂನು ಮತ್ತು ಸಂಸದೀಯ ವ್ಯವಹಾರಗಳ ಸಚಿವರು, ಪ್ರವಾಸೋದ್ಯಮ ಇಲಾಖೆ ಸಚಿವರು, ಕರ್ನಾಟಕ ಘನ ಸರ್ಕಾರ, ಗದಗ ಜಿಲ್ಲಾ ಉಸ್ತುವಾರಿ ಸಚಿವರು ಹಾಗೂ ಈ ನಮ್ಮ ಭಾಗದ ಅಭಿವೃದ್ಧಿಗೆ ಅವಿರತ ಶ್ರಮಿಸುವಂತ ನಾಯಕರು, ಅವರಿಗೆ ಈ ಒಂದು ಸನ್ಮಾನ ಮಾಡುವುದು ನಮಗೆ ಒಂದು ಹೆಮ್ಮೆಯ ಸಂಗತಿಯಾಗಿದೆ. ಅವರಿಗೆ ಈ ಗದಗ IMA ವತಿಯಿಂದ, ಕರ್ನಾಟಕ IMA ವತಿಯಿಂದ ಹಾಗೂ ಈ ಸಂಸ್ಥೆ ವತಿಯಿಂದ ನಮ್ಮ ಹೃತ್ಪೂರ್ವಕ ಧನ್ಯವಾದಗಳನ್ನು ಈ ಮೂಲಕ ಅರ್ಪಿಸುತ್ತಾ ಇದ್ದೇವೆ. It's our turn to felicitate President, National IMA, Dr. Dilip Bhanushali, sir. I request our dignitary to felicitate, sir. Next, I request and welcome President, Karnataka Medical Council, Dr. Yoganand Reddy, sir. Next, Dr. Chinivalar, sir, IMA, Karnataka State Branch President. Thank you, sir, for receiving the honors. And I also request National Vice President, our own Dr. G.B. Bidnal, sir, to accept our gratitude. And I also request Dr. Pawan Patil, sir, to felicitate our main resource person, Dr. Jogarao, sir. He's been of immense help and full of resources. Mr. Jogarao, sir, is a well-known name in both medical and legal fraternity, not only in Karnataka, all throughout India. Okay. It's a fortune that he has come to Gadag and is sharing his knowledge and experience with us all. I request the dignitaries to please be seated. And we call upon Dr. Arvind Karinagan, our Organizing Secretary, to deliver vote of thanks.
I request Dr. Anupama Patil, IMA Ladies Wing President, Gadag, and Dr. Shilpa Daduti, IMA Ladies Wing Secretary Gadag to give mementos to all the dignitaries on the stage.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಜೀವನದಲ್ಲಿ ಗುರಿ ಇರಲಿ, ಗುರಿ ತಲುಪುವ ಮನ ಇರಲಿ, ಮನದ ಜೊತೆ ಛಲ ಇರಲಿ, ಛಲದ ಜೊತೆ ಗುರುವಿನ ಆಶೀರ್ವಾದವಿರಲಿ, ಗುರಿ ತಲುಪಿದ ನಂತರ ಗುರುವಿನ ನೆನಪು ಸದಾ ಇರಲಿ. ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದ ಮುಖ್ಯ ಅತಿಥಿಗಳಾಗಿ ಹಾಗೂ ಉದ್ಘಾಟಕರಾಗಿ ಆಗಮಿಸಿದ ಸನ್ಮಾನ್ಯ ಡಾಕ್ಟರ್ HK ಪಾಟೀಲ್ ಸರ್, ಕಾನೂನು, ನ್ಯಾಯ, ಮಾನವ ಹಕ್ಕುಗಳು, ಸಂಸದೀಯ ವ್ಯವಹಾರಗಳು ಮತ್ತು ಶಾಸನ ರಚನೆ ಹಾಗೂ ಪ್ರವಾಸೋದ್ಯಮ ಸಚಿವರು ಮತ್ತು ಗದಗ್ ಜಿಲ್ಲಾ ಉಸ್ತುವಾರಿ ಸಚಿವರು. ಸನ್ಮಾನ್ಯರೇ, ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಒಂದು ಮಾತಿದೆ, ಎ ಪರ್ಸನ್ ಹೂ ಲಿವ್ ಫಾರ್ ಹಿಮ್ಸೆಲ್ಫ್ ವಾಸ್ ನಾಟ್ ರಿಮೆಂಬರ್ಡ್ ಬೈ ದ ವರ್ಲ್ಡ್, ದ ಪರ್ಸನ್ ಹೂ ಲಿವ್ಡ್ ಫಾರ್ ಅದರ್ಸ್ ವಾಸ್ ನಾಟ್ ಫಾರ್ಗಟನ್ ಬೈ ದ ವರ್ಲ್ಡ್. ಈ ಮಾತಿನಂತೆ ತಾವುಗಳು ಹಾಗೂ ತಮ್ಮ ಕುಟುಂಬದವರು ನಮ್ಮ ಸಂಸ್ಥೆಗೆ ಹಾಗೂ ಗದಗ್ ಜನತೆಗೆ ಹಲವಾರು ಮಹತ್ತರ ಕಾರ್ಯಗಳನ್ನ ಮಾಡಿದ್ದೀರಿ. ತಾವುಗಳು ಒಬ್ಬ ವಿಷನರಿ ಲೀಡರ್ ಆಗಿದ್ದು ನಿಮ್ಮನ್ನ ನಾಯಕರನ್ನಾಗಿ ಪಡೆದ ನಾವೇ ಧನ್ಯರು. ತಮ್ಮ ಬಿಡುವಿಲ್ಲದ ಸಮಯದಲ್ಲೂ ನಮ್ಮ ಕರೆಗೆ ಹೋಗೊಟ್ಟು ಈ ಕಾರ್ಯಕ್ರಮವನ್ನ ಯಶಸ್ವಿಗೊಳಿಸಿದ್ದಕ್ಕೆ ನಿಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಅನಂತ ಕೋಟಿ ಧನ್ಯವಾದಗಳು ಸರ್. ಈ ಕಾರ್ಯಕ್ರಮದ ಗೌರವ ಅತಿಥಿಗಳಾಗಿ ದೂರದ ಊರಿಂದ ಗದಗ್ಗೆ ಆಗಮಿಸಿದ IMA ಸಂಘದ ರಾಷ್ಟ್ರೀಯ ಅಧ್ಯಕ್ಷರಾದ ಡಾಕ್ಟರ್ ದಿಲೀಪ್ P ಭಾನುಸಾಲಿ ಸರ್ ಅವರಿಗೆ ನಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಅನಂತ ಧನ್ಯವಾದಗಳು ಸರ್. ನಿಮ್ಮ ಉಪಸ್ಥಿತಿ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಇನ್ನೂ ಹೆಚ್ಚಿನ ಶೋಭೆಯನ್ನ ತಂದಿದೆ. ಅದರಂತೆ ಇನ್ನೋರ್ವ ಗೌರವ ಅತಿಥಿಗಳಾದ IMA ಸಂಘದ ರಾಷ್ಟ್ರೀಯ ಅಧ್ಯಕ್ಷರನ್ನ ಗದಗೆ ಕರೆತರುವಲ್ಲಿ ಯಶಸ್ವಿಯಾದ ನಮ್ಮವರೇ ಆದ ಡಾಕ್ಟರ್ GB ಬಿಡ್ನಾಳ್ ಸರ್, IMA ಸಂಘದ ರಾಷ್ಟ್ರೀಯ ಉಪಾಧ್ಯಕ್ಷರು ಹಾಗೂ ಕನ್ನಡ ರಾಜ್ಯೋತ್ಸವ ಪ್ರಶಸ್ತಿ ಪುರಸ್ಕೃತರು, ಇವರಿಗೆ ನಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಅನಂತ ಧನ್ಯವಾದಗಳು. ಅದರಂತೆ ಇನ್ನೋರ್ವ ಗೌರವ ಅತಿಥಿಗಳಾದ ನಮ್ಮವರೇ ಆದ IMA ರಾಜ್ಯಾಧ್ಯಕ್ಷರು ಡಾಕ್ಟರ್ VV ಚಿನ್ಲವಾಲರ್ ಸರ್ ಅವರಿಗೆ ನಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಅನಂತ ಧನ್ಯವಾದಗಳು. ಹಾಗೆ ಈ ಸಮಾರಂಭದ ಮತ್ತೋರ್ವ ಗೌರವ ಅತಿಥಿಗಳಾದ KMCಯ ಅಧ್ಯಕ್ಷರು, ಅತ್ಯುತ್ತಮ ವಾಗ್ಮಿಗಳು ಹಾಗೂ ವೈದ್ಯರ ಪರ ಅಪಾರ ಕಾಳಜಿ ಹೊಂದಿದ ನಮ್ಮವರೇ ಆದ ಡಾಕ್ಟರ್ ಯೋಗಾನಂದ ರೆಡ್ಡಿ ಸರ್ ಅವರಿಗೆ ನಿಮ್ಮೆಲ್ಲ ಪರವಾಗಿ ಅನಂತ ಧನ್ಯವಾದಗಳು. ಅದರಂತೆ ಗದಗ್ನಲ್ಲಿ ಯಾವುದೇ ಕಾರ್ಯಕ್ರಮ ಆಯೋಜಿಸಲು ನಮ್ಮೆಲ್ಲರ ಮೊದಲ ಆಯ್ಕೆ ನಮ್ಮ ಹೆಮ್ಮೆಯ KH ಪಾಟೀಲ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಮೆಡಿಕಲ್ ಸೈನ್ಸಸ್. ಸದರಿ ಸಂಸ್ಥೆಯ ನಿರ್ದೇಶಕರಾದ ಡಾಕ್ಟರ್ ಬಸವರಾಜ್ P ಬಮ್ನಳ್ಳಿ ಸರ್, ತಾವುಗಳು ಸಮಾರಂಭಕ್ಕೆ ನೀಡಿದ ಎಲ್ಲ ಸಹಾಯಕ್ಕೂ ಸಲಹೆಗಳಿಗೂ ನಿಮ್ಮೆಲ್ಲ ಪರವಾಗಿ ಅನಂತ ಧನ್ಯವಾದಗಳು ಸರ್. ಈ ಸಮ್ಮೇಳನಕ್ಕೆ ನಾವೆಲ್ಲ ನಿಮಿತ್ತ ಮಾತ್ರ. ಸಮ್ಮೇಳನದ ಬೆನ್ನೆಲುಬು ಹಾಗೂ ಆಧಾರ ಸ್ತಂಭವಾಗಿರೋರು ಒಬ್ಬರೇ. ತ್ರೇತಾಯುಗದಲ್ಲಿ ಲಕ್ಷ್ಮಣನನ್ನ ಕಾಪಾಡಲು ಅಂದು ಪವನಪುತ್ರ ಹನುಮಂತ ಹೇಗೆ ಸಂಜೀವಿನಿ ಪರ್ವತನ ಹೊತ್ತು ತಂದನು, ಅದೇ ರೀತಿ ನಮ್ಮ ಗದಗ್ನ ಡಾಕ್ಟರ್ ಪವನ್ ಪಾಟೀಲ್ IMA ಪ್ರೆಸಿಡೆಂಟ್ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಬೇಕಾದ ತನು ಮನ ಧನವನ್ನ ಎಲ್ಲವನ್ನ ಧಾರೆರಿದ್ದಾರೆ. ಸರ್, ನಿಮಗೆ ನೀವೇ ಸಾಟಿ. ನಿಮ್ಮ ಕಾರ್ಯಕ್ಕೆ ನಮ್ಮೆಲ್ಲರ ಪರವಾಗಿ ಅನಂತ ಧನ್ಯವಾದಗಳು ಸರ್. ಡಾಕ್ಟರ್ ವೀರಭದ್ರಯ್ಯ ಸರ್, ಪ್ರೆಸಿಡೆಂಟ್ ಎಲೆಕ್ಟ್ IMA KSB ಸರ್, ತಮಗೂ ನಮ್ಮ ಪರವಾಗಿ ಅನಂತ ಧನ್ಯವಾದಗಳು ಸರ್. IMA ಕರ್ನಾಟಕದ ಮಾಜಿ ಅಧ್ಯಕ್ಷರುಗಳಾದ ನಮ್ಮ ಗದಗ್ನ ಡಾಕ್ಟರ್ BM ಆಲೂರ್ ಸರ್, ಡಾಕ್ಟರ್ ರಾಜಶೇಖರ್ ಬಳ್ಳಾರಿ ಸರ್, ಡಾಕ್ಟರ್ ಶಿವಕುಮಾರ್ ಲಕ್ಕೋಳ್ ಸರ್, ಡಾಕ್ಟರ್ ಮಸೂದನ್ ಕಾರಿಗ್ನೂರ್ ಸರ್ ಹಾಗೂ ಡಾಕ್ಟರ್ ವೆಂಕಟಾಚಲಪತಿ ಸರ್ ಮತ್ತು ಡಾಕ್ಟರ್ ಅನ್ನದಾನಿ ಮೆಡ್ಡಿ ಸರ್ ಅವರಿಗೂ ಅನಂತ ಧನ್ಯವಾದಗಳು. ಹೆಣ್ಮಕ್ಳೇ ಸ್ಟ್ರಾಂಗ್ ಗುರು ಎನ್ನುವ ಹಾಗೆ IMA ಸಂಘದ ಯಾವುದೇ ಕಾರ್ಯಕ್ರಮಗಳಿಗೆ ಹಸಿರು ನಿಶಾನೆ ತೋರಿಸುವ ಈ ಸಮ್ಮೇಳನ ಅಧ್ಯಕ್ಷರಾದ ಡಾಕ್ಟರ್ ರಾಧಿಕಾ ಕುಲಕರ್ಣಿ ಮೇಡಮ್, IMA ಮೇಳ ಘಟಕದ ಅಧ್ಯಕ್ಷರಾದ ಡಾಕ್ಟರ್ ಅನುಪಮಾ ಮೇಡಮ್ ಹಾಗೂ ಸೆಕ್ರೆಟರಿ ಆದ ಡಾಕ್ಟರ್ ಶಿಲ್ಪಾ ದೊಡುತಿ ಅವರಿಗೂ ಅನಂತ ಧನ್ಯವಾದಗಳು. ಹಾಗೆ IMA ಗದಗ್ನ ಸೆಕ್ರೆಟರಿ ಆದ ಡಾಕ್ಟರ್ ತುಕಾರಾಮ್ ಸೂರಿ ಸರ್ ಅವರಿಗೂ, IMA ಗದಗ್ನ ಟ್ರೆಜರರ್ ಆದ ಡಾಕ್ಟರ್ ಭೀಮ್ ಸಿಂಗ್ ಸೋಮರೇಕರ್ ಅವರಿಗೂ ಈ ಸಮ್ಮೇಳನ ಪರವಾಗಿ ಅನಂತ ಧನ್ಯವಾದಗಳು. ಈ ಸಮ್ಮೇಳನಕ್ಕೆ ಹಗಲುಗಳು ಶ್ರಮಿಸಿದ ವಿವಿಧ ಕಮಿಟಿ ಎಲ್ಲ ಸದಸ್ಯರಿಗೂ, ಎಸ್ಪೆಷಲಿ ಚಂದ್ರಶೇಖರ್ ಬಳ್ಳಾರಿ ಸರ್, ರಾಧಿಕಾ ಬಳ್ಳಾರಿ ಮೇಡಮ್ ಹಾಗೂ ಶ್ವೇತಾ ಸಂಗ್ನೂರ್ ಮೇಡಮ್, ಶ್ರೀಧರ್ ಕೂಡ್ಗಿ ಸರ್, ಪ್ರಮೋದ್ ರಂಗಸುಬೆ, ಪ್ರತೀಕ್ ಖೋನ, ಜಮಾದರ್ ಸರ್, ಶಿಲ್ಪಾ ಹಾಗೂ ವಿನಾಯಕ್ ಸರ್ ಮತ್ತು ರಮೇಶ್ ಸರ್ ಅವರಿಗೆ ನಿಮ್ಮೆಲ್ಲ ಅನಂತ ಧನ್ಯವಾದಗಳು. ಎಲ್ಲರ ಹೆಸರನ್ನ ಸಮಯ ತಗೊಳಕ್ಕಾಗ್ತಾ ಇಲ್ಲ, ದಯವಿಟ್ಟು ನನ್ನ ಮೇಲೆ ಕ್ಷಮೆ ಇರಲಿ. ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಶ್ರಮಿಸಿದ ಎಲ್ಲಾ ಬೋಧಕೇತರ ಸಿಬ್ಬಂದಿಗಳಿಗೂ, ನಮ್ಮ ಪತ್ರಕರ್ತ ಮಿತ್ರರಿಗೂ, ನಮ್ಮ ಗದಗ್ನ ಎಲ್ಲಾ ವೈದ್ಯರಿಗೂ ಹಾಗೂ ನನ್ನ ನಮನಗಳು. ಕೊನೆಯದಾಗಿ ಈ ಸಮ್ಮೇಳನಕ್ಕೆ ರಾಜ್ಯದ ವಿವಿಧ ಜಿಲ್ಲೆಗಳಿಂದ ಆಗಮಿಸಿದ ನಮ್ಮ ಎಲ್ಲ ವೈದ್ಯರಿಗೂ ಹಾಗೂ ಈ ಸಮ್ಮೇಳನದ ಎಲ್ಲ ಗೆಸ್ಟ್ ಸ್ಪೀಕರ್ ಅವರಿಗೂ, ಮೂಡ್ ಕೋರ್ಟ್ ನಡೆಸಿಕೊಟ್ಟ ಡಾಕ್ಟರ್ ಜೋಗಾರಾವ್ ಸರ್ಗೂ ಹಾಗೂ ಅವರ ತಂಡದವರ ಎಲ್ಲ ವೈದ್ಯರಿಗೂ ಮತ್ತು ವಕೀಲರಿಗೂ ನಮ್ಮ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೂ ಸಹ ಅನಂತ ಧನ್ಯವಾದಗಳು. ಪ್ರತ್ಯಕ್ಷವಾಗಿ ಹಾಗೂ ಪರೋಕ್ಷವಾಗಿ ಈ ಸಮ್ಮೇಳನಕ್ಕೆ ಶ್ರಮಿಸಿದ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳನ್ನು ತಿಳಿಸುತ್ತಾ, ನಾನು ಯಾರಾದ ಹೆಸರನ್ನು ಮರೆತಿದ್ದರೆ ನನ್ನ ಮೇಲೆ ಕ್ಷಮೆ ಇರಲಿ ಎಂದು ಕೋರುತ್ತಾ ವಂದನಾರ್ಪಣೆ ಕಾರ್ಯಕ್ರಮ ಮುಗಿಸುತ್ತೇನೆ. ಜೈ ಹಿಂದ್, ಜೈ ಕರ್ನಾಟಕ, ಲಾಂಗ್ ಲಿವ್ IMA. ಧನ್ಯವಾದಗಳು.
Stand for national anthem now, please. Break for lunch, and after this there is one session, and after that panel discussion, and after that moot court. Now we all break for lunch break.
Hopefully everybody enjoyed our today's lunch. It was like delicious our side, local side, ulgi and chapati rice. And it caused little bit very drowsy now. I request everyone to please be a little bit aware for another one session. One scientific session is there. One topic followed by one moot court, and that will be followed by a panel discussion. That is the last one. So we'll start with our topic, scientific program topic. So that is consent in medical practice by Dr. Ravi Shankar sir. For this, I request Dr. Shukumar Kumbar sir and Advocate NC Mohan sir to please come on the dais. So I think we already introduced Kumbar sir, and he is very well known anesthetist as well as a medical legal consultant. So lawyer Advocate NC Mohan sir is a famous lawyer, a practicing advocate before various trial courts, appellate courts, high courts, consumer commissions, state and national medical commission for over past 27 years. Welcome, sir. So now I call upon today's speaker, Dr. Ravi Shankar sir. I request our chairpersons to please introduce our speaker, Dr. Ravi Shankar sir.
Good afternoon, everyone. We're finding a thin attendance, that too after the post-lunch. Probably all the delegates are partially consciously sedated after lunch. And Dr. T.N. Ravi Shankar, who is my good friend, my mentor in medical legal aspects, and we have traveled many places to address the medical issues in many of the platforms. Dr. T.N. Ravi Shankar, he did his MBBS from, he did a diploma in forensic medicine from Colma University, PGDMLE from Premier Institute of National Law, Bangalore. He did the MBA in BITS Pilani, and is the past secretary, past president of IMA Tamil Nadu, and also IMA CGP, National Secretary and the Chairman of Medical Legal Cell, National Headquarters. And he's a medical legal consultant, drafted the replies defending doctors and hospitals in many of the cases in Tamil Nadu. Received the Best Doctor Award from Dr. MGR Tamil Nadu Medical University and the Government of Tamil Nadu, and is a medical director of Sudhar Hospitals, Chennai. And he's a very audacious speaker, and many times I proclaim him as encyclopedia of the medical legal aspect. With this, over to you, Dr. T.N. Ravi Shankar. Thank you.
Thank you for your nice words, and let me thank first the Karnataka IMA, more so
Gadag branch, and in particular, Dr. Pawan Patil, my friend, for giving me an opportunity on this afternoon. In fact, when once things gets delayed or postponed, it will keep getting postponed forever. Finally, you will get a chance. Shivkumar said, the crowd is little thin. The crowd may be thin, but there is one person very, very significant in medico-legal angle of this country. I used to say he used to mentor and all these things. I told them, maybe we are all fathers or chitapas or small fathers, but the grandfather to give the meaning for medical negligence in this country is there in the audience, Dr. Joga Rao. If he is there and I am getting an opportunity to give a talk in front of him, I think it's a great honor. Thank you, sir, for being here, because it's not now. I have seen him 3 decades ago. The man who wrote the first book, A to Z in medical negligence. Am I correct, sir? 3/4 of the cover page was green, olive green. The 1/3 was black in color. That's a Joga Rao, sir. That's probably the first book in this country. Subsequent to it, Compendiums of Medical Judgments by Neeraj Nagpal. And this gentleman is the man who gave the meaning and the sense for the medical community to follow what is medical negligence. Thank you, sir. Thank you again, sir. And people who are sincere, truthful, knowledgeable will be recognized at any part in their career. And that is classical example is Joga Rao, sir. Thank you. And let me come to the consent. When Consumer Protection Act came into force in this country, I don't think the word consent was there. I don't think consent was really taken in the way what it is being done now. Probably in the 90s only, the meaning and the sense for consent came into force. If I am wrong, Joga Rao sir will correct me, because I studied in the 80s, practiced in the 90s. At that time, if a patient is taken into the theater, only one single word would have been told to them. We are taking you to do appendicectomy. Are you willing to do surgery? He will say yes orally. Express consent. Implied is one what you have told him, and express is what he had expressed. And beyond that, everything will be action. It's action like our Rajinikanth for us in our state. Next slide, please. 60% of the cases in the consumer courts are due to poor consent, and more because the documentation of the consent. We as a professionals are too smart in our knowledge, too skillful in our using our hands, our fingers and everything like that. But we will never use the pen to document, and even that pen would have been given only by a pharma company. I have never bought pen in my last 40 years of my practice career, and now I don't use a pen. I only type it out. Next slide, please. A good knowledge of consent will, please go back, please. A good knowledge of consent will prevent you from spending time either with the police or the lawyer or in the court, or at least attending such a session post lunch. It's very difficult to keep yourself awake post lunch. I know that. And more difficult to keep myself also awake because I have not slept for 30 hours traveling all the way from Chennai here. So I have to keep myself awake and also keep you awake. Next slide, please. And the types of consent, I think, click it on. Yeah. Implied consent, that's what I told you earlier itself. The dimmer behavior and action of the patient indicates his concern. Trust and empathy from the basis of implied concerns are limited to inspection, palpation, percussion, auscultation. A patient walks into your clinic, sits in front of you, tells that I have got fever for 4 days. That's an implied consent. Next slide. In expression consent, a patient specifically permits a physician to undertake diagnosis and treatment of specific problem. An express consent can be written or verbal, and he expresses to get a prescription from you. You give a cross-examination, you put him a questions for him to answer, and he answers us. And that is where he says that he expresses his concern to proceed on the treatment for which he has come to you. Next slide, please. And an informed consent is one what is there is now an accepted and the cornerstone of medical practice. That is why today we are talking about it. It's a continuous process which includes the exchange of information and the development of choice. Exchange of information and development of choice. Understand that. That one single word of in the English literature will have to be implied on our mind to get a concern of a proper nature. Loco parents, there had been questions always that this is where in an emergency involving children, when their parents or guardians are not available, consent is taken from the person in charge of the child. Example, a school teacher. That's a local guardian that is there at the time of emergency. Somebody who's there important will be the loco patient. That is also applied to the jail and certain things which we'll see later. Next slide, please. Informed refusal. Any individual has a right to refuse the treatment, and if that is going to be there, and if he says no, at least get a thumb impression. Otherwise, that informed refusal is not valid in the court of law. If after knowing about the procedure, its side effects, and other information related to the procedure, patient declines or refuses to undergo the procedure, it must be taken in written. Next slide, please. Two most common mistakes that we always do in our practice is taking a general concern at the time of admission in a hospital. We try to take a concern there. It's only to get admitted, only to the doctor to examine, not beyond that stage. Maybe to take a blood sample, maybe to do a PV examination or a PR examination, maybe to auscultate and percussion and all these things. Not beyond that stage if you are trying to do an intervention procedure or shift the patient to the ICU or take the patient to the theater, taking concern from parents, spouses, children, relatives of an otherwise competent adult. If a competent adult is there, it is his right to decide on the treatment, what he wants. Next slide, please. Concerned, and every patient has the right to get the full information. Incomprehensible, non-medical terms concerning his diagnosis, treatment, and prognosis, alternatives, possible complications, risk, and involved. It means from anatomy to forensic medicine, you will have to tell them. What's the physiology? What is the pathology? What is the microbiology? What is the physician opinion treatment? What is the surgery you are going to do? What is the complications, side effects? What all can happen for a patient with your action? It has to be told to him. That is what is a concern from anatomy to forensic. And if he dies, how is his body going to send to him, whether with an autopsy or not? All these things also should have to be told on the lighter side. Patient has the right to make informed choice about his or her health care, responsibility to explain and counsel lines of the doctor. Patient can change mind, give or withdraw consent at will. That is informed refusal. Next slide, please. Even the smallest and most innocuous interventions need to get a concern. See, you need to tell them. 1995, when we started the PPLSS scheme, at the time only Dr. Joga Rao was there in Chennai. When we started the PPLSS scheme, we adopted it from Kerala because revolutionary people, with all the revolution that happens in the state, will be the first people to do it. And we are the second people who followed it. And I was their charter joint secretary and legal committee chairman without the knowledge of legal committee at that time. And even the smallest, most innocuous. Because when we tried to we received a lawyer notice from one of the patients saying, without my consent, my urine sample was taken for examination. Can you understand? Can you interpret what the patient would have thought? His urine would have given all information about his good and bad habits. That was probably his opinion was. At that time, the Prime Minister of this country was Morarji Desai. You know Morarji Desai, what he advocated in the country. Investigations, diagnostic procedures that requires intervention, anything you try to give an injection and take a blood sample or do something, yeah, I think you need to get a concern for that. And each types of anesthesia, you start with a spinal, you start with the local, and then get on to do a general anesthesia. I think you need to explain at the earlier point itself. Each of the anticipated alternatives will have to be done. Newer drugs, newer techniques cannot be done without the ICMR concern and all these things. Blood transfusion, 12 a.m. to 12 midnight. You need to get a separate concern. If it is going to be whole blood, it is a separate concern. If it is going to be components, a separate concern. Why? Because today, the blood would have been procured from your own hospital. You might have a sample. You might have a stock in it. Next day, it would have been in a different blood bank. And components have a different side effects. Whole blood has got a different complications and all these things. That is why anything in regarding transfusion of blood, will you need to get a concern for at least 24 hours. Every 24 hours, you need to get a newer concern. It's very important. The case, all these things are not imaginary things from the medical fraternity or from the legal medical consultants. It's because there had been a case in the Supreme Court from my own state. Gokulam Hospital was a doctor. That case was there. They gave the judgment and it said you need to get a concern for every blood transfer. It's a judicial law. Next slide. Diagnosis, nature, patient's illness or injury, name of the proposed concern, treatment, procedure, name and purpose of the proposed treatment, inherited and special risk, known side effects, probability of success. Probability of success is very, very implied nowadays with the presence of reproductive medicine. Most of the advertisements come in the country saying we have 80% success rate on reproductive medicine. Today, in the Consumer Protection Act 2019, all the revision, you cannot guarantee cure, you cannot guarantee success rate. You cannot guarantee cure as by the Code of Medical Ethics, but you cannot guarantee the success rate as per the Consumer Protection Act. And if you fail, CPA will be imposed upon you. Next slide. Time required for recovery, any alternative methods and its associated risk and benefits, risk and prognosis if no treatment is rendered or procedure performed, date and time when treatment will commence or procedure will be performed. All these things, I think these things have evolved over the years. Everything will have to be explained to the patient, at least on the bedside. More comfortably, call them to the consulting chamber, try to do that. Next slide, please. Next slide. If I talk too much, my throat will pain. That is why all those clippings are there in between. Signature of the patient, doctor and witness. If required, was a statement there, which I was using these slides nearly 15 years ago. Today is required. I think Joga Rao can add about for that. And there are a number of judgments which have come now. Patient should know who had operated on him. He will know it at the time when you are explaining it to him. But when he goes to the court, there is always things of ifs and buts. You can always change certain things. And that is why we need to do the signature may be in any of the style which has been in circulation in the WhatsApp all over the country. Date and time when the concern is signed is also very important. The time when you have advised LSCS and the time when the patient gave the concern for it, the time when you have advised PCN, primary plasty, and the time when they gave the concern is also very, very important. In between the time, so many things would have happened for the patient, for the baby, or for anybody else. Next slide, please. What are proxy concerns? There are times when you have to take a proxy concern. Initially, I have told also the parent not available for a school child and the school teacher could be a proxy concern. That is there. Take a decision in the best interest of the patient. Proceed with oral consent on even without consent. Take written consent from friends, relatives, accompanying persons only if necessary or possible. Record specifically and elaborately in the patient's medical record the fact that the consent is improper and write it down clearly why it was an improper consent. Somebody in the road traffic accident. Today, after Paramanda Kataria case, anybody can bring the patient and put them into the emergency ward and get away. It is the RMO of the hospital who's the guardian. So you have your smart mobile phones to record events that is there. You can record the event in the monitor that the BP pulse is scoring, and that is why you are taking a decision before the relatives come or any guardian come and proceed on the treatment. Today, video consent is accepted. And there is a smartphone. The smartphones are much smarter than us. They had made us idiots. We don't remember the mobile number of even your kith and kin. And if you don't remember your wife's mobile number, then it is a kill for you. Because any day on your anniversary, they will ask you, what is my mobile number? And if you don't tell the mobile number, your anniversary is going to be extended for several years later. Be careful about it. Next slide, please. And filling the concern form is another important one. Do not change the pen of the person who's filling the concern. And no alterations or additions, signatures and initials in every page. Every doctor will have got a loan from any of the bank. No doctor survives or grows without a loan. When you go to the bank, today the bank people come to you. They don't even come to you. They send it on the email and ask you to sign and send it. They'll ask you to sign it in both the sides and at the bottom. They leave the top only for your Ganapati 786 and Christ. Every other place they'll ask you to sign. But we as a professionals in the medical community never even sign it anywhere, never even get it signed properly. And that is why it is being stressed here that signature and initials on every page. Take the patient's signature wherever handwritten typed entries or corrections are made in the concerned form. You know why these alteration additions are done? Who are the people who invented or made us follow that dirty habit is the sonologist, not the radiologist. And that is why law has been enacted in this country for the last 10 years. TCP&T Act. A radiologist cannot go to more than 2 centers within a district. And if you have to go to the next district at 1 center, because when the sonologist and the ultrasound machine came, the sonologist will have a typed format. They'll go from one hospital to another hospital. At least 10, 15 hospitals in a day, keep striking out, adding on things, missing number of times to strike out that a hysterectomy would have been done for the patient. Uterus found will be there. Number of times these kind of complaints had been there, which had gone without much problem in the court. But today, nobody is going to leave you. Even if you don't make a mistake, they want to sue you. And if you have done a mistake documentarily, then you are in trouble. Next slide. Do not leave any blank space in the printed concern. That's only the sonologist who started it. Record specifically the delay in giving a concern, particularly for an NSCS, for a cardiac, for a polytrauma. Please note down at what time the concern was given and who gave the concern. Record specifically in the concern form the date and time when the patient concerned was south and when the patient gave the concern. Next slide, please. In problematic patients, 2 witness. And witness should not be from the hospital. If the witness is from the hospital, it means he is also part of the treating team and your concern form becomes obsolete. Thank you for the advocate. Number of times he was trying to write down something. I thought he's going to ask me a lot of questions at the end of the session. At least now he's nodding his head. Thank you, sir. Record the concern form in the concern. If a surgeon, if there are more than 3 surgeons involved, a polytrauma, an orthopedic, a general surgeon, or an physician would have been there. Try to write down in which part and from what time to what time, who was the anesthetist, who was the surgeon, what was the procedure done. Why I say this? The patient would land up with a malunion. Why should a general surgeon or why should a vascular surgeon or an obstetrician should be called to the court? It is not that you want every one of us to come to the court. At least 2 of them could be away in the court, give a moral support for you, try to help you out, finding out something from a good lawyer or from a good medical legal consultant, so that you are confident. Somebody is giving you confidence. As far as possible, if there is going to be more than 1 person involved in the treatment of the patient, try to get away people who need not be taken into charges in the court. See, occupational hazard, today consumer notice, summon and all is all occupational hazard. We need to face it. There is no other go. Video consent is valuable in the present day of practice, but you need to tell the patient before that you are taking a video of the event and you are taking a video consent. It is usually the patient who does the video and audio recording, because they will come into your chamber, put the mobile phone on and keep recording, and that recording will be used later, and courts will not take the concern, take the word of the doctor saying that this recording was not given to me or told to me that the recording is going on. But when we don't put it down in our chambers, when you don't put it down in a hospital, that CCTV under CCTV coverage, then you are going to be taken to task. Next slide, please. Keep concern in the local language. That's a very, very difficult thing. Another proportion when you are in the border states. The person might know the language known to you. Kannada, he might know Kannada, but he will sign in English. He will come to the court and say, I don't know English. Somebody told me to sign, so I sign. So you need to have an interpreter, particularly a witness person who knows the language Kannada and who can talk to the patient in Kannada, and that person will have to be the witness. And it has to be written in the concern form. Kannada interpreter is this person who is also a witness. That is very important. That's very important. There will be uneducated person who will put a thumb impression. Once again, everything should be written there in the concern form. Such and such person has explained to the patient the entire procedure in the language known to him, and subsequently the thumb impression was taken. Thumb impression, I don't know English, but signing in English, border states, different languages, be doubly careful about getting a concern from them. and always take two independent witnesses if there's going to be a complicated cases. And today there is one smart thing that we can always ask for is the Aadhaar card. And today everybody has the Aadhaar card in their mobile phone. Please take it. Number of times people come to me to get a fitness certificate from different part of the state. They come and live in Chennai. They don't have a family doctor. So I am the person who's scapegoat for them. But then Aadhaar card has made a big difference and success for us. Next slide, please. I think the same thing. And last sign, confirm before every procedure or surgery whether the OT nurse has personally checked the presence of consent form in the patient's medical record and that is complete. This is all 10 years, 15 years, 20 years back story. Today, I think every one of us should have to take it. When you are trying to charge 30,000, 50,000, 60,000 for a surgery, I think it is our responsibility to see that the consent form is proper or kept properly or stored properly. We have a case in my own state. You know, CMC Vellore has got a different system of the MRD sections. They have the case sheet separately. They have the notes separately. They have a concern separately, investigation separately. And you keep 3 different, 4 different things in different places or in the same rack or somewhere in the different racks. Then it is a problem. Somebody from the theater took away the consent form when the patient was subjected for a second surgery because the second surgery happened because they did a PCNL, ruptured the large intestine, problem identified, explained, did the surgery. Everything went on fine. But finally, they went to the court saying, I have not given a concern for my second surgery. And when they searched for it, consent form was not there because the system was different. The system which we cannot follow it or we cannot trust all the time. That is why I always keep known devils in the hospital are better than unknown angels. Unknown angels can easily be bought by the patient somewhere or other. Next slide, please. Click it again. Everybody will be thinking only about Ahmedabad right now. 5 more minutes. I'll push it through, sir. Next slide. We need to be very, very precise on certain things. Sterility anticipated as per the Government of India, Ministry of Health and Family Welfare, consent of spouse is not needed for sterilization. But in the NMC, an operation which may result in sterility, the consent of both the husband and wife is needed. What does your state CEA says? So better tell the wife, get everything. The first one is because it is a national welfare program. The government has given that way. But then when you go to the court, what will the court follow? Next slide. That the only place where a doctor doesn't need to get a concern is send the body for a post-mortem, not for an autopsy. Autopsy is different, post-mortem is different. When you want to send the body for a post-mortem, suspicious death on the theater, death in the ICU, attenders not willing to accept the cause of death, then you have the right to call the police and send the body to the post-mortem. Next slide. And different ways how to take a concern, assent the patient has capacity to give a concern, communicate in the language understood by the patient, provide all relevant information to patient, give the patient enough time to give consent after counseling, especially for sensitive procedures, not for emergency. Take written consent signed by the patient. Next slide. And below 12 years, consent of only the guardian, even for MTP, 12 to 18 years, consent of both guardian and patient. Above 18 years, consent of only patient. Dispute between parents, consent of any one parent who's acting in the best interest of the child. That is there. Next slide. Concern should be procedure specific. It is either diagnostic, therapeutic, and palliative. Very, very common cases, Samira Kohli versus Prabha Machandaya. Next slide. Therapeutic privilege. Sometimes you need not give the full information to the patient on a therapeutic privilege, but it has to be proved, or it is very difficult to prove it in the court of law that you have used the therapeutic privilege, not giving the full information to the patient. Emergency, life-threatening in situation, that is what I told you. Smartphones are very, very nice. Today, every hospital should have a notary public within them. The value and the signature of a notary public will be much valued in the court of law. I think the advocate will be able to answer that. Next slide. Exceptional situations, cadaver donor transplant, informed consent from the next of kin should be taken. Video recording of the consent process can be done with prior consent from the same. MTP Act 91 does not require spouse consent. I already told you. Assisted reproductive technology, informed consent should be taken from both the spouses. And next slide. Click on it. A little bit on document. I think everybody would have been thought about document earlier. A document is a very, very valuable one. Next slide. Next slide. And the medical legal for claiming insurance, tax benefit, malpractice, negligence, evidence on the code. One thing we don't try to do a document properly today is research paper in this country can be Humpty number, numerous in thousands and lakhs. And that is why we don't document. If you document properly with your computers and with your software, when 10th pass and 10th fails can go to database, why should not we do it? And your research paper will be very, very worthy in this country. Next slide. Why is poor documentation is all there? I think everybody will be knowing about it. Poor documentation can make good care look dirty, ugly, bad, or put you in trouble. Next slide. That's the reason why documentation. Next slide. Next slide. When you are trying to change anything in the document, strike it down, write down on which date and time, when we will not know what the incident, why it was done and what it was changed. And today you have softwares which can always be very, very useful, date and time and which computer and which person with the password can be known. Next slide. I'm almost coming to the end. Samira Kohli, everybody will know this case about the Samira Kohli. Anybody doesn't know about Samira Kohli? Should I talk about Samira Kohli, sir? Just 2 words I can tell you. 44 years old spinster had the confidence in her life that she can conceive after marriage after 45 years. And her boyfriend from the defense came down and saw that this lady was subjected for diagnostic laparoscope. Understand? Diagnostic laparoscope. When they did the put down the ports, like how Pawan Patil would have done it, they saw entire abdomen with seedlings. The second surgeon came out, talked to the mother of the lady, got an oral consent with an opinion that the patient will get up and then put down the sign. So they got an oral consent, went on. From the defense service came, took away the patient out home, not paying the bill. The hospital filed a complaint. They filed again another complaint. Case went to the court. They said without consent, they had removed 1 or 2 minutes. Without consent, they had removed the uterus and the ovary. That was the case. And the next slide. Next slide. Compensation claim for the loss of reproductive organs and consequential loss of opportunity to become a mother for diminished matrimonial prospect for physical injury. What the court said was everything is necessary, but a real concern should have been taken. Had the concern been for diagnostic laparoscope and proceed, it's totally different. They did only for diagnostic laparoscope. Next slide, next slide. Next slide. Next slide. These are all about that case. Code of Ethics also has got a statement for that. Next slide. This is about a 4-year-old. Once again, a concern will specific concern. 4-year-old polio child operated, alleged assurance of 2 months, child will walk. Right leg shorter and weak leg. Defense not willing for surgery. Insisted and no assurance was given. That was a defense of the hospital and the doctor. They were not willing to do the surgery. They insisted on doing the surgery. And what was the concern form with the court observed was only straight leg and no improvement in power was stated in the concern. So specifically the concern will have to be there. What is the end result of the procedure? Next slide. Need to be watchful like the cat always. I've got last 2 slides. Try to recollect everything. Procedure is considered trivial. We don't take a concern. Consent of relative is taken when the person is conscious and oriented. Minor and intoxication of unsigned can be taken. You need to note it down in the case sheet and then get a proxy consent. Blanket consent is of no value. It has to be specific procedure. Blood transfusion consent need to be obtained. Fresh consent is not taken for a repeat procedure. You put a stent into the ureter. You're trying to take out a stent. You tear the ureter. Second time a consent should have been taken. Next slide. Procedure related necessary information is not given. Even if the information is given, it is not documented. Consent lack the signature of the treating doctor. Consent is not witnessed. Alteration additions. All these things have happened in the court. That is why it is being told here. Next slide. I always finish my slide with Mother Teresa. She is not a biological mother. She was only a spiritual mother. Yeah, the love, care, and compassion. That is what we need to provide to the society. Love, care, and compassion need to be provided so that we can escape people like hearing people like me talking on an afternoon, go back to home on Sunday afternoon and sleep. And again, Sylvester Stallin's word is fine. Life is not about how hard of a hit you can give. It is about how many you can take and keep moving forward in the society. Every doctor will have to take this word so nicely, because any number of times a patient charges you, does anything against you, our duty is to give back to the society the best of care
Thank you,
for
doctor.
them. Thank you. Thank you. One small story about Sylvester Stallone, sir.
But people will lose out on the opportunity of asking questions.
Oh.
Probably we can come back to that.
Okay,
Thank
sir,
you for
okay.
the very
Okay.
enriching, enlightening
Thank you.
insight into the topic of consent. While most of us thought that consent simply meant seeking permission, you gave us a lot of insight into what consent meant. I think the audience also need to be told that in Samira Kohli's case, though the court gave a compensation of 25,000 rupees and asked for waiver of the bill, the doctor spent 12 years, 8 months, and 6 days loitering on the corridors of the court. Over to the audience.
Yeah, we have one question, sir. I think probably we discussed it. This is Dr. Abhishek. Should you take a consent or permission from the patient or attendees while shifting the case from ICU to general ward or a private ward once the patient is stabilized? Recently, one of the patients denied to shift out as our ICU was full and we wanted to make a bed for the new myocardial infarction case. He called the THO, Taluka Medical Officer. THO asked me to have you taken the consent to shift the case to the other ward? I don't think we need to take it.
Shifting into the ICU, shifting to the theater, shifting to the ER, you need to get a consent. Shifting out when you think the patient is fine and total, explain to them and shift it out. The whole issue would have been the patient would have been shifted out for the sake of shifting in another patient. That's a bad relationship between the patient and the hospital. One. Number two, somebody would have given wrong information. That is why the patient would have said, you are deliberately shifting out before he has recovered totally. That is what is the whole issue is. That also can be video recorded. Plus, shifting out of the ICU, I don't think you need to get a concern for that. That's not there. Joga Rao sir will be there to answer it, or
anyone?
Any question from the audience other than this?
Hello. Sir, do you think it is a good idea to notarize the consent?
To?
Notarize.
Notarize. Ask our advocate, sir. Sir, it is putting the onus on somebody else who has got a legal right. That is why today most of the hospitals are trying to have medical legal consultants, a notary public. That is why I think advocate sir will be the right person to answer, or whether it is there within their purview or anything like that.
There is really no need to have a notary. And all said and done, we've been listening to topics on various medical legal aspects since yesterday. One thing that lawyers can assure you, I'm sure Jogara sir also will vouch for what I have said. Despite the fact that it looks so difficult to comply with all the legal requirements, the Supreme Court has always come to secure the interest of doctors. Right, sir? Always. There are many judgments, including the judgment in Samira Kohli's case, Jacob Matthews' case, then Bombay MRI hospital case. So there is no need to be fearful. What an advocate would tell you is to capture this clinical scenario there. If the patient refuses to sign, or if the patient takes indefinite time to sign the consent, please make a note of it.
Document.
And one very important thing, apart from simply taking signature on the pre-printed form, also make parallel notes in your case sheet. Draw line diagrams, pictures. So that is going to make an impact on the judge's mind. The judge will then be able to say, yes, this doctor has spent enough time with the patient to take and record consent. That is what is going to form a very strong impression in the mind of the judge. I am told by many of my clients that they do make notes and scribble drawings, but they simply throw it in the dustbin.
Throw it in the dustbin.
That, in fact, is your best defense in court. Yeah.
Thank you, sir. Thank you, sir.
Sir, I have a question. So I'm a surgeon, and we have come across so many occasions where while we're doing one surgery, additional surgery will be required, and the patient is either under anesthesia, and the relative is not very thinking about giving this consent. Especially, I would like to quote that when we are doing an appendicectomy, there is Meckel's diverticulum, and the relative outside is not very clear about why the surgeon wants to do another surgery. And so many times it has so happened that the surgeon has closed the abdomen, later on the relatives have come grumbled with him saying that why didn't you do that surgery in spite of not giving consent. So you can please tell me about two things. What is the liability of a surgeon to take consent at this time? And what is the next thing that if he doesn't do, how is he going to be accounted for?
Pawan is ready to answer it. Shivakumar sir is ready to answer it.
Yeah.
Pawan.
See, many times it does happen. It does happen. They take it for the appendectomy. If they find something else, they'll try to remove it, which is not the case. You cannot proceed a surgery other than for what the consent is given unless it's a life-threatening.
Life-threatening.
Yeah. If you are told you are doing appendectomy and there is a twisted ovarian cyst which is going to be gangrenous, you can remove it, you can substance it. The emergency probably post-operative would have been a burst-operative patient would have been lost it. That case can be done. Any elective procedure, you cannot do any procedure unless for the what for the consent is being taken.
Agreed, sir.
But the patient, the patient would ask you, okay? Patient would ask you, you would have said that you have given a consent only for this. That's what I have done it. That's it.
Sir, now in this case, you said about the twisted ovarian cyst. Is a surgeon allowed or having this thing to do a ovarian cyst, and how
in
much
this case, in a place like a Gadag, Dharwad, Hubli, okay? And if the gynecologist is available, probably you take his help and just document yourself that you have taken opinion of that also. If he is not available, you have a liberty to go ahead. This is a life-threatening.
Prashant was Nizam Institute, Hyderabad. The whole problem was the cardiologist did the neurosurgeon's work. Here in your case, if you say it has to be a life-threatening, you have to have the consent specialist, call them and proceed with it.
Sir,
Pawan sir.
I'd like to simplify this entire conversation. Anything done in the best interest of the patient with the information provided to the patient, and if they are giving consent, then fine. If it is a life-threatening problem, if they don't give consent also, you can do in the best interest of the patient, and no court of law you will be able to justify yourself. And regarding the expertise, even if it is a life-threatening case and it is other speciality, as sir said, every time there is no need that you take the notes opinion about the another specialist if that is life-threatening or it is of the concern during the surgery. Because if you have found that there is a twisted ovarian cyst and you need to call an gynecologist, you'll have to wait, you have to give the anesthesia for another 1 hour or 2 hours. That is not justifiable in the interest of the patient again. Thank you, sir.
Thank you. Any more questions from the audience?
Excuse me.
One more gentleman.
Sir, you said that the time of consent is also important. You said here this side to your right. To your right.
Please go ahead. Doesn't matter where you are. Go ahead.
Consent is also important. So, like when we do elective surgeries and all, patient gets admitted previous day night, and next day early morning we are planning for surgery. That time we take consent previous day night only, and then ask our staff to prepare OT and inform anesthetist.
As long as there is no problem happening between the night to morning, you are safe.
Yes.
If an MI had a silent MI had happened between the night and morning, don't you feel that you have done a mistake?
The best thing is for all elective cases, previous day should be
so
taken.
you
Unless the
explain
things are
to them,
getting changed overnight.
You explain to him on the previous night, get the sign on the morning, or try to get 2 signatures. What is wrong in getting the second signature when the bank is trying to get in every paper and every page your sign for a loan to be given to you? It's only money, but this is life and your profession. So if you have got a sign previous night, 9 o'clock or 7 o'clock, better on the morning before rolling into the theater, get another sign. It is no harm. It is much safer to you.
Thank you.
There's the last question.
Yeah. I am Dr. Venkatachalapati, pediatrician. Sir, do we require written consent for vaccination, or is it implied? Because some talks we are hearing that even for vaccination also, you're supposed to take consent.
Sir, by the time your kith and kin are going to practice pediatrics, they will be getting consent for vaccine also. Right now, it is not.
No, sir. In metro, some of them are even practicing.
To be on the safer side. See, I think the vaccine death happened in my Chennai city. I still remember. I was a PPLSS legal committee person, and that doctor gave the injection. Vaccine today, complications are much, much less. But after COVID, it is again going to create a problem in the society's people's mind. I think over the time it is going to happen. But then again, there is an implied concern. As a pediatrician, you would have given a big chart. You would have given a big note, noting down all the vaccines. The vaccine, which date, which month it has to be given, signed by you. If they have taken it home, brought it back, it is an implied concern. Am I correct, sir?
Yes, sir.
Thank you, sir.
The mere fact that the patient has come to you asking for a vaccination itself is implied consent. That is one thing. Now, there has been an instance where a baby was brought to the hospital for vaccination. The fallout of that vaccination was that the child may develop fever. Now, the parents were not told that this is a possibility. They had travel plans and they had to cancel the travel plans. So they filed a case in the consumer court and it was deemed to be deficient in service for not having informed that there is a possibility that the child would have developed fever. Yeah. So things are becoming difficult. Like Dr. Ravi Shankar pointed out, you will need consent for everything and anything. It sounds fortunate that I and Dr. Jogarao have chosen not to take up medicine and have chosen to be lawyers here.
One more, sir. Last, can anybody clarify what is a witness signature? Who should sign as a witness when we take a consent? Witness.
Witness is only from the patient side.
No, I mean patient close relative or like it is. We always.
How are you going to prove it?
Sir, this
is a big question about this legality.
Yes.
Today, legality number of times in ART clinics have happened. Somebody comes as a husband. We don't ask for Aadhaar card. Aadhaar card doesn't have the husband or wife, or sometimes the parent's name is there. It's a big complicated question.
So this is a very common situation that we face in courts. We find signatures as witness in the document, but that witness is not identified. See, you are not expected to be an investigating officer. It is not your duty to confirm that he or she is wife or otherwise.
Husband.
And then you are only expected to do the due diligence, and the document must reflect that you have done the due diligence. That is all that is required. Somebody
from the hospital should not be there to put the witness sign. Somebody has signed. Get their phone number, get their Aadhaar card, put it down. It's now the onus is now on the police to find them out and the courts to interpret it.
Yesterday, somebody was pointing out that you should actually call them, as they give their phone number. That's a very good practice. But unfortunately, in a situation in a country like ours, where you are catering to larger population in the OPDs, it's not quite possible. Courts have been very eager to borrow principles from other countries. But what we must also realize is that the patient load, the patient volume that we have in our country, you cannot, maintain those standards. And the Supreme Court, like Dr. Jogarao yesterday mentioned, in Dr. Samira Kohli's case, has held that the court don't want to push the doctors to such a situation that it becomes difficult for them to practice. That is why I said that the courts are there always to ensure and safeguard the interests of doctors, especially the higher courts. See, one more minute. I think I'm talking more than Dr. Ravi Shankar.
No, sir. We are happy to hear you. Because if you are not putting question to me.
Sir, I had one last question.
Last question, please.
Sir, I have one last question, sir. Here. So recently I was in the emergency ward and there was this patient. He was brought by the auto drivers. He was hit by an auto person and he was unconscious. So he was brought by the auto person. So he is not related to him. That person who's fallen, he is unconscious. Like, who do I take consent from if I have to do anything?
That's what I told you. The head of the institution is a proxy guardian.
Or else the good Samartyan. Okay, it's legalized in India. That will take care of it. You don't have to take anybody.
You are doing it in the best interest of the patient.
Best interest of the
That is
patient.
all. Or take.
We
That
can
is
go
why
with
I said.
intubation, everything in that situation.
Yeah, this has happened because after Paramananda Kataria versus Union of India.
Madam, the situation is that the patient is not conscious or oriented. Patient is brought by a third person and he needs medical care. This is the situation of an emergency. So there is no need to
I can go ahead with what
Yes,
you
can. Because
that is why I said record it in your smartphone.
Paramananda Kataria versus Union of India is clearly given the guidelines what to do in the accident cases.
Thank you again. I thank again Pawan Patil for calling me and the presence of Jogarao in spite of his schedule to be here to listen to me. Thank you so much, sir. Thank you.
Thank you, sir. I request the chairpersons to give a memento to our speaker, Dr. Ravi Shankar, sir. I request Dr. Yoganand Reddy, sir, to please come and give the memento to the chairpersons. Advocate N.C. Mohan sir and Dr. Shivkumar Kumbar sir. Thank you, sir. Thank you, sir. Next will be our mode court case 3 again, Dr. Jogarao sir and team. That will be followed by the last panel discussions. Thank you.
Disclaimer, moot court proceedings are being conducted purely for educational purposes and creating awareness on courtroom proceedings. There is no intent and attempt made to misinterpret the courtroom proceedings or bring disrepute to the judiciary. ಅಣಕು ನ್ಯಾಯಾಲಯದ ಕಲಾಪಗಳನ್ನು ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಗಳಿಗಾಗಿ ಮತ್ತು ನ್ಯಾಯಾಲಯದ ಕಲಾಪಗಳ ಬಗ್ಗೆ ಜಾಗೃತಿ ಮೂಡಿಸುವ ಉದ್ದೇಶದಿಂದ ಮಾತ್ರ ನಡೆಸಲಾಗುತ್ತಿದೆ. ನ್ಯಾಯಾಲಯದ ಕಲಾಪಗಳನ್ನು ತಪ್ಪಾಗಿ ಅರ್ಥೈಸುವ ಅಥವಾ ನ್ಯಾಯಾಂಗಕ್ಕೆ ಅಪಖ್ಯಾತಿ ತರುವ ಯಾವುದೇ ಉದ್ದೇಶ ಮತ್ತು ಪ್ರಯತ್ನ ನಡೆದಿಲ್ಲ.
This is the problem.
Check, check.
Hmm.
Check, check, check. Check, check. Done.
Yeah.
Yep.
Open court.
Silence.
How
The
many
four-
matters are listed today?
So 4 cases are listed today and they are for admission hearings.
All four for admissions?
First 2 matters are for admission and final arguments, and the other 2 are for admission.
Okay.
Serial number 1, FA number 3 of 2023, Mrs. A versus Dr. D and others, counsel for appellant, Advocate Yashwant Prasad, and counsel for respondent, Advocate Radha Pyari, and FA number 2, 4 of 2023, Dr. D and others versus Mrs. A, counsel for appellants, Advocate Radha Pyari, counsel for respondent, Advocate Yashwant Prasad. They are the connected matters, and it is for admission and final argument.
Your Lordship, I'm appearing for the appellant in serial number 1, representing the patient. And I'm the responsible.
It is posted for both admission and arguments. Sir.
Yes, Your Lordship. In fact, if Your Lordships would recall on the last date of hearing, I was informed by the bench clerks that that Your Lordship would be interested to hear both on admission as well as on merits, which in fact is a welcome move in my respectful submission, because oftentimes we don't see arguments taken up in this manner, and that would save time. So and that way I'm very, very grateful and I'm ready to argue.
Your Honor, in this case, an execution petition has already been filed, and therefore I am ready to argue both on the admission as well as final hearing.
I think, to my understanding, this is the first time in the history of Honorable State Commission Principal Bench where admission hearing and a hearing on final merits taking place at the same time. I think it is necessary because the kind of pendency what we are experiencing, it is the need of the hour. Therefore, luckily both the councils you are prepared for. Therefore, let's address it's a cross appeal.
Yes.
Okay.
My request, Your Lordship, is since there are other matters also listed, these 2 matters in serial numbers 1 and 2 may be passed over, and thereafter the appeals can be heard together.
Yeah, but in State Commission, there is nothing like passover process. Only in High Court it happens. But considering today's situation of cross appeals, maybe the appeal hearing, admission and final may be taken up later.
Grateful.
Oh. FA number 3 of 2024, Mr. A and another versus XYZ web porters. Counsel for appellants, Advocate Yashwant Prasad.
What is the matter?
Your Lordship, I am appearing for the appellants 1 and 2 in this case. And in this matter, the appellants are impugning the final order passed by the Honorable District Commission, which had partly allowed the original complaint, wherein a compensation of rupees 1 lakh was sought and the awarded compensation was a meager 10,000 rupees. Now, this case pertains to a product liability case wherein the appellant number 1 happens to be a consumer, and he had placed an order for certain shoes on an intermediary website.
Is this an online transaction?
Yes, Your Lordship. In fact, as part of the appeal also, there's annexure A1, which would demonstrate that I have placed the order on the online portal.
What is the product you had asked for?
Pair of sports shoes, Your Lordship.
Sports shoes.
Sports shoes. Because, in fact, my client is a health freak in the sense he's a fitness freak, and he believes in spending a little more and lavishly on a lot of accessories.
Branded shoes.
Branded shoes. And one such product is the shoe, which costs almost 7,000 rupees. And the fundamental grievance against the district commission order is that my shoe cost itself is 7,000. And what will I do with 10,000 rupees as overall compensation? And this case has been pending in the district commission for so many years, almost 5 years. And the district commission has not taken into account the litigation cost that I had to incur, the fee that I had to pay to my lawyer. And that way, my check. Check. Okay.
I hope you don't file a case against the state commission for this deficiency of
No, Your Lordship. Totally understandable with technical glitches. And therefore, the principal grievance of the appellant number 1 is with respect to the awarded compensation being meager. And therefore, the appeal is...
The awarded compensation was
10,000 rupees.
10,000. What was your claim?
My claim was 1 lakh.
1 lakh.
Yes.
As against the cost of the shoes, which is 7,000 rupees.
Yes, Your Lordship. In fact, the lawyer's fee that I had paid came to almost 50,000. And the case was prolonging for almost 4 years before the district commission. So I had to pay 50,000 for 4 years before the district commission. And considering the costs and expenses that I had incurred, the awarded amount of 10,000 is insufficient in my respectful submission, Your Lordship.
Which means you are seeking enhancement.
Yes, Your Lordship. I am seeking enhancement. And that is insofar as appellant number 1 is concerned, who is the direct consumer. The appellant number 2 is the manufacturer.
Manufacturer of?
The shoe itself.
Shoe.
And my grievance, insofar as the district commission's order, is that the district commission has come to a factual finding that it was a fake product that was given to the consumer. And they had dismissed my claim saying, you are not a consumer before this honorable commission, and therefore you have liberty to agitate your grievance before the jurisdictional court. But a consumer commission won't have the jurisdiction to decide your case. Is the district commission's order. And my submission is, Your Lordship, but that when a factual finding of a fake product being given has already been done by the district commission, my only grievance is that how compensation has been given to the consumer, the same way compensation must be given to me as well for trademark infringement, Your Lordship.
Mr. Counsel.
Yes, Your Lordship.
Manufacturer is not a consumer.
Yes, Your Lordship. Strictly speaking, he is not.
He is not a consumer.
Yes, Your Lordship.
If the manufacturer is not a consumer,
yes,
you need to make out a case.
Yes, Your Lordship.
Under which aspect the state commission will have jurisdiction.
Yes, sir.
For instance, do you think it comes under product liability? If it is IP infringement,
yes, sir.
For instance, trademark registration infringement,
yes, sir.
Whether I will have a state commission will have jurisdiction.
In fact, strictly speaking, no, your lordship, I will have to approach the commercial court. I definitely concede. But when the district commissioner has already decided that it's a fake product, my only concern is I don't have to again re-agitate this issue before a new court. I'm just seeking this honorable commission's intervention to say the finding of a fake product is true and compensation may be also given to the manufacturer is my only grievance.
Your thinking of approaching commercial court may not be fruitful. The reason is the claim is 1 lakh,
Yes,
but
Your
their threshold jurisdiction is 3 lakhs.
Yes, Your Lordship.
Therefore, I don't think you will be able to file
In fact, in this specific case, the trademark infringement is made out only against one product because there's only one consumer before your lordships. If I had to approach the commercial court, I will definitely seek an inventory of all the fake products that have been sold by the intermediary. And therefore, perhaps the client would be able to make out at least a case of more than 3 lakhs. And therefore,
Okay, please take the dictation.
in fact, your lordship, my apologies for the intervention, but there is no delay in preferring this appeal. And therefore, the appeal may be admitted, Your Lordship.
Please repeat once again.
There is no delay in preferring this appeal, Your Lordship.
Though it is not very clear whether the State Commission will have jurisdiction over the manufacturer. However, I am of the opinion that it is a fit case for adjudicating the other plea made by the council with regard to enhancement of compensation. List it after 2 weeks.
I'm grateful. Your Lordship.
What is the next matter?
Serial number 4, RP number 255 of 2025, Hospital ABC versus Mr. X. Counsel for the petitioner, Advocate Radha Pyari.
Is this the file?
I'm for the petitioner in this case.
Miss Counsel, just wait for a few minutes. What is the number of this case?
250. 2025.
Which file you have handed over? Please look into it. This is not the file. ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಕೆಲಸ ಸ್ಟೇಟ್ ಕಮಿಷನರ್? ಎಷ್ಟು ವರ್ಷದಿಂದ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರು? 5. ಟ್ರೈನಿಂಗ್ ಕೊಡಿಸ್ಬೇಕು. ಯಾಕಂದ್ರೆ ಫೈಲ್ ಚೇಂಜ್ ಆಗ್ತದೆ. ಮ್ಯಾಟರ್ ಏನಿದೆ ಇದರಲ್ಲಿ? ಮ್ಯಾಟರ್ ಏನಿದೆ ಮಿಸ್ ಕೌನ್ಸಿಲ್?
In this case, we have received a notice of the complaint in January, my lord. And the documents which I have received along with the notice, they are all illegible and inadequate. Some pages are missing. And therefore, when I filed wakalat on the subsequent day, I mentioned about serving the copy of the legible copy of documents from the complainant. And he said, you apply in the office and file the version. And accordingly, I had applied for the certified copies of the documents. And by the time I received, there was 1 day delay in filing my version in the process of getting the copies. And therefore, the State Commission, the Commission has rejected my version. And accordingly, I'm aggrieved because of the follies of somebody else, I had to suffer without filing or my version or contesting the case.
Miss Counsel, show me a provision or a precedent which says State Commission can waive the 45-day position with regard to filing of version. Is there such a precedent or is there a principle?
There are decided cases, my lord, under CPC where the statutory period has been condoned in special circumstances if sufficient cause is shown. And I have furnished it along with with my version, and this is on record, my lord. And though there is no statutory provision in the interest of justice, and I'm praying for this.
No, in fact, I have a serious objection with the registry of this State Commission. How and on what basis an appeal can be scrutinized in this level? When Supreme Court judgments very clearly categorize and clarify that beyond 45 days, version cannot be filed. And challenging that, appeal is being filed. How appeal can sustain? If there are decisions which say that there is a window period or some other way where you can seek exception, I can understand. Where is that kind of judgment? Is there a judgment to that effect?
It is under 151 CPC, I'm praying for this.
Which means by invoking 151 CPC, you wanted to prevail over Supreme Court judgments. How it is possible?
It is because there are...
Miss Counsel, let us pass over. I know passover is not correct. This passover because I am not at all convinced. And I want you to take it up maybe at 3 p.m.
Passed over. Passed over matter serial number 1, FA number 3 of 2023, Mrs. A versus Dr. D and others, and serial number 2, FA number 4 of 2023, Dr. D and others versus Mrs. A.
Your Lordship, I'm appearing for the appellant in serial number 1 and the sole respondent in serial number 2.
Yes, madam, yourself.
Yes, I'm representing the respondents in this case and the appellant in the connected matter.
Okay. It's a cross appeal.
Yes.
Yes.
Now, I need the base information as to what happened to begin with, followed by, for example, why do you think the district commission judgment is not sustainable legally? That you need to mention. The other way, you need to mention why it is legally sustained. I think this is how I want you to make submissions.
Please.
And the entire record has come from the district commission.
Yes, Your Honor.
Medical literature, everything, version, affidavit, all the things, everything. Okay. File is ready. Yeah. Please go ahead.
Yes, Your Lordship.
How much time you may take?
Your Lordship, I'll take about 5 to 10 minutes.
How about you?
I'll just take 10 minutes.
Yeah. I don't think we have a luxury of more time, etc.
Yes.
Already a lot of pendencies there.
Yes, sir.
Okay. Yeah. Please go ahead.
Your Lordship, by way of this appeal in serial number 1, the appellant is the patient who has challenged the district commission's order that has partly allowed the original complaint. As a matter of record, Your Lordship, the compensation sought before the district commission vis-a-vis medical negligence is 7 crores, Your Lordship. And the awarded amount was 10 lakhs, despite there being a clear finding of medical negligence by the district commission.
Was there a finding to that effect that there is negligence?
Yes, Your Lordship. There was a finding, which is being challenged in the cross appeal. In my appeal, I'm just seeking enhancement. And I'm challenging the very award of 10 lakhs is beyond any sort of rational basis. And considering the age of the child and the longevity of the child's life also, the fact that the court has awarded 10 lakhs is insufficient and beyond reason, Your Lordship. Insofar as the factual matrix of this case is concerned, Your Lordship, the appellant, who is also the patient, she's a 27-year-old woman working as a school teacher, and she is married. In the year 2020, she had her first pregnancy, which was uneventful. Or in other words, there were no complications that she had suffered. Subsequently, in the year 2023, she had her second pregnancy, for which she had approached the first respondent doctor, who is a gynecologist.
Is the same doctor who delivered the first child?
No, Your Lordship.
Different doctor.
Different doctor.
Okay.
The first respondent, that is Dr. D, is a renowned gynecologist. And the patient had followed up with her for the entire period of the pregnancy, insofar as whatever advice was necessary.
1 second.
Yes, Your Lordship.
You didn't mention about who are the respondents in your appeal?
Yes, Your Lordship. The first respondent is the treating doctor.
That is Dr. D.
Yes, Your Lordship. The
Next.
second respondent is the scanning center.
PQR scanning center.
Yes, Your Lordship. PQR scanning center, respondent number 2. And the allegation against them is insofar as a false report is concerned.
Okay.
That's
Who is the third respondent?
There's no third respondent, Your Lordship. There are only two
respondents.
Two respondents, one appellant.
Go ahead.
And the appellant had approached the respondent number 1 doctor for multiple scans. And amidst all these scans, the one crucial scan, Your Lordship, was the 19th week scan. And in my appeal, I have accepted at para 3, Your Lordship. And I say,
your appeal memorandum?
Yes, Your Lordship. Subsequently, during the 19th week of pregnancy, the radiologist conducted the crucial second USG, the anomaly scan. This scan revealed the presence of mild 3 to 4 ventriculomegaly with ventricular measurements around 11 mm. However, the radiologist interpreted these findings as no obvious congenital anomalies in the fetal head, abdomen, and spine, considering the ventricular enlargements to be within the spectrum of common fetal variations. Upon reviewing this report, the gynecologist concluded that the pregnancy was progressing normally and deemed further anomaly scans as unnecessary. She then advised the patient to undergo a regular interval USG and other requisite scans as the pregnancy advanced towards the delivery date. Now, by way of this very paragraph, Your Lordship, my contention is the report given by the radiologist stating no obvious congenital anomalies in the fetal head, abdomen, and spine is false, Your Lordship. And that is the exact finding of the district commission as well.
What do you mean by false?
When it is when I say false, Your Lordship, I am referring to the fact that there were certain other anomalies, mild anomalies that were around 11 mm. And when they were present, it was wrong on their part to say that there were no obvious anomalies. And in other words, it's a way of misleading the patient and at the same time too concealing crucial information, Your Lordship.
Are you by any chance saying the radiologist did notice anomaly or anomalies, but in his report, he mentioned there are no apparent anomalies?
Yes, Your Lordship.
Are you saying that?
Yes, Your Lordship. That is precisely my argument.
Proceed.
And concealing such information, Your Lordship, is blatant negligence and deficiency of service, which has been agreed by the district commission. Now, insofar as the gynecologist is concerned, my grievance is that the only option that was suggested to me, medical advice, was to undergo delivery. Whereas I could have, had I been informed by the gynecologist, I could have availed the remedy under MTP, Your Lordship. I could have undergone medical termination of pregnancy, although it is at the 34th week is when I'm informed of the anomalies.
Is it the same radiologist?
Yes, Your Lordship. Yes, same radiologist.
During the 34th?
Yes, Your Lord. Yes.
Okay.
And it is during the 34th week I am informed about this major anomaly. And the only medical advice I'm given is to undertake delivery. My only grievance is that, Your Lordship, medical termination of pregnancy, where was the need for you to say that your only option is to undergo delivery? In fact, the Honorable Calcutta High Court has permitted MTP at 34 weeks of pregnancy.
When the doctor mentioned no apparent anomalies, how do you expect the gynecologist to suggest MTP?
In fact, Your Lordship, there were subsequent scans, and then that is when the gynecologist got to know about the anomalies. And even after getting to know, she did not advise MTP as an option.
That is around which week?
34th week, Your Lordship.
But 34th week, MTP is not possible.
Yes, Your Lordship, certainly. But the Calcutta High Court, in an exceptional circumstance, had allowed for medical termination of pregnancy at the 34th week. In fact, I have placed leaders were consulted by the Calcutta High Court also, wherein they had mentioned that it is possible in the given facts and circumstances. So my argument, Your Lordship, insofar as the gynecologist is concerned, is that when we have a precedent which has been set by the Calcutta High Court, why couldn't I have been given the same remedy or an option? As a patient, I deserve to exercise the choice. You know.
Are you sure Calcutta High Court mentioned about 34th week?
Yes.
Or is there a typographical error? Instead of 24th week, they mentioned 34th?
In fact, Your Lordship, not only the Calcutta High Court, to my knowledge, even the Kerala High Court in one judgment recently has exactly at the 34th week has allowed for MTP.
I think you need to share those judgments with the state commission.
Yes,
and
sir.
survey copy to the opposing counsel.
I've already sought a copy of the Calcutta High Court judgment. I'll
Oh.
file the Kerala High Court judgment as well, Your Lordship.
Yes, go ahead. You have to
And
conclude.
yes, Your
You have
Lordship.
taken more than 10 minutes. Yeah.
My apologies. Sir. And in this case, I'd like to also highlight that there is absolutely no need for an expert opinion in this case, because the evidence on record would demonstrate the medical negligence by the gynecologist and the radiologist. In fact, Your Lordships would not require an expert to assist in terms of identifying what is the specific conduct of both these doctors which amounted to medical negligence. In fact, there is a blatant violation of the Code of Medical Ethics. I was not informed of the possibility of MTP at the 34th week. Perhaps the treating doctor was not aware, but ignorance is not an excuse. And therefore, I have a child who has
Mr.
multiple.
Counsel,
Yes, sir.
please take me through the operative part of the district commission's order,
Yes, sir.
where you mentioned that district commission is convinced about the medical negligence.
Yes, sir.
I just want you to.
I'll just read two specific paragraphs, Your Lordship. In the appeal, paragraph 7 and 8, I read, in light of these facts and circumstances, the patient filed a consumer complaint before the Honorable District Consumer Commission, Bangalore, alleging medical negligence against the gynecologist, radiologist, and claimed a global compensation of rupees 7 crores under different heads. Upon hearing detailed arguments, the District Commission partly allowed the complaint, holding the above parties jointly and severally liable for medical negligence. The District Commission granted a compensation of rupees 10 lakhs under the four heads, namely medical negligence rupees 5 lakhs, mental agony rupees 1 lakh, medical expenses incurred rupees 1 lakh, and loss of future earnings rupees 3 lakhs.
Did you submit any medical literature in support of your?
Yes, Your Lordship.
Now, particularly in recent times, we have noticed some of the district commissions, they, as against a claimed compensation of 1.5 crores, they order around 10 lakhs, 15 lakhs.
Yes, sir.
A recent judgment we have come across.
Yes, sir.
In such circumstances, how do you really make out a case for 7 crores compensation?
In fact, Your Lordship, the amount of 7 crores I have calculated based on the Supreme Court's ruling in the Krishna Kumar case, where they have identified a formula. When you're seeking compensation,
Ophthalmology case.
Yes, Your Lordship. And that is the precise basis on which I understand that there have been many complaints before consumer commissions vis-a-vis medical negligence where there is no rational basis, there is no reasoning on seeking huge compensation. But insofar as our case is concerned, there's a particular formula as recognized by the Supreme Court. We have captured, we have used, and basis that we have arrived at a compensation claim of rupees 7 crores. And the basis at which the district commission arrives at 10 lakhs is beyond reason, Your Lordship. In fact, even these two paragraphs, except for saying that yes, there is a case of medical negligence, there is no whisper by the district commission Bangalore stating the reasons why it felt 10 lakhs is sufficient. Or on the contrary, there is no reason why this district commission felt that the claim of 7 crores is unreasonable.
I think I must hear the other side.
Please, Your Lordship, please.
Yes, please.
In this case, my lord, the district commission has arrived at an erroneous findings with regard to the medical negligence committed by the opposite parties, doctors and the scanning center. Because the district forum basically failed to take note of crucial piece of evidence consisted in the medical records, wherein the doctor, the gynecologist, has specifically mentioned to repeat the scan soon after saying the anomaly scan. And she advised to repeat the scan after 2 weeks. This has not been properly appreciated by the district for commission. And that is one aspect. Similarly,
normally during which week anomaly scan is undertaken?
Between 18 to 24 weeks.
18 to. In this case, what happened?
She was subjected to anomaly scan on 19th, in the 19th week.
19.
Yes. And thereafter, I asked her to repeat the scan before in 22nd week, my lord.
Which she did not.
She did not. The patient has lost follow-up subsequently, and she turned up. I'm told that unofficially that she has gone to her native place where she must have either consulted somebody or she has approached me only in the 31st week.
Okay. 19th week she underwent.
Yes.
Next subsequent she did not.
She did not.
When is the next time she underwent the scan?
31st week.
31st week. And that report revealed the abnormality in the
Yes,
fetus.
yes, Mela.
Proceed.
Therefore, this particular advice given by me as a gynecologist to repeat the scan has not been properly appreciated by the
Whether the evidence has been produced before the district commission?
Yes, ma'am.
If
Yes,
so,
ma'am.
why district commission has not appreciated?
It has missed it. That particular, it was written in small letters to repeat the scan after 2 weeks.
Why doctors write always in small letters?
For the constraints of space and time.
Constraint of space, sir.
Yes.
On a different page you could have written.
Because
there is I'm not kidding. I'm saying this is the problem what general common people face. If it is so important, in my opinion, you should have written in capitals and bold letters. That you have not done. Did you bring it to the notice of the patient?
Yes, ma'am. We have counseled the patient that there is a mild ventriculomegaly and there is a possibility. It may resolve on its own before delivery, but sometimes it may also lead to certain complications.
Did you produce medical literature to this effect?
Yes, ma'am. We have produced. That is the second point which I am going to highlight, saying that the district commission not only not appreciated the medical records, but also the medical literature produced by me has not been appreciated.
Are you representing radiologist as well?
Yes.
Come to radiologist.
Yes.
Now, the question, one simple question is, the scan what he has undertaken, he gave the report saying no apparent anomalies, congenital anomalies. That's what he said.
Yes.
For which the council, he submits, which I want to test its veracity. You know what he submitted? The doctor did notice anomalies, but he gave a false report. That's what he says. How do you react to that?
The report is correct, my lord. And because it is it's a case of mild ventriculomegaly, it was mentioned in the document. But as per the role of a radiologist, his role is only to identify and report the anomalies in the scan and hand it over to the patient. And it is for the gynecologist to interpret. The radiologist is not under an obligation to inform the patient about the report. They only write the report and send it to the gynecologist so that she will take the proper decision and advise the patient, which she did, in fact.
No. are you by any chance submitting that there is a deficiency of service on the part of gynecologists?
No, because I have advised for the repeat scan, and I have also counseled the patient for the repeat scan, which she has not come for follow-up subsequently.
Mr. Counsel, yes, sir. You did not even whisper about this particular missing.
In fact, Your
No, how
Lordship,
come is it not a misleading submission before the State Commission?
Your Lordship, there has been no delay by the patient. Whatever has been mentioned, I'd like to clarify that the patient was not informed of any of these repeat scans. And she being a school teacher, she definitely would not understand the medical jargon, Your Lordship. Even if it is written, there is a duty on both the doctors to inform that, okay, please.
Mr. Counsel.
In fact, Your Lordship, that is the.
Mr. Counsel.
Yes, Your Lordship.
She is in family way second time.
Yes, Your Lordship.
First child.
Yes, Your Lordship.
Uneventful.
Yes.
And she is a school teacher.
Yes.
How, on what basis you claim that?
Your Lordship, she being a school teacher, I mean, it would be difficult for her to understand the technical jargon, Your Lordship.
No, go for review scan or a particular scan, particular week. Is it difficult?
In fact, Your Lordship, the aspect is not about whether there's a repeat scan advised or not. The fact that whatever those anomalies that have been mentioned, they should have been communicated clearly in a language that is understandable to the patient. That has not at all been done. It may have been mentioned in the report, but that is not the grievance, Your Lordship. Even if it is written, if the patient does not understand, isn't there a breach of duty by the...
No, by any chance, are you admitting that the report indicates so?
That's what they're claiming, Your Lordship. I'm not saying.
No, what do you say?
I'm saying it's not mentioned. In fact, it's not even legible.
Is it so difficult to make out whether it's mentioned in the report?
In fact, in the copy that I have received, Your Lordship, there's no mention at all. There's no mention at all in the copy that I have received. Which is why Your Lordships have also asked the same question. Why is it written in small letters, even if it is seen in their copy? In mine, it is not there. Which is why I'm
No, but writing in small letters does not mean not writing.
But in my
writing in small letters means there is writing.
Yes, Your
but
Lordship.
in you are claiming that there is no writing.
There is no writing, Your Lordship. In fact, the copy
How
that
do
I
you
have
respond to his?
Probably he must not have received the correct copies, my lord. Yeah, I think we have submitted before this Honorable Council. You may
If
kindly.
you submit a correct copy to me,
yes,
you are admitting that you have not submitted correct copy to them.
No, my lord. I don't know how he got the copies. Because we have submitted certified copies before this Honorable Commission. Probably it has erased by course of time. Got
Please show
erased
me
by
the
course of
particular
time.
record. How there can be opposing views
yes,
on a fact which is decipherable?
Yes, sir.
This is the certified copy you submitted, Ms.
Yes,
Counsel.
madam. Yes,
In this, there is a mention.
Your Lordship, in the copy that I have, there's no mention, Your Lordship. And that is the only source through which I can make an argument, Your Lordship.
Is there no other way where you counsel the pregnant mother saying that such and such duration you have to go for scan, etc.? Is there no other document? This is the report. I am talking about scan during which period, etc., etc.
The progress notes are indicating, my lord.
Mr. Counsel, there is some problem.
Yes, sir.
Either your client has not collected medical records properly, or they have not given medical records properly. But the record before the State Commission very clearly indicates that she has complied with her obligation.
In fact, Your Lordship, whatever documents that have been handed over to the client, they have been filed as part of our appeal, Your Lordship. In
You
fact,
show
even the
me
trial
his
court
documents.
records. Those are the only set of medical records that I have received. I gave a written intimation asking for the medical records. Those are the sets that I received and I filed it before Your Lordships.
Let me check once. Yes, in your record also there is a mention.
No, Your Lordship, but probably that is written.
You are challenging me? Counsel?
In fact, Your Lordship, I certainly know that the client does not
There
mislead
is
me.
a mention in this particular record No doubt it is in small letters.
Yes, Your Lordship.
But there is a mention here. You can show this.
Your Lordship, this is a handwritten, in my respectful submission, it's handwritten.
Even if it is
the print,
handwritten, is it not
the
legally
print
allowed?
the print is not even there, Your Lordship. I can't even see this. Is this Dolo 650 or
See.
Solo 650? I don't even know, Your Lordship. I
Mr.
can't even read
Counsel-
out, Your
no,
Lordship.
no, Mr. Counsel, when you received the document, if you think it is illegible, your duty is to bring it to their notice.
Yes, Your
Or
Lordship.
you could have filed a memo before me. I could have instructed them to file. But the fact that it is not there in your record, but whereas in your record submitted to the court indicates, I think there is some kind of communication.
Yes.
In the light of this, I'll ask you both the counsels one simple final question.
Yes.
Very honestly, your claim of 7 crores, though you mentioned about Krishna Kumar, did you explain all the heads?
Yes, Your Lordship. I did explain. In fact, I even filed the judgment for the district commission.
No, we are aware about it.
But they did not even apply, Your Lordship. That is the surprising.
Not a, I am talking about this.
Yes, sir.
Okay, we are aware. Krishna Kumar
Very
is
well.
one of the landmark judgments.
Absolutely.
Therefore, that principle, etc., I appreciate.
Yes, sir.
Now, my only point is you are only at enhancement.
Absolutely.
Therefore, I am asking.
Yes.
Now, coming to this particular, do you have introduced medical literature?
Yes.
Any expert evidence have you introduced?
Yes,
Why
sir.
you are taking so much time? You don't remember?
Yeah, because
Too many cases.
yes,
Hmm.
we did submit the expert opinion in this case.
So who gave that expert opinion evidence?
Mr. I. Suresh has given the
doctor.
Yes. Dr. I. Suresh has given the expert opinion in this case, giving his opinion that there is no negligence on the part of doctor, considering
he
the
is referring-
findings.
No, one second. He is referring to both radiologist and gynecologist.
Yes, both. To be have adduced the evidence of a specialist gynecologist as well as radiologist.
Dr. I. Suresh is a radiologist, right?
Yes.
Who is the gynecologist who gave expert?
One doctor, Dr. Ramani Rao
Ramani Rao. Okay. She is from which place?
from Bangalore.
Bangalore. Do you endorse that such and such expert affidavits have been filed?
They have filed the affidavits, Your Lordship, but they have not turned up for cross-examination. So I could not get an opportunity to test the.
The doctors did not appear for
No, Your
cross-examination.
Lordship. There's only an expert affidavit. There were multiple opportunities given before the district commission, calling upon them to come for the cross-examination.
How do you respond to that?
There was no application made by the complainant's counsel to seeking cross-examination. And as your lordship is well aware that cross-examination cannot be claimed as a matter of right unless a case is made out for cross-examination.
No, you are saying that he did not file an
He
application.
did not file an application.
Did you file an application?
I filed an application, Your Lordship.
Then what
but
happened to
then
that
it was kept pending, and the court has decided on merits. In fact, that IA was
No, which
considered
means doctor not turning up for cross-examination has no value.
In fact, Your Lordship, there was an oral remark made by the district commission saying that yes, until I dispose of the IA also in the interim, please ask your doctors to come. And that is also a mention made, Your Lordship. In fact, the district commission has said, please call the doctors. It's not just one expert, but there are 2 experts. And there's a claim of 7 crores. They have given their expert affidavits. At least as a judge, I need to know what is the credibility of their evidence.
No, all these oral words we understand, but
Yes,
they
Lordship.
don't hold water.
Yes, Your Lordship.
The commission should have passed an order
Yes, Your Lordship.
stating you made out a case for cross-examination.
Yes.
Notice must be sent to the experts, and accordingly they need to come and appear before the court.
Yes, Your Lordship.
But that has not been done.
That has not been done by the district commission.
He didn't even serve interrogatories to the experts, ma'am.
Why did you not serve
Because
interrogatory?
I was waiting to cross-examine the doctors.
How long you wait that way?
In fact, if they did not turn up for cross-examination, ideally the district commission should have discarded their expert evidence. The district commission has not even done that, Your Lordship. Directly, they say that there's medical negligence, but they've not taken the effort to even mention on what basis they've arrived at negligence. They should have also discarded the expert evidence.
Mr. Counsel, I understand district commission. They are also burdened, right? Lot of cases pending.
Yes.
You could have taken the initiative of serving interrogatories.
No, Your Lordship. In fact, in my respectful submission, when I have the right to cross-examine, which was also agreed by the Honorable District Commission, the question of me serving interrogatories does not arise. This is not a case where they have filed objections.
Okay, but ultimately what happened?
They did not turn up for cross-examination.
Again, whether the application was what upheld by the district commission?
No, Your Lordship,
No.
it was not. It was still pending.
That
They
is
just
the
made an oral
in
submission.
such a case, if it is still pending,
Yes,
how
Your
do you expect doctors to come for cross-examination?
The IA may have been pending, Your Lordship, but there was an oral remark and oral direction.
Oral remark, how they?
In fact, Your Lordship, that is the doctors have not turned up, Your Lordship. Otherwise, when I still have a right to cross-examine.
You have a right. I'm not denying.
Yes, Your
But I'm saying, in order to give meaning to the right,
Yes,
there
Your
is a process that is to be followed.
Yes, Your Lordship. I mean, in my respectful submission, for the fault of the district commission, no blame can be put on the advocate, Your Lordship. And therefore, I cannot be compelled to serve interrogatories when I also have a stronger remedy of cross-examining the expert doctors. For the fault of the district commission, if I am being forced to serve interrogatories, that would curtail my right to a fair representation in this case, Your Lordship.
Finally, I would want to know in one or two sentences, both for gynecologist and radiologist, why district commission's judgment has to be intervened.
The district forum has not even considered the judicial decision submitted by me of the cases which are decided by both the Kerala State Commission and the West Bengal State Commission, wherein they have vested the right to the mother to abort even at the stage of 34 repeats. And therefore, we have, even after seeing the report, we have informed and counseled the mother that.
Time.
Yes, counsel the mother. And as I mentioned, the radiologist at that, considering the findings in the report at that point of time, he has given his report. Whatever he has identified, he has recorded in the report, and therefore, he is not under a duty. There is no duty on the part of the
Okay,
radiologist.
that you are repeating.
Yes.
No, final point.
So he is
Yeah.
not negligent. He has complied with the standard
Okay.
medical practices.
Okay. Yes, your submission.
Your Lordship, as the original complainant, the complainant has discharged her burden of proof to prove medical negligence. And therefore, the finding of medical negligence cannot be in dispute before this Honorable Commission. And the only claim ought to be enhancement of compensation, Your Lordship.
No, I'm surprised.
Yes, Your
How district commission's order as to negligence cannot be challenged before in appeal before the state
in the appeal that I have filed, Your Lordship.
Naturally.
Yes.
In their appeal, we have to.
Yes,
Yeah.
Your Lordship. And therefore, I have discharged the burden of proof also. And accordingly, the compensation ought to be enhanced.
Take the order. Heard submissions from both the parties. I am of the considered opinion that the district commission has not appreciated the medical complexities and nuances in radiological examinations. Particularly when there is lapse on the part of the patient in complying with the review request. Considering the health condition of the child, I think we need to follow a humanitarian approach. Full stop. Accordingly, I allow the appeal filed by the doctors and at the same time, I allow the request for, I'm sorry, I recognize the decision of district commission As a result, the amount has already been paid.
Yes.
Whatever the amount that has been paid by the doctors may be kept with the parents of the child. This is not to, full stop. This is not to be considered as a contradiction. This is not to be considered as a contradiction. On one hand, no negligence on the part of doctors. On the other hand, whatever amount the doctors have paid, that will remain with the child, parents and the child. With this particular matter is closed.
I'm grateful. Grateful.
Number 4, RP number 255 of 2025, Hospital ABC versus Mr. X, counsel for the petitioner, Advocate Radha Pyari. Passed over matter.
Because of the paucity of time, I think let's take up next week. Today, maybe next week we can.
Yes.
Thank you. Yes, rising.
Silence.
You have to this. Yeah. Yes. Water bottle.
I now request Dr. Madhusudan Karignur sir to felicitate our moot court team members. I request the members to please stay on the stage. Dr. S.V. Jogarao sir, Dr. S. Radha Pyari ma'am, yes, Yashwant Prasad, Arun Kumar, Memory Fani, Nirmal, Kavana, G.S. Nagendra, Ria, Mrs. Saujanya Prasanti, Ramakuri.
Good evening, friends. I thought I'll just say a few words. On behalf of myself and my team of legal excellence attorneys, we are so grateful to Karnataka State and particularly IMA Gadag for hosting this conference and giving us an opportunity to associate, involve, and in the process learn a great deal. I'm thankful to all my colleagues as well. When Dr. Pavan Kumar Patil has told me the diary dates and declared a holiday for legal excellence attorneys, like the KMC, the way they have declared a holiday, for example, yesterday. And we came, I think, day before yesterday evening. We'll be leaving now. Particularly, I want to thank Dr. Pavan Kumar Patil and Dr. Shweta, because I know for almost 1 month or so, a lot of, coordination, problems, problems, not our problem, moot court problems, with generation, so many things, even the infrastructure, taking the suggestions, etc. We are very, very thankful to you, Doctor. Naturally, Dr. Pavan Kumar Patil, we will be meeting every Saturday because of KMC proceedings. And thank you so much. And more particularly, I felt very, very happy when the law minister has come for inauguration. In Gadag, I don't think any event can take place without his participation, because the way he has the kind of visionary. Thank you so much once again. Thank you. Yes, yes. Thank you.
So with this, we come to the last part of the program, the panel discussion. I thank all the delegates and all the panelists as well for the patient waiting. I call upon Dr. Harsha, who is the moderator for the panel discussion. And let me introduce Dr. Harsha. Dr. Harsha is a surgeon, and also he's done FALS and LLB. He's an EC member of KSC ASI. He's a managing director of Shivakrupa Multispeciality Hospital and Research Center at Harpnalli, Vijayanagara district. He's secretary IMA and Surgeons Association, Vijayanagara. I welcome you, sir. He's made a lot of preparation for this panel discussion. Next, I would like to call upon the panelists. Majority of the panelists we already know. We have introduced Dr. Ravi Shankar, Dr. Shivkumar Kambar, Dr. Doriraj sir. But 3 panelists we are yet to introduce. First of all, Dr. Vivek Dore sir. Yes. Vivek Dore sir will be joining online, but I would just like to introduce him. Next slide. Next slide, please. He's the former president, Karnataka Government Medical Officers Association. He's won many awards. At present, I think he's the Deputy Director, Arogya Sabha, Sauda, of Department of Health and Family Welfare. He has significantly contributed in digitizing and reforming KPME Act, PCPNDT, Artificial Reproductive Technology and Surrogacy Act, along with POCSO. Next, we have another eminent panelist with us. Next slide. Dr. Asha Nervi ma'am. She's the head of Department of OBG at SDM Dharwad. She has completed her UG and PG from MRMC Gulbarga. She's a postgraduate teacher. She's a UG and PG examiner. She's been a past president of, I think it is HDOGS. Her areas of interest are high-risk obstetrics, diabetes in pregnancy, metabolic syndrome, vaginal surgery, myomas, and adolescent PCOS. Next, we call upon another panelist, Advocate N.C. Mohan sir. He's a practicing advocate before various courts, trial court, appellate court, high court, consumer commission, state and national medical commission for the past 27 years. He's had the advantage of studying human anatomy and physiology as a part of undergraduate course curriculum. He later on graduated in law with keen interest in medical malpractice litigation. He has a master trainer program in healthcare communication and certificate course in telemedicine laws. He has authored multiple articles in magazines like Tulanam of BSOG. He has been pursuing this specialty for the past 27 years. I welcome you, sir. I kindly call upon all the panelists to come and occupy your places. Dr. Ravi Shankar, sir, Dr. Asha Nervi, madam, Dr. Shivkumar Kumbar, sir, Advocate Doreraj, sir, and Advocate N.C. Mohan, sir. Now I hand over the stage to our panel, our moderator, Dr. Harsha.
Hello. Good afternoon, and it's actually late afternoon. Good afternoon and warm greetings from Indian Medical Association Harapanalli and KCSI Vijayanagara branch. It is with great pride that I extend heartfelt greetings. I want your little patience because there are very good cases which we have prepared, 7 cases, and they will give you lots of insights regarding judgments. It is with great pride that I extend heartfelt greetings from the glorious land of Vijayanagara Empire and the magnificent heritage site, a symbol of our rich legacy, resilience, and cultural grandeur. Along with that, I bring some medical legal wisdom. Before I begin today's session, let me express my sincere gratitude for the kind introduction and the opportunity to stand before this esteemed gathering. It is both an honor and privilege to be part of this academic celebration, a true intellectual feast. We have attended so many conferences, but this is a special one. A special thanks to organizers IMA Gadag, the dynamic president and ever efficient organizing secretary, and the dedicated team working behind the scenes, especially Dr. Pravan Patil sir. His leadership and efforts deserve applause. Let me also take a moment to highlight an important truth. In a democratic nation governed by the rule of law, a strong and united IMA is not a luxury, but a necessity. Without an active IMA like Gadag, the fraternity, medical fraternity risk marginalization, vulnerability. Ultimately, the public will bear the consequences, as we all understand how public will bear the consequences. Let us never forget the weakened medical community leads to weakened society. Today, more than ever, we must stand united as doctors, advocates, and responsible citizens to defend our rights, uphold our duties, and protect the sanctity of our profession. For that, IMA is required. A heartfelt salute to the visionary leaders and dedicated members of this association who have tirelessly worked to forge bonds and build bridges between the medical and legal communities. And dear IMA members, please reflect deeply. The first and the most meaningful question is what the association has done for us, but what we have done for the association. That's why we are all here. If we nurture and protect IMA, rest assured the IMA will always stand with us. Finally, I have the honor of moderating today's panel discussion. I have wonderful panelists, experts. I warmly invite you all, and you can participate very freely. If you have any medical legal questions, doubts, big or small, please don't hesitate to ask. This is your platform, safe space, and a moment to engage. Thank you. Let us begin. No issues. Mic. Okay, it's on. Dear friends, I just introduced myself. I'm going a little bit faster. So panelists already been introduced. The data, what data says? The annual medical practice incidence is approximately 52 lakhs. Negligence related deaths approximately 98,000 per year, which is surged by 110%. Litigation increase is 400% in recent years. Before I talk, all these, whatever the presentations have happened, have actually threatened all of you. I know it. Because the way the presentation has been put forward, looks like we are in the clutches of litigation, but it is not. I'm going to conclude here that we are not in trouble. And I am also going to prove on this stage and forum, how we can defend ourselves, how we can prepare ourselves. And medicine is more protected than punished. And the actually hotspots are Punjab, West Bengal, and legal climate, rising insurance, all those things. Over 12,000 medical negligence cases are filed annually in India. Only 30% of doctors in India have adequate medical indemnity insurance. 2022 survey, Indian health professionals, nearly 60% admit they were unaware of laws governing medical practice and documentation, as said by our Honorable Minister. Legal wisdom from court to clinic, all enacted laws must operate within the boundaries set by the Constitution of India. State cannot write a law which violates the Constitution of India. No individual is above the law, and ignorance of law is not valid excuse. Any action not explicitly allowed by law is deemed unlawful. Every person is entitled to equal treatment under legal system, regardless of status, class, and background. Legal process must follow the principles of natural justice, including fairness, impartiality, and right to be heard. Part. Laws are originally framed by legislators and are subsequently interpreted and elaborated by judiciary through case laws. And why this slide is important is there are some kinds of notices you will receive sometimes. They're all against these things. They have never called you. They have never asked you. They have directly taken. Recently, they have shut down the hospital. This slide. Authority can make mistakes. This is also very important. Mistakes is like stupidity, where authorities, you think that DHO cannot make mistakes. You think that advocate cannot make mistakes. You think that KMC cannot make mistakes. They can make mistakes. So, meeting a good advocate and knowing about law is very important. You may not have done any mistake, but still you may be punished. Okay. Unless you approach an advocate, you will not know the illegality. Being aware of law is becoming more important nowadays. From while I was discussing with my friend, after 2000, after the year 2000, who have done post graduations, they are a little bit more aware. Before 2000 people, they don't even write the notes. Being unaware professionals will be stupid. So those who are not aware, who have not attended, who have not, it's indirect meaning that this medical legal conference has a very good message. They may be very much perfect in their profession, but still they don't know means they cannot execute. They will do definitely the mistakes. Recent cases, sitting here are the seasoned professionals are here to share valuable legal insights, listen and learn from them. Legal guidance from experienced mentors is crucial. You can't understand within 1 day, 1 month, 1 year. It takes some 10 years of dedicated study to understand law. Law is as deep and as wide as medicine or bigger than that. Never miss a medical legal masterclass, which is essential because that's not been included in our syllabus. None of us know about it. Medical colleges teach skills, but not legal precautions. Even minister has pointed, Yogananda Reddy sir also so many times told that some book with a limited syllabus has to be made so that graduates before coming out should know, before registration should know. Coming on to a case number 1. This is a case, Karnataka High Court, where Dondiba Anna Jadhav versus Taluka Health Officer Gokak, 21st of February 22, which was author of this judgment was Nagaprasanna, Justice Nagaprasanna, and the bench is Justice Nagaprasanna, sir. Petitioners, Nitin Jadhav, Dr. Mrs. Padma Nitin Jadhav. Those are the couples. Doctors, medical practice running Sri Donda Anna Jadhav Memorial Hospital, Gokak. Respondent is state of Karnataka. It's a criminal case. Respondent will be the state, represented by Taluka officer of Gokak. Court is High Court of Karnataka, Dharwad bench, Honorable Justice, in front of M. Nagaprasanna, sir. Case type is criminal petition number, so and so, under section 482. Relief sought is Taluka health officer visits the hospital and conducts an inspection on the allegation that the hospital has not maintained records. As required under the Act, equipments and documents were seized from the hospital. After the registration of the said complaint, the magistrate, jurisdictional magistrate records sworn statement and takes cognizance. That means he will agree that there is some offense of the offense and punishable under section 22 of the Act, rule number 9. It is this action of the learned magistrate that drives the petitioner to the court, because magistrate has taken the cognizance. So there is an order that the party can be arrested. Relief sought was quashing of criminal proceedings. Section 23 PNDT Act and rules. I will come to that. Preconcept PCPNDT Act, section 17, appointment appropriate, that is section 22, cognizance of offense. So we have come to know that case. The case is, I'll just go back. The case, relief sought, the case is, there is a hospital in a Taluka center where the PCPNDT, under PCPNDT, they are also performing the scans, but suddenly one complaint was given to Taluka officer, and Taluka health officer directly comes and seizes the records and also seizes the machine. So now the panel is open for discussion. And now comes the PCPNDT Act, section 17, appointment of appropriate authority, and section 28, cognizance offenses. Whether the Taluka officer had jurisdiction to file the complaint under PCPNDT Act, madam.
Am I audible? Thank you, Gadag IMA, for the opportunity, and thank you, sir, for being a participant, allowing me to be participant. I feel what the Taluka officer went and did, I feel it is wrong, because he is not the authority. The authority lies with the assistant commissioner, or the one who is appointed by the
assistant commissioner.
Yes, sir. He cannot come and just verify things and ask them to close.
Can assistant commissioner appoint THO to do this job?
Assistant commissioner,
I'm asking you, can he subdelegate the THO to do this job?
If assistant commissioner can delegate, I think, according to me, but as far as I know, assistant commissioner is in charge of doing this.
That is right, madam. I ask Doraraj sir to put a light on this. Can assistant commissioner appoint another person to do this job?
No. So that delegation is not granted under the statute. And the recent Supreme Court judgment by Mr. Justice Abhay Oak, where he defined the authority under PCPNDT Act, all the 3 members of the authority should go for inspection. And 1 person going for inspection is also illegal. So with that, it is settled principle in one of the matters that we are doing in Gulbarga, that the inspection was done at the behest of some other complaint who was not even related to authority. I don't want to take the names of the clients, but now the law is very well settled that the appropriate authority which is there, which consists of 3 members, they should do the inspection rather than getting delegated. Even single person doing it is called as illegal now.
Any question from the audience? You can ask any PCPNDT question, because I see this case has been presented. And if I keep on talking, you will not get the opportunity. You can ask. Just 5 minutes. We'll move on to next case.
The gentleman there wants the mic. Mic ಕೊಡಿ ಸ್ವಲ್ಪ ಅವ್ರಿಗೆ. Sir, in the meantime, if I may just share my thoughts on this. Here, the Taluka health officer not being authorized under the statute, he has exercised the jurisdiction not vested in him. So plain and simple, if he is not authorized, he is not supposed to do it. And therefore, the court has the right to strike down whatever action he has initiated by going to the magistrate and filing the complaint.
Thank you, sir. Actually,
even the court would not have taken the cognizance of this case. That is the reason. The court would not have taken. I'm really surprised how the court has taken the jurisdiction like this case. Probably THU has no authority to seize and whatever it is. But
so
it's a good case.
nowadays, under PCP and DAY Act, we are all, including myself, we are facing so many difficulties. Even authorities also make mistakes that you should understand. When they do not have jurisdiction or authority, if they do this, then it becomes illegal. And actually, the process where you have to go and face the district commission, and then again you have to go and face the district court, maybe high court. This is a normal process. You should not be worried to do all those things. Maybe 15 days, 10 days, your scan center may be closed, but still you have to fight. You should not be worried too much. Like, see, it's not said and done. Even they do not know the law. Okay, so you should not be worried too much. So law is of highly protective for us, even PCP and DT law. But you don't. Recently, I was discussing that there are doctors who do sex selection. Such kind of things should never be done. So such things we should come out. Ethical practice we should do. In spite of doing ethical practice, something happens like that, then court is always with us.
Three members, sir said 3 members should be doing inspection. Who are those officers? Please let us know, sir.
Section 30 of the PCP and DAY Act, sir. Kindly take a look. Okay. Section 30. Sir, it is the authority defined who all be the parties into that authority. Assistant Commissioner and DHO, and there is another one I'm a little forgotten on that.
Sir, if I elaborate, it is actually
District Advisory Committee will have a gynecologist, a pediatrician, genetist if in case, and DHO is only a member secretary. He just provides the office, but the whole show is run by this advisory committee. And as such, there was a case in one of my place also. The inspection and monitoring committee will go for inspection. They would have had a delegation of powers from the deputy commissioner, who is the appropriate authority for that particular district. In that case, they can inspect, and they have filed a case, and it was there. And it's been admitted, and we proceeded with the case.
Sir, there is nothing, no clause like that, like deputy commissioner can delegate someone else. State government has to notify it in the
inspection. For inspection.
So inspection also,
and monitoring committee, they can go for inspection.
First, district has to form 2 committees.
Advisory committee and DAMC.
And okay, without forming those 2 committees, the act has no force. Act has no force at all. And everything done by them is illegal. That's it. And that committee has to be formed using the stakeholders.
Yes,
so stakeholders should always insist on doing such things. Same thing has happened with our KPME Act. Same thing is PCP and DAY Act, where we don't have a committee. When committee is not there, how will you execute it?
Sir, excuse me, sir. This is happening in all the districts, sir. 1 minute. This is whatever they done, not DHO visiting. Even actually, district commissioner is the appropriate authority, and district commissioner is again handed over to AC, sir. AC is handed over to again DHO. DHO is handed over to program officer. Program officer is handed over to Taluka. This is happening everywhere.
Subdelegation
it is not at all. It should not happen.
No, sir. We are discussing only we are limited to case only. We are not going. No administrative loopholes. We are not going to talk here.
What is the
DC also has no authority because he has the notification says only assistant commissioner AC, and government has notified it. Government has to again specially notify that other officers. It has not notified it till now. There is no further notification.
Sir, PCP and KPME is different. 1 minute. PCP and KPME total different acts.
Yes, sir.
KPME, there is a definite delegation by the DC to form a team to inspect.
Agree, sir.
That is not there PCP and DT.
Yes, sir.
Very clear.
Yes, sir.
Second thing is, all the way we talk about ignorance of law is not acceptable. What is the punishment for the THO who is ignorant about the law?
Sir, they are all protected from their actions because that's what even our advocate sirs can put a light on that, because what are the actions done in good faith?
Because
Actually,
of
the
this,
good faith rule comes under rescue for them. Even same good faith rule comes for our rescue.
Unless-
Whatever said and done without any proper intention.
Unless malefides are shown, they are protected under good faith.
Good faith rule will come into action because there is no malified intention. Someone has given complaint and they did not know that they have done it, and you have to challenge it. You see, there is always open court for you. It's not that court is not hidden for you. You have to go to the court and challenge it. That is what the thing. Even government officers also suffer from problems like transfer problems. They also go to the court.
What I mean to say, all advocates are here, sir. Suppose what is my thinking? If court, whatever THO has visited, is suppose court, what action can be taken to this THO? Sir?
No, sir.
No action can be taken.
Judiciary, police officers and government officers, okay, they have got certain, I would say immunity for this, so that you cannot go against them. And mistake is happened. If at all you want to really go for it, there are some remedies for them. You can file a case against them, but I don't think anybody will so far as file a case.
Sir, if you prove malified intention
Sir,
from
may
them,
I
you
just
can
throw
go
a
against
light
them.
on?
So we'll move on to next case.
Yeah, it is just that the matter can taken up to the superiors. And if malifides are imputed, then if the senior takes action, sanction has to be obtained under the section 91, and then criminal prosecution can be launched against the Taluka health officer. That is the
yes.
process. Unfortunately, in our country, it rarely happens or doesn't happen at all.
That won't happen. Actually, there is a process, as sir said. Complaint. Actually, state government has to give a clear-cut permission to file a criminal petition or civil petition, whatever the damage which has happened. Sanction has to be obtained from the government. Yeah, DC can initiate, but usually they will protect their officers. All of us know. The second case, Supreme Court of India, Chandarani Akhori versus Methu Setupati, 20th April 2022, recent one. Justice Ajay Rastogi has given the judgment, and bench is Abhay sir and Rastogi sir, justice. So appellants are Chandarani Akhori and her children. Respondent is the doctor and other treating doctors of the hospital. Supreme Court of India bench, Justice Ajay Rastogi and Abhay sir. Relief sought is compensation for alleged post-operative medical negligence under Consumer Protection Act. Key legal issues are Consumer Protection Act 1986, transplantation of human organ tissues 1994. Key legal issues again, whether there was a post-operative medical negligence in the treatment of Naveen Kant after his kidney transplant, who is deceased. The kidney transplant was successfully performed by qualified and experienced nephrologists. And the patient was under post-operative care and was discharged on 24th of 1995. Complaints included persistent pain in the forearm, which later developed into cellulitis and septicemia. The patient eventually died on 1996, February 3, November and 2 February. Evidence is appellants produced two witnesses who were not nephrologist experts. Actually, they have, in this case, appellants, that is those from whose side the party has died, that this renal transplant patient has died. They have produced two witnesses. They were not nephrology experts. And whereas respondents, that is the doctor who has performed the kidney transplantation team, has produced nephrology experts who testified about the standard of care. Now, Supreme Court relied on expert testimony and previous judgments. Jacob Matthews, State of Punjab. Okay. The final decision on no evidence of gross negligence, death was unfortunate but not attributed to lack of reasonable care. Appeal dismissed and no cause. And I would like to ask, sir, what are the components for to prove a case of negligence?
See, there's a duty of care, breach in the duty, then the causation and the damages. In this case, probably the surgery took place in the month of November. And since the patient post-operatively had a swelling in the elbow, maybe because of the infection, IV line, and he went into septicemia, he died in the month of February. So they believe that post-operative complications, he died it. But Supreme Court relied upon Jacob Mehta, Bullen test, and another two cases wherein ultimately the expert opinion was sought. See, the doctor's team who did the operations, they produced an expert opinion stating that both of them were nephrologists. They said that yes, the surgery was done as per the TOHA Act. The hospital was very well registered in the local vicinity or authority. There was sufficient infrastructure and post-operative care. And any death cannot be post-operative or on table, cannot be taken as a negligence, whereas the complainant failed to produce evidences or testimony stating that there was a negligence of post-operative which led to the death. But in this case, okay, National Commission has taken a good view, and the Supreme Court also has not taken a country view, and it upheld the decision of the National
Sir, I
Commission.
would like to interfere a few points here regarding the there are few things Supreme Court has discussed regarding registration of the hospital for transplantation under 1994. One thing. Second is post-operative care was taken place in other hospital other than this hospital. Post-operative care was taken first up to discharge was this hospital. After discharge, once more he had some complications. Then he was treated in other hospital. So two things. And other thing is those two things. And patient's death alone is insufficient proof of negligence, court has pointed out. I would like to ask the panelists, how in this case, I want to punish the doctor. In this case, what he should have done mistakes for in this particular case to get into the clutches of law. Because now it is very clear that the hospital is registered and he is a qualified nephrologist and he has done all the things, but in spite of all the things, patient has died, but he has put up with the medical experts, and also they have opined that there is no negligence. Okay, these four important points. So based on these things, what mistakes the doctor would have done from the registration point till the post-operative care, so that he could have been get caught in the clutches of law, so that he would have got the punishment as well as criminal negligence. To the panel, please.
Coming to the point of giving service, if he has had total disregard to the patient's complaint, though evidence on the face of the record, and if such is reflected by the case sheet, that there is that the case sheet shows that one of his own colleagues has written that there is onset of infection and no action has been taken by the primary consultant, he would have been imputed for negligence. That is one thing. Non-registration is another thing.
Not registering the hospital.
Registering the hospital, that would have been, he would have been crucified for that. There was no way out for a lawyer to represent and say he did it in an institution
and not qualified, sir. If you were not
appropriate
qualified
qualification,
person.
appropriate qualification, and very importantly, I have noticed that some of the senior doctors have not registered their postgraduate qualification at all. I had one client who had served in the government, and despite having served in the government, she also doesn't remember how and why her postgraduate qualification had not been registered with the KMC, and she had also retired by then. Only her MBBS graduation was registered with KMC. That is one other big issue that, and the doctor must remember that they must update all their qualifications with the KMC. It rarely happens. Even I was surprised how that doctor had not registered her DGO, even after she attained the age of 65 years and she had finished government service and she was.
So what is the position of KMC right now? Whether we have to re-register it or not? Whether someone who has not registered and who has operated, what is his position?
Sir, if you don't register...
Not renewed.
Yeah, no. In this case, if you don't register your specialty or specialty in the respective medical college where you are practicing, when it goes for the authority, KMC, to look into the credentials of the doctor, so KMC or any council for that matter, as per the records available with us,
unauthorized,
is a MBBS. Okay. And in another, one more commission has said that the same thing can happen over there in, I think in the UP or MP. That time they produced, the doctor produced the credentials of the degree certificate, post-degree certificate in that university. So that way there are contrary views are there. But in this particular case, if the post-operatively, if the patient is not being managed, which are led into the septicemia, probably the team of doctors who are looking after us would have been responsible.
Sir,
But
my
there are
question is, my
SOP.
question is very
Yeah,
specific.
yeah.
If KMC registration is not renewed, he is registered, his degree also registered, but not renewed. For since 5 years, it is expired. What is the position?
I think Dr. Yogananda is the right person to.
Sir, Dore sir, please.
Yes.
Yeah, he is part of KMC.
So this is what the dilemma we are at. The renewal per se is the provision which is provided under the Act. The renewal is mandatory as per the Act. But practically, how many are doing it is the question. The question which was posed in the court during this renewal issue came in election matters. If the renewal is not made, can you take away all those doctors from practice? How many percentage will be left for practice to public health?
No,
It's a big question that we need to answer.
I am
But the
not- sir,
statute says,
I'm not asking from defense side, sir.
no. But the statute says renewal is mandatory.
So all of us should. Sir wants to answer. Sir wants to answer.
Mike Kodi Solpa.
So because
Please bring a mic.
registration of the hospital is also very, very important. MTP Act also registration is important. PCP and DT Act registration is important. Organ Transplant Act registration is important. KPME registration is important. Without that, if you do, you are got into some trouble. And the case is brought in front of the court. Definitely, we will be in trouble. Unregistered place, illegal place. That's the end of first thing. So, sir,
Yoganand Reddy wants to say something.
Sir, please.
2024 amendments, the renewal section has been removed from KMR Act. Now the renewal is as per the NMC guidelines. NMC clearly says that all the existing doctors have to get unique ID number by entering into their portal. From then onwards, 5 years. And they have not yet made any specific regulations for the procedure of renewal. They are not just sticking to continued medical education, it seems. They are entering into one more phase of continued professional development, CPDs. So that is in the process of lawmaking.
So what is the current position?
Current position,
What people should do sitting here? Sir?
as of now, the Karnataka Medical Registration Act do not have the section or the clause related to renewal. at all.
It's clear to
And-
the crowd.
But please take my point. If any complaint falls or comes before this amendment, then your renewal is mandatory as per is. Suppose the complaint is of 2023 when renewal is mandated. If complaint falls on me today, if I am not renewed, the amended section applies.
So please note this very between the lines and between the words. Law is read between the lines, between the
Sir,
words.
is it cause of action or for the date of filing of the complaint, sir? Say suppose as on the date of cause of action.
Discovery rule, all of us know discovery rules.
Corollary to that, he said there is a cause of action. At the date of cause of action is not renewed. Okay, case is not filed. Right?
Yes, sir.
1 year back he has renewed. Patient goes to the court today. What is the?
Sir, position is court has got the power to condone. Always, it will condone. Surely, discovery rule, he will say, he will pray that I didn't.
As far as renewal is concerned, the cause of action is very important. If,
Hello.
if something has happened in the year 2023, 23, if somebody files a case within 2 years, that is 2025, that is after the amendment, the earlier act of mandatory renewal applies to you.
So
there is one recent judgment just to.
He is
enrich the
illegal
audience.
then.
I came to read this judgment very lately. I don't remember the names of the parties. There's a mere non-registration of your additional qualification will not infer negligence if you have had the adequate qualification.
Agree, sir. Now
we'll see, even in, as Mohan's advocate said, that alone will not form the merit for adjudication. That may be one of the issues. Just not renewed.
It is violation of code of medical ethics, but
Ethics.
not negligence.
Negligence.
That will not attribute to the negligence issue.
No, standard of care is maintained means usually it will not be, but standard of care is also deviated. Along with that, registration is on that. They are go become contributory for definitely. Sir, next question in this same case regarding qualification. Any one of you can elaborate regarding a qualification of a doctor? Because MBBS people will be doing something, MS people and MCH or DM people are doing something. So can you just elaborate to the crowd what they can do, what they should not do?
I think a classic example would be that of hysterectomies being conducted by general surgeons. I think the NMC later made it clear that it's only obstetricians who can conduct hysterectomies. So therefore, there are certain gray areas. Super specialties have left no place for the general surgeon. Proctologist you have dermatologists. So a general surgeon virtually has nowhere to conduct a surgery going by that measure. So it's a matter of argument. And of course, where the law is clear, it is clear.
If in case, I just want to just put a little bit of word on this. If in case it is there in your syllabus.
Yeah.
The following procedures are mentioned in your syllabus. Even a MD fellow or a MBBS fellow or otherwise even a MS fellow, advocates can definitely defend. First thing. Second is, you have maintained logbook of cases. You have done such cases for so many cases. And nothing has happened. And this case, something has happened, but still you are within the standard of care. Then we can defend. Anything to add on, sir?
Sir, what you have said reminds me of one more thing. If it is part of your curriculum, if you have had adequate exposure, third thing is very important. If it is not prohibited by any other law. For example, hysterectomy being conducted by general surgeon is now prohibited by law.
Yeah, I do agree. But in a place like Taluka places, okay, where you didn't get the qualified gynecologist, but the general surgeon has been doing since so many years, okay, hundreds of cases have been. But if at all he brings to the notice of the patient, if the patient himself wants this particular surgeon has to be done, it has to be recorded, and he can definitely do it. He can definitely do it. There's a contrary to that, but he can do it, provided the patient agrees for the surgery getting done by him only. And also he tells to the patient relatives that, yes, this is the case. He can go ahead with that. There are another 2-3 judgments.
Sir, you mean to say in the consent, we can give a disclosure?
Yeah.
Like I am so-and-so, but the following procedure should be done by so-and-so persons. And I am also entitled to do this, whether you are ready to appoint me for this procedure. Can we disclose that in the consent?
Not at all. Such disclaimers are not allowed in the consent. No.
Not in the consent.
Sir, if go by this law, what is the job of the MBBS doctor?
No, thing is, sir, NMC has not clearly stopped anybody to do anything because EMRB board has no rights to curb the syllabus. It has no rights. It has acted excessively. I read some EMRB book or something where it has crossed excessively. Nobody has challenged it because UGC Act, otherwise syllabus is decided by the university. UGC Act is a peculiar special act. So NMC has got its own ways of doing the things, whereas the UGC has got its own ways of doing the things. When that is been included, for example, MD General Medicine and DNB General Medicine. DNB General Medicine has different curriculum, whereas MD General Medicine is different curriculum. So we can't go by asking a general MS from India or MS in 1994 from Mysore University, MS in Rajiv University. So decision can be taken only after looking into the syllabus and is logbook. Otherwise, decision cannot be taken. This is regarding qualification because lots of superposing gray areas which we came across in giving some legal opinions. So what do you say, the panel? What decides the qualification?
No, it is very
Is it
clear.
the degree decides the qualification or syllabus decides the qualification?
It is very clear. It is very clear that MS general surgeon is doing a hysterectomy. That is the argument now. Just reading about the problems of uterus and hysterectomy as a syllabus is not enough to be skilled enough to be doing hysterectomy. how many hysterectomies you have done after your MS is not an issue. How much your logbook says about your hysterectomy training during surgery. That becomes a skill. So who is going to give you the authority or check your logbook? Where is the logbook? In the current curriculum, as you all know, how many of our trainee surgeons, post-graduate surgeons are allowed into the gynec courses? How many of them are given first-hand experience onto the uterus? Almost nil. Then that being the case, very much known to the medical fraternity. And when that being the case, when so many gynecologists are available outside, what right you have got to attempt to do the hysterectomy?
Unless it is an emergency.
Unless it is an emergency. This is how a court looks at.
So
Not at your qualification, not at what NMC case law.
So hysterectomy is totally not allowed in the any syllabus, sir. So MSLC syllabus does not have hysterectomy only. It doesn't have. There are other procedures like upper GI endoscopy, lower GI endoscopy is mentioned. Laparoscopic cholecystectomy is mentioned. Even general medicine procedures or some gastro procedures are mentioned. But when it is not mentioned, it is impossible to defend. If it is mentioned, somehow a advocate, I am just giving a clue to the audience, because when they do some mistakes, there are some clues for yourselves to check your syllabus, curriculum. If it is mentioned, you can do it. See, for example, knee replacement surgery, which was not at all there in old syllabus, exactly some 15 years back. Now they are doing knee replacement, orthopedic surgeon. That is called elaboration of syllabus by associations. So such things are not at all discussed in Indian case laws. They are discussed in UK case laws. So that might of such kind of cases are not being faced by the boards even right now, but maybe in future days. I would like to put a shine on that, because not degree, name of the degree, it is the syllabus which is going to, and the which first thing is it should be there in the syllabus. Next thing is he should have done that case, maybe training time or otherwise also, because training time, some medical colleges do not have cases at all. Even the syllabus cases are not. Can you mandate them to bring all the cases and show? No. So the syllabus is its duty to learn, somehow get associated with the people who do the same job and learn it. May not be in the training period, maybe after a training period. This is what is, there is a judgment from UK courts. So coming on to the, we'll move on to the next case, because it is, so important legal notes is doctors may provide reasonable care, not guarantee the recovery. Expert evidence is critical in medical negligence cases, because the court has disposed that prima facie cannot be taken in especially criminal negligence suits. Post-operative complications do not automatically imply negligence. If they are written, mentioned in your textbooks, the following complication can happen, death can happen. Spinal anesthesia is given, death can happen. In even 0.0001%, if it is mentioned in your standard textbook, nobody can punish you. Provided you are done to save the life, Article 21. To save the life, you have done, what is the process to be done as per the Boehm's test? You have taken all the care to save the life after having that effect, so nothing will be done. Hospitals performing transplants must register in this particular case. The court acknowledged that the trauma of the petitioner, but emphasized legal limitations on the liability. There was no award. So there are, because medical negligence is a very common thing, I wanted to just put some slides like Canterbury yesterday told Bolam, and then Rowe and Chester, Montgomery. And Indian cases, you know, landmark cases like Samir Kohli, Jacob Matthew, all of you should read. Kunal Saha, Krishna. Where I can get, you can ask me. All these judgments are available online, free. What you should do is you download it with your PDF. After downloading, what you should do is go to OpenAI, ChatGPT, paste it, and ask specific question regarding analyze this case and give me notes. It will give you 20-line notes. You read it. That's enough. Hardly it takes 10 minutes to read one case.
After you read the 20 lines, you better go to an advocate. Don't depend on ChatGPT. I promise you, I promise you, you will end up in bad shape if you don't consult a lawyer. There are different ways of interpreting things. AI cannot do everything and anything. Dr. Yoganand Reddy wants to say something. Sir, Panni sir, please come. You will be actually enriching the audience. It's very important for you to participate. Panni sir, please come.
Please.
Because we will have the right perspective.
Sir, lots of things.
Advocates in ಎದುರುಕೊಳ್ಳೋದು ಬೇಕಾಗಿಲ್ಲ sir, definitely
ಇಲ್ಲ
case
ಸರ್ ಆತರ ಅಲ್ಲ. This particular issue
don't let you
that
down.
Dr. Yoganand Reddy spoke about the 2024 amendment. I was personally not aware of it.
See, what is Bolam?
Section 19 is not touched in 24 amendment. Section 19,
Which one, sir?
KMR Act.
No, you are asking a judgment here or anything else, sir? No. This was just we were just stressing on Bolam's test. Bolam's test. A few of friends were not really aware what was Bolam's. They were asking. Sir, any one of you can just tell in simple words, just 10 sentences. What is Bolam's?
Conduct of a reasonable man. ನನ್ನ ಕೊಲೀಗ್ಸ್ ಏನ್ ಮಾಡ್ತಾರೆ, ನನ್ನ ಗ್ರಾಜುಯೇಷನ್ ನನ್ನ ಪೋಸ್ಟ್ ಗ್ರಾಜುಯೇಷನ್ ನನ್ನ ಜೊತೆ ಓದ್ದವರೆಲ್ಲ ಏನ್ ಸರಿ ಅಂತಾರೆ ಅದೇ ಸರಿ. ಅಷ್ಟು ಸಿಂಪಲ್ ಆಗಿ.
MBBS doctor ಹೆಂಗ್ sir Bolam's how you apply Bolam's to MBBS doctor?
For any
MBBS panel, there will be 5 MBBS doctors sitting. They should agree that this MBBS doctor has done what we are also doing. MS doctors or those 5 MS doctors should agree. Yes, the person who has done these mistakes, it's not a mistake. We also do the same. MCH doctors, MCH panel. DM doctors, DM panel. So Bolam panel can also be challenged.
That is where Bolito's principle came in.
Yeah, Bolito.
The judge will be able to apply his own mind also. Whether
Challenging
what
Bolam
saying.
is Bolito, sir.
So 2 schools of thought per particular case treatment person. If the doctor follows one method of a treatment, that's what requires the Bolam test. If the 2 schools of thoughts, and if you follow one among them, that's enough for in the Bolam test.
Sir, we will move on to the next case. This is a case with a criminal liability. In those days, it was the section 304A, now 106, as sir said. Rightly, in this section, petitioner is doctor, who's a doctor by name Budwal, and the respondent is Gurpreet Kaur. It is a High Court, Punjab, Haryana, Chandigarh. Punjab, Haryana, it's in Chandigarh. Honorable Justice Singh Bedi. So crime number I told, quashing of complaint, summoned under section 304A. Who has put this relief sought was by doctor. The Gurpreet Kaur has put this case, 304A. Background of fact is Gurpreet Kaur's son Jagdeep Singh suffered an eye injury in 2015 and was treated by Dr. Budwal. Budwal assured there was no major problem, but later son lost vision. Another hospital diagnosed permanent eye damage. An artificial eye was required. A criminal complaint was filed under section 326, 304, 447, 504, 506 IPC. We will not elaborate all the sections. We will confine to 304A only. Legal grounds is section 304A was wrongly applied as no death occurred. And the Consumer Forum had already dismissed a negligence complaint in 29/9/16. The criminal complaint was filed the next day without referring to the forum decision. Key legal proceedings, Jacob Matthews was stated, Martin F. D'Souza was stated, Pepsi Foods was also considered as a precedent. High Court observed section 304 does not apply in absence of death. Magistrate issues summons mechanically without verifying facts. I just put for the first slide, authority also will make mistakes. Even judges make mistakes. Advocates make mistakes. Doctors make mistakes. But they are not punished. We are punished. Okay. They also make mistakes. You asked.
Sir, that's a wrong misconception. I am confronted by this question very often. Don't make that statement. Judges have been rusticated. They have pulled down. They have been forced to resign. Lawyers have been proceeded against in the bar council. It's a misconception, sir. Everybody has challenges to face in their profession. Nave yake, doctors nave yake, because you are all vociferous. We hear about you. And whenever there is a compensation awarded, it is widely published in the press. There are another 10,000 cases which are dismissed. That doesn't come to light. ಯಾವುದೋ ಒಂದು ಕೇಸ್ ಅಲೋ ಮಾಡಿ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಅದ್ ಮಾತ್ರ ನಾವೆಲ್ಲ ಓದಕ್ಕೆ ಒಂದು ಅವಕಾಶ ಸಿಗೋದು. ಅದಕ್ಕೆ ಹಂಗ ಅನ್ಸುತ್ತೆ ಅಷ್ಟೇ.
There are very few cases for which award is done. Just 2 to 3% cases the award was The another nine, as sir said,
See, and
97% dismissed.
very important, error of judgment is not wrong in your profession. What if the judges give a wrong verdict? It's an error of judgment. Error of judgment is not wrong even with regards to doctors also. Unless there are malafides. If there is an allegation that the judge has taken some consideration and there is some material indicating that, then of course.
Most of the times the clients are consumers, the complaint to the medical councils, but very negligible. I'm yet to hear the complaint to the Bar Council of India about the advocates. I think you agree with that.
Sir, number of cases
Totally
filed
agree.
against advocates in Bar Council versus number of cases filed in KMC.
So the problem is, we can afford it, sir. Doctors can't afford it. See, we are in the corridors in the court, so if an advocate is confronted with the litigation, it's very easy for him to defend himself. Absolutely, it's very difficult for a doctor to leave behind his practice because the legal arena is totally different.
Sir, we'll confine to this case again, Budwal. Here, what is the point, sir? Yes, sir. Sir, Mike.
Please pass this mic.
Compare, we can't compare how many cases are against doctors filed in KMC or somewhere, or how many cases filed against advocates. No, we can't compare like that. How many cases were filed against doctor in 1970s?
Sir, you're not audible.
How many
No,
cases?
he's raising a very important aspect.
How many cases were filed against doctor in 1970s, 1980s?
Why is it become like this now?
It is an evolution. See, it is of course the perception of the society. When the perception of society about doctors, that's what I always say, is changing very fast. The number of complaints filed against doctors are multiplying enormously. Similarly, perception of society about advocates or any other profession changes, it also multiplies.
So over a period of time,
we cannot compare, but all are being questioned under adequate authorities. Other question.
I agree with this point,
Just
sir.
to add, as sir took data to the past decades, so we should also appreciate one fact: the people are informed. Now there is something called transparency, and transparency leads to accountability. So it is not a pain. So you should rather seeing it is something evil is happening to the profession than to see through the past decades that more accountability is demanded. That is how it should be perceived.
Agree
Sir,
with that, sir.
unmet expectations are the emotional equivalent of broken promises, sir. Broken promises lead to disappointment. Disappointment provokes anger. Anger precipitates into medical malpractice litigation. See, patients come with a lot of expectation. Unlike before, you have a beautiful building, you have a nice lady welcoming you into the hospital. The expectation of the patient is big, and you are going to ask him or her to deposit 30,000 rupees at the very first action. Now he doesn't care. He doesn't come and argue with you. Why 30,000 rupees? Explain to me. He will simply deposit that. Expectations are high. That's why when things go wrong, it's easy for him to point the finger at the doctor. Corporatization of the medical sector, I think, has been the biggest reason. There is a disconnect between the doctor and the patient, while the patient identifies himself only with the hospital. Sometimes he doesn't even know who the consultant is. But if you ask him where he went, he will say, I went to X hospital.
So the message is doctors need to be little more careful and the way they behave with the patients, and also
interpersonal relationships, sir.
For
If you want to
interpersonal
avoid litigation, interpersonal relationships, very
and
important.
we meet large number of clients. For example, per day some 30, 40 clients, whereas the number of people who meeting the advocates is less. So there is a comparable questioning about the accountability. So there is an equal comparison of accountability as per the forum. So we'll move on to
Sir,
these
one more
case
last question. What is the percentage of a Bar Council of India? Okay, for that matter, issuing a warning notice or suspending from so and so is a professional service. What is the percentage from advocate's perspective in India?
Really have no clue, sir. But I totally agree with what Dr. Yogananda Reddy said. I don't think it's a right thing to compare your profession and being challenged and people going up against lawyers before the Bar Council. The scenarios are totally different.
So in this case,
here for us, the cushioning is that the judge was wrong and the advocate was not. But in
Specific, sir, in this case of Gurpreet Kaur, here 304A is applied. Yes, sir.
One more specific point I would like to
Mic
add
up.
at the juncture is
Mike, sir.
the quality of medical education, quality of nursing education, quality of others associated healthcare education has taken a serious hit over the past 30 years. I think everybody agrees.
It has deteriorated, sir.
Deteriorated. The line of separation, which was very, 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 very obvious between a complication and a negligence, when everybody is efficient enough to manage, has been now taken a serious dent because of inefficiency being creeped into the practice of medicine. This you take it very seriously. An inefficiency which has creeped into the practice of medicine, which caused negligence or which caused complication, is a very, very, very debatable, very, very
That is secondary
very,
to
very discrete event happening at this juncture in the medical. That is all because of compromise in the quality of medical care we give to the doctor.
training.
When I was a postgraduate, I was seeing almost hundreds of emergencies every day, every month. How many emergencies are seen in certain medical college? I don't want to name, even in a year. That's where inefficiency, negligence, complication now are becoming more and more obvious in nature. That's why the
So Penal is in the opinion that medical education standards has to be raised, training has to be upheld. So that
Actually disagree with that. What I did a postgraduate and what now the post, it's definitely it is good, sir. It's not that we can't say that it quality has not come down.
you can't compare with the institutes of where you practice.
Yeah, okay.
You have to take the institutes
Yeah,
of certain
probably.
nature, where I don't want to name, where quality has definitely taken a serious
Because
step.
NMCs have made it so much mandatory, this classes
It is all,
and
it is all on paper, madam. It is all on paper. You go, I will take you to institutes,
yeah,
a nursing
okay,
institute, a medical
probably.
institute.
Yeah, some
where
are there. You are right.
Department of Pediatrics, which is my specialty.
Yes, sir.
The daily outpatient runs in single digits.
Oh, okay. Maybe mine is a different.
Yeah,
opinion.
yours is a very prestigious.
Yes,
I think you,
yeah.
I are from SDM.
Yes, TM.
Yeah.
Yes.
You don't compare SDM with
Yeah,
other
okay. Yeah.
So that we need to look into. That's
Yes.
what
Yes,
we
yes,
need
there
to
are
engage. That's
engage.
what where we engage and then start reconsidering our status in society.
absolutely agreed, sir. The way the seniors teach the juniors, then only juniors can become the better doctors. This is also a message should be taken by the crowd. And regarding this case, which 304A cannot be applied just because that there was no death. When there was no death, the magistrate has simply taken the cognizance, saying that he has directly taken the cognizance. That has been like court has condemned that, and the whole proceedings was acquitted because even the negligence has happened, eye injury has happened, eye was lost, but the wrong section was applied. For that, even negligence case was also gone, and all the proceedings are quashed. He has to come fresh, which may not be allowed by the court. So going on to the next case, Rupali Mishra versus National Medical Commission. Here, petitioner, because there is a time shortage, another 10 to 15 minutes. I think this will be shall we take this last case, sir? This will be the last case, and we'll finish in another 10 to 15 minutes. So here, Rupali Mishra, owner of Rupali's Medical and Diagnostics in Delhi, National Medical Commission, respondent is, and court is Delhi High Court, and Justice Sanjeev Narula, writ petition. Background is 21st July, petitioner Babita Bishop underwent a DNC procedure at Dr. Mishra's facility. Procedures were performed by Ranjita. Mrs. Ranjita, she is not a doctor, was not a qualified doctor. Patient condition worsened. Then they referred to Safdarjung. Actions Delhi Medical Council found Dr. Mishra's guilty under Regulation 1.6 of Medical Ethics. Her name was removed from the state medical register for 30 days. Appeal EMRB NMC upheld the penalty. NMC also ordered clinic closure for 1 month. Just arguments. Petitioner arguments is NMC exceeded jurisdiction by ordering closure. no legal power under NMC Act. Closure would impact 56 daily. Undertaking given, Dr. Mishra would not practice during the suspension. Response arguments the center is registered under Dr. Mishra's name, hence closure was justified. Court's analysis is interim stay granted on closure order. There is a stay order for closure order, whereas the removal from register had already been implemented and was not disturbed. No provision in NMC Act authorizes NMC to close a clinic. Closure order deemed ultra wires and quash, similar to the first case where THO went and closed that clinic. Similarly, NMC also has got limitations. See, law has got limitations. I want the panel to discuss regarding the closure order by the NMC.
I think.
And before that, madam, before that, why they suspended the license of the owner? He has not done the MTP. He has not done the MTP, but there was a unqualified person who did the MTP, but still, but still Mishra was punished.
It was that center was registered under his name. Actually, the DNC was done by a maybe a PMS doctor. What I went through the case and led to a complication. If they wouldn't have been any complication, I think it would not have gone to this extent. But definitely, NMCA doesn't have any role to close the center. They cannot. They don't have any authority to close the center. So that was what I understood, and it's lawyer.
Provision for a closure. So that is the catch. Now, the other question which I take a cue from this case is, for the current scenario, is the integrated medicine. And in this case, it is the same integrated alternative medicine person who was practicing. Look at the circumstances in which we are debating about the quality of medicine, public health, and the motto of the IMA is public health. And I'm sure IMA has already taken that initiative of challenging that integrated medicine. Now, take a cue from this case, you punish that. Now, NMCA does not have the power because there is no enabling provisions to close that. Today, integrated medicine is made part of your. Where are we standing?
So NMC Act has got section 35, if I'm not wrong, 33 or 35. There is a provision for integrating the Indian system with modern medicine. There is an act. There is a subsection provision.
One clarification we need is whether that hospital was registered under modern medicine or a
modern medicine.
Modern medicine.
Modern medicine.
But how did that doctor enter into modern medicine hospital?
Sir, we all appoint VMS doctors. That is why I put this case. We all appoint unqualified nurses, and they do something, death happens, and properly if complaint is written against us with all the names and all those things and video recordings, what is our position? We have to think. What is our position?
Owner is responsible for whatever happens in his premises. He will not be going.
Death has not happened. At least death, if death happens.
Now, though NMC has no jurisdiction to close the hospital, if this case is properly fought under a proper authority, yes, hospital is going to be closed. Suppose the same thing falls in front of a Karnataka private medical establishment authorities, yes, this hospital will be closed.
So that act also should have been mentioned. That section should have been mentioned. Then in Karnataka, that would have closed. So I ask the panelists, what precaution Dr. Mishra should have taken to not happen such things in his clinic?
Once he is registered under the KPMA.
Ideally speaking, we are not supposed to appoint unqualified modern medicine people. Unqualified modern medicine people. That is ideal. If at all you want to appoint any alternate medicine people in your hospital, you cannot appoint them as duty doctors. You can play with
managers,
all these acts,
managers,
all
something.
this law of the land. You can play, but when you meet with negligence, it is very difficult to justify your vote. So the best way is do not appoint. Having said that, what is the answer for appointment of a duty doctor? When no MBBS graduate is coming forward to get appointed in a role area. See, this is the problem. The law of the land is being imitated by somebody else, having followed somewhere, but situation is not conducive to follow the law. So how
They-
court interprets is different now. The court will interpret in a different way now. You have a law, but situation is not conducive to practice that law. How court interprets, nobody knows. That depends upon the merit of a case. The
If
merit of
not
a
as a,
law.
sorry. If not as a
Just
duty doctor,
One,
probably the connotation physician assistant would do the trick. And such physician assistant cannot exercise clinical discretion. He has to simply follow the orders of the registered medical practitioner under the KMR Act.
But he cannot install the drugs.
One last straw that I will take from what Sir said is that demand and supply, quality. So where you can engage them, what will happen at the rural area? Who will take the decision? Now the trend, or rather the law demands, after MBBS there is a 1 year minimum rural service. Because people are not going to rural areas, this rural service become mandatory. Now, can you even there merit? A lot of issues are there. 2017 landmark judgment passed by Krishna Dixit is available. But today, alternatively, because doctors are not available qualified, can you send this alternative medicine practicing people because there is a demand?
No, sir, that is the intention of NMC to legalize them. And I am not for that. But what I mean is to legalize them so that even community nurses are being deported.
No. All of us are misunderstanding the concept of this integrated medicine. Concept of National Medical Council was to practice both on the same floor. Practice both on the same floor is different from integrating. Not mixopathy. Mixopathy, if you really read NMC Act, it is not mixopathy. It is practicing the different systems of medicine on the same floor. That's what is happening in NIMANS also. Even in NIMANS, the Department of Modern Medicine Psychiatry is different. Department of Ayurvedic Psychiatry is different. They're practicing different systems of medicine on the same floor.
Under one roof.
The option for the patient is to go wherever he likes. NMC never speaks about mixopathy.
That is the aim of it. That's what they wanted it.
I think
That's what it. Yeah. See, appointing them as an assistant duty doctor or a duty doctor, the functioning of that Ayurvedic doctor is the same. He follows the orders of the consultant. Okay, even in the Ayush, there is given a certificate as a doctor so and so. Okay, so assistant doctor or a duty doctor, I don't think it will make much demarcation however you appoint him because he follows the orders of the consultant.
no, sir, they are not entitled to install the modern medicine drugs.
One minute, I'll add. The integrated medicine people are now around 700 in Karnataka, as per the record. All of them are qualified and taken degrees very much earlier in 1980s. Probably, if I remember right, in the late 80s, the process of giving the degree for integrated medicine has been stopped. There are no integrated medicine means an Ayurvedic doctor learning the modern medicine for 1 year and coming to practice both by himself. That is integrated medicine. Such are there around 700 in Karnataka as per the list available with the government of Karnataka. They are allowed to practice on certain guidelines till their death. That's all. After that, this integrated medicine practitioners will not be available in Karnataka.
Thank you, sir. So
One more question to the panelists.
Sir,
What
Mohan
is
sir wanted to say.
obstetrician, madam? What is the role of that online e-Kalyani portal in
Sorry,
case
sir?
of legality, madam? E-Kalyani portal for MTP, it is mandatory now.
Yeah, mandatory. We are doing it. We are doing it.
Kindly throw some light on.
Yeah.
There is a portal, Harsha.
Yeah, definitely.
There is a
there
portal called e-Kalyani.
Yes,
If you don't
yes.
enter also, it is illegal.
Yeah, by 5th of
need to
every
take-
5th of every month we have to take the forms. You have to fill it.
MTP forms. Yes, ma'am.
TP forms, and we are at luxury in our medical college actually that we have a person to
Do it.
but we check all the MTP forms and indications whether signatures are done or not, everything is documented or not correctly. We make a file and keep, and we have appointed one person who will every month.
Same thing is PCPNDT, madam. Before 5th, we have to.
Valika software.
So the institution, everything will be streamlined. That is what
It is not wrong. It is accountability. We can't oppose it.
Accountability is
It should be it should become more and more better and better every day. Healthcare should improve.
Yeah, people should be,
Any question from the floor, please. You
yeah,
can.
people
it's
should be
open.
aware that such portal is there to enter. That is there.
Yes, sir. It's true, sir. So many things we do, we are not aware. Certainly.
No, that's it.
Problem with this is so
I'm
much of
closing it.
Harsha.
Yes.
See, as we are talking about, as Madam said, she is working in a medical college. They will have very good resources to resourceful person to work. When it comes to the periphery, it's very, very difficult to manage the even internet, problem is there. Electricity, in the internet, server problem. So much of things are there. I don't know how these policy makers don't think in terms of the end user.
Sir, AC room policies.
I don't want to comment on that. They have to come to the periphery, take the peripheral doctors into the policy making.
Yes, sir, it's very unfortunate. It's very
Sir, like
unfortunate.
time shortage,
Agree with
because
you.
we have to conclude this session. Actually, we were supposed to discuss another 3 cases, but I will not go into that. But this has given enough information for the delegates. And also the panel is so beautiful and such a knowledgeable panel. I thank the whole panel and also the patience listening of the delegates. And that concludes. And further, I think organizers have to take over. Thank you.
On behalf of the panelists, I thank Dr. Harsha for having beautifully moderated the session. Very interesting. And within a given time, we can finish at least 4 to 5 cases in depth. Thank you. On behalf of all the panelists.
Thank you so much, sir. Thank you, panelists. Thank you, Dr. Harsha. I request Dr. Arun Patil, sir, to kindly hand over the memento to the panelists and Dr. Harsha. Dr. Harsha had prepared a lot with the cases. So I'm sorry that there was.
Add one more point is I just prepared within 2 hours using AI. Maybe you may not agree with me. I downloaded 7 cases. After that, actually 11 cases. Then 7 cases. Then I put it into AI. AI gave me notes, then cut and made into slides. Nothing more much I have done. Hardly 2 hours. I have prepared 7 cases. So please use AI. You can't use it for filing. You can't use it for going to court, but you can use it for knowledge sakes.
I wish Dr. Shweta was benevolent enough to talk about my situation also. She caught hold of me on the corridor of the auditorium and said, "Your panelist, come inside."
Yes, I have to thank NC Mohan sir
I'm
also for
thankful.
being so kind and agreeing to be the panelist for this session. Thank you, sir.
Thank you so much, Dr. Shweta. Thank you.
Anand Reddy sir for being support and coming over here. Thank you, sir. I request Arun Patil sir to sir, kindly, I request Dr. Arun Patil sir to hand over the memento to Advocate NC Mohan sir. Dr. Shivkumar Kumar sir. The third memento sir is receiving the for all the roles he's played. Thank you, sir. As a speaker, as a chairperson, and as a panelist. To Dr. Asha Nirvi, madam. To Advocate Dore Raj, sir. To Dr. Yoganand Reddy, sir. Thank you, sir. Thank you for your valuable input, sir. I thank all the delegates for attending and for your patient hearing. And I thank all the team members and organizers for organizing this event. Thank you.